that, and we'll go from there.
Very good. Ms. Corral, would you remove the slide as soon as the interpreters are sworn in and make their introduction?
Yes.
All right, would you please both raise your right hands? Do you swear to well and truly translate from Spanish to English and English to Spanish all matters in the hearing? Thank you so much.
Thank you. And Rosa Maria, if you would like to make an introduction. Oh, yes, pop it back up, Marty.
Can we have the interpreters, please? Yeah, let's please have the interpreters identify themselves by their full name, and then we can have them proceed to the instructions.
Yes, we can hear you. Okay.
I can't hear anything. This is Richard Virtue. I am clicking on.
Mr. Hearing Officer, this is Chris Vigil from the Environment Department. Can you hear me?
Telling me I'm having problems.
Did you choose the English channel, Mr. Hearing Officer?
Excuse me, Mr. Hearing Officer, this is
I'm sorry, I just heard the tail end of that.
this is Phoebe. Mr. Hearing Officer, Mr. Virtue, maybe if you turn off your camera and just go to audio, that might help.
Chairman Sweeney, just a quick question here. So it doesn't look like, excuse me, it doesn't look like we have a quorum. Does that matter? Anybody know?
Thank you for that, Member Cates. I don't believe it matters, but I'll lean to Ms. Soloria for that.
Thank you, Chair Sweeney. Can everyone hear me?
Yes.
Great.
Yes, we can hear you.
Yes. Members of the board, since you opted to have the hearing conducted by a hearing officer, that a quorum is not required for the hearing to proceed. And of course, you'll have a quorum when you deliberate the outcome of the case.
Okay, thank you.
Do we, Ms. Jones, do we have our hearing officer, Mr. Virtue? Is he still having some connectivity issues?
It looks like he has gone off. I am going to give him a telephone call. Please
Okay.
stand by.
Thank you. And just a quick good morning to everybody. Thank you for attending our hearing this morning. We're just, for those that just logged on, we're having some a little bit of technical issues. So please just be patient and bear with us as we navigate our technical issues this morning. But we're all here. Hope everyone's doing well today. Good.
Can you hear me? It's telling me I'm connected again. Can you hear me?
Yes, we can hear you.
Yes, Mr. Virtue, we can hear
Okay,
you.
thank you. Let's have the go back to the point where I think I lost communication, and that is to have the Spanish interpreters identify themselves by their full name and then give an explanation of how the interpretation globe may be used.
Thank you, Mr. Hearing Officer.
And the other, Rosa? Was that Rosa Maria? Okay. Thank you very much. Now that you've identified yourselves, could one or both of you please provide an explanation of how the interpretation feature will work?
Good morning again, Mr. Virtue. I don't know if it's mine, but I can't hear any sound other than you.
And I'm not hearing any sound either.
Okay.
Yes.
I can't. Yeah, I can. Yeah.
Mr. Hearing Officer, I think you're still cutting out. I don't know, Ms. Jones or other members of the board, can you hear our hearing officer, Mr. Virtue?
Madam Chair, I don't think he's speaking. Rosa Maria was giving the interpretation explanation.
Okay.
Yeah, this is the hearing officer. I haven't been speaking. I've been listening to the interpreters.
Okay. I'm not hearing the interpreters. Are other members of the board hearing the interpreters?
Yeah, I'm not either.
Have you all selected?
Yes, Ms. Jones, what were you saying?
Hang on a second, Rosa Maria. Members of the board who are unable to hear the interpreter, she's reading the screen that you see. And if you would look to the bottom left of your computer screen, there is a globe. And if you would click that and click the drop-down menu and select English, the English channel, you will be able to hear the interpreter. There's a little slidey bar through there, which will increase or decrease the volume. But you should be able to hear Rosa Maria if you get in the globe, select the English channel, And now I will let her continue. Ms. Rosa Maria?
Okay, I believe those are the instructions. Are we going to get them in Spanish also? Please.
She is currently speaking them in Spanish. If you'd like to hear them in Spanish, simply go to that globe again and select the Spanish channel, and then you'll be able to hear it in Spanish. But I believe she'll come back and tell us when she's finished with that interpretation.
Mr. Hearing Officer, this is Chris Vigil, New Mexico Environment Department. It's my opinion that we should give the Spanish instructions in the English channel as well, because there may be Spanish speakers who are in the English channel, and they may not be able to understand the instructions if it's not in the language that they prefer. So if we could give Spanish language instructions in the English channel, I think that would be helpful to make sure that everyone gets to the place that's most helpful for them.
Mr. Hearing Officer, I believe you can continue now.
This is the hearing examiner. I didn't hear the Spanish version. Are we completed with that? And are we ready to proceed? Or do we have more instructions to give?
You're ready to proceed, Mr. Hearing Officer.
Ms. Jones, I think we're seeing indications that his internet is not sufficient.
Yes, it appears that way. Mr. Hearing Officer, can you hear us if you leave your camera off?
Ms. Jones, I was wondering if our hearing officer could call in via phone. I think you might have to opt to that.
Yes, thank you. And ladies and gentlemen, I apologize for this delay. I'm going to mute out and call the hearing officer and suggest that. Thank you, Chair Sweeney.
Richard.
Yes, Mr. Hearing Officer, Ms. Jones is going to be calling you. Member Kate, can you hear us okay?
Yes.
Okay. And
Yeah.
member our Vice Chair Davis, can you hear us okay?
Yes, I hear pretty well. Sorry,
Okay.
late joining.
No worries. We've been having technical issues, so we have not really started.
Okay.
Yeah, so just wanted to double check because member Garcia was having she couldn't hear either, so I don't know. We'll figure it out here. I know Ms. Jones is talking or contacting hearing officer Virtue. So you didn't miss much, Vice Chair.
You know, I don't know if it's this forum or this group or just having used WebEx periodically over the last 2 years for different things. It's pretty glitchy, and there was a time when we used Zoom and we didn't have any issues. So I just wonder if maybe we ought to move the whole kit and caboodle over there. But
Yeah, let's I know we have some notification
oh,
requirements
that's true. Yeah. Okay.
and
Yeah. Okay.
yeah. But let's see if Ms. Jones and our hearing officer can work out a way where he can at least call in. I know it's going to be a little
Right.
more challenging for him, but
Yeah.
thank you
Okay.
all for your patience and and attending this morning. If you will, just a little more patience here, and we'll see if we can work out the glitches.
Chair Sweeney? Would
Member
you say, oh, okay, got it. Okay. A minute ago, I couldn't hear anything, but I got you now. Thank you.
Yes, no worries. Thank you for is the hearing better now?
Yes, I can hear now. Thank you very much. Perfect.
Okay. Okay, now we just got to get our hearing officer.
And I think he just dialed in successfully, Madam Chair.
Thank you, Ms. Jones, for all your work. Mr. Hearing Officer, Mr. Virtue, are you there?
Star 6.
I am.
To unmute yourself. To
Uh,
unmute. Star 6.
I should be unmuted and on by phone also. Can you all hear me?
Yes, Mr. Virtue, we can hear you.
Okay. Okay. Just did everybody who's on the call hear the instructions for translation?
Yes, sir.
Let's put it this way. Did anybody not hear the instructions for translation?
Excuse me, this is Vice Chair Davis. There's a echo. And Mr. Virtue, you might want to go ahead and mute your speakers on your laptop. And that should clear up the echo.
Can folks hear me? Problem is if I mute myself on the laptop, nobody hears me or nobody was responding. So I'm gonna mute on my laptop connection and just talk into my phone, see if you can hear me.
Okay, we'll stand by, Mr. Virtue.
Oh, I'm sorry. I think you misunderstood me. Turn your speakers off. The volume on your speakers on your laptop, turn it all the way down, and that should stop the feedback.
The speakers on my laptop are down to the minimum. And I'm still echoing, I think. Am I echoing now?
Just a little bit, but it wasn't as loud as. Oh, yep, never mind. There's an echo.
So I'm not.
Okay, can folks hear me now?
We can hear
Yes.
you. We can hear you.
And are you still getting an echo?
Yes.
Okay.
I'm sorry, but I think he has to join with only the audio for his phone.
Thank you, Ms. Gibson. Yes, Mr. Hearing Officer, did you hear that suggestion?
Yes, I'm still hearing the echoes.
Mr. Hearing Officer, this is Maslin Locke with the New Mexico Environmental Law Center. Is the volume on your computer also turned up? Because I think it's coming through your computer and back into your phone.
All right, let me go check that. It should have been, but I will go look. Yeah. So that is this better? No.
No.
So if you turn the volume on your computer off, you'll be able to hear all of us through the phone as well.
Let me try. Okay, the volume is off. It's better. Okay. I think we're all right. Can you all hear me without echo? Is anybody getting an echo?
Yes, sir. There's still an echo. Oh, yeah.
Okay, well, I'm getting echoes from some of you, but we'll just try and deal with it.
Pam, is everyone muted?
Yeah, I guess. Yeah, please mute yourself
Yes,
when you're not
everyone's muted.
speaking.
Can we try one more thing? Because the echo is still pretty bad. There's a button. It's on near the hang up on your screen, and it's got 3 little dots. And if you select that, there's an option there to switch audio. And it allows you to call in there, and that might help. Is that the option that you used when you called in, Mr. Virtue?
Vice Chair, can you still hear me?
Yes, I can hear you.
Okay, so there's no echo, right? Yeah, let's see if Mr. Virtue is able to follow up, and if your suggestion works, that will be great.
Mr. Virtue, are you able to hear us?
Can you hear me?
Yes, we hear you now.
Okay, but we still got the echo. The last thing I can try here, by the way, we'll go into recess. You can stay on the call, but we'll be in recess, and I'm gonna try and get this fixed. And then I'll call us back to order once I get it fixed.
I don't hear much of an echo now. Oh, never mind.
Yeah, I'm hearing an echo.
When, sir, one suggestion, so are you on your phone and your computer simultaneously?
Yes, I am.
Now, I think that's what the deal is. Can you just
So
talk to us
I
over your
can,
computer?
pardon me?
Can you just talk to us over your computer?
Well, that's the problem. There was an echo, so I called in. There's an
No.
echo when I call in too. The problem, as I understand it, is my connection on my computer is weak, so I called in.
No. Hmm.
So that's making the echo.
Mr. Hearing Officer, what would you suggest? How many minutes or how long do you think? Maybe 10, 15 minutes recess, or what's your thoughts?
One other idea or thing, I wonder if, can you turn off the microphone on your computer? And maybe that'll clean it up.
Can you hear us, Mr. Virtue? I think all of the suggestions have been to turn off your computer microphone and speakers.
My computer microphone, I'm on both my computer and my laptop. So I'm going to click off the computer, so I'm no longer connected on my computer. And I'm gonna unclick from the phone and go back to the original connection and see if it works. So let's stay on for a minute and see if it works. If it doesn't, we'll go into recess until I can get this fixed. Okay, thank you. Okay, can people hear me? This is the hearing officer. Can you hear me?
Yes, we can hear you.
I'm seeing nods.
Yes, Mr. Virtue, we can hear
Seeing
you.
some people aren't nodding. Would all those people please turn your videos on and give me a nod if you can hear me? Okay, everybody that has their video on is nodding. Okay, so let's just proceed and see how we go. And if we need to go do more work, we'll just recess and get the work done to get the connection correct. So it is my understanding, based upon what I have heard, that the Spanish interpreters have been introduced, they've been sworn, and they have given the interpretation instructions. Is that correct? Can the hearing administrator
Yes, sir.
confirm that that's correct, and the court reporter?
Yes, that has been accomplished.
Now I'm not hearing anything. Can the
Again,
hearing
Mr. Virtue, have you
administrator
chosen
speak up?
the English channel on your globe?
Now I'm not hearing the hearing administrator.
Can you hear
Uh,
me, Mr. Virtue?
Can the co-host speak up? Matt,
I think his speakers are still down.
Oh, that's a good point. Mr. Virtue. Pardon me, ladies and gentlemen. Let me call him on his phone and tell him to turn up his speakers. Hold on.
Thank you.
I am. Can folks hear me?
I just want to say a quick thank you to everybody for being patient and navigating our technical issues this morning. Thank you all.
Okay. He says he's on the English channel and he's going to turn his speakers up. So I think we're on the way.
Thank you, Miss Jones, for all your help this morning.
Not a problem. The technical world is it sometimes gets away from all of us.
Can you hear me?
Yes, sir, we can.
Okay, so I am going to proceed now with the hearing itself, now that we've taken care of those technical matters, hopefully. This is a public hearing in the matter of the petition for hearing on air quality permit number 8585, Earth Care, New Mexico by Miguel Acosta Munoz and Linda Marianello as an individual petitioners versus the Environmental Improvement Department and Associated Asphalt and Materials LLC as applicant. My name is Richard Virtue. I am the hearing officer for this proceeding. If you have problems with respect to the Spanish interpretation, if anyone is having trouble following the interpretation, you can email the hearing administrator at state.nm.us. That's pamela.jones@state.nm.us. Or you can call her at 505-660-4305. The public notice of this hearing was published in the Albuquerque Journal on January 15th, 2022, and the Santa Fe, New Mexican on January 17th, 2022, in English and in Spanish. I am conducting this hearing by appointment of the Environmental Improvement Board, and they will be making the decision in this case. I will simply make a recommendation to them based upon the hearing. And I see that we have several board members on at this point. I can see Chair Phoebe Sweeney, Vice Chair Amanda Trujillo Davis. I can see Carl Cates, and I believe Mr. Barry Bitzer is also on. I believe those are the only members of the board that are on. If there's any other board member on, please identify yourself. Oh, we have Karen Garcia. Karen Garcia is also on. Are there any other board members on that I didn't see? Okay. With that, let's turn to entries of appearance of counsel. Who appears for the petitioner?
Good morning, Mr. Hearing Officer. My name is Maslin Locke. I'm a staff attorney at the New Mexico Environmental Law Center on behalf of petitioners Earth Care New Mexico and Linda Marianiello, and I'm with my co-counsel Eric Jantz. I'll let him introduce himself.
Okay. And for the Environment Department?
Good morning, Mr. Hearing Officer, Chair, members of the board. Chris Vigil, Assistant General Counsel for the New Mexico Environment Department.
Okay, are there any other appearances by counsel?
So, Mr. Hearing Officer, this is Eric Jantz, Senior Staff Attorney at the New Mexico Environmental Law Center for petitioners.
Okay, thank you, Mr. Jantz. Hearing no other appearances, we will proceed to a discussion of procedural matters. I entered a procedural order on Monday, which sets forth the general procedures in the case. I'm not going to go through it, but I am going to go through certain portions of it and supplement it to some extent at this point. The first item I wanted to cover is the admission of statements of intent to submit technical testimony. The parties have, by stipulation, agreed to the admission of certain of the exhibits, and I have ruled on certain other exhibits. And I just like to state for the record here what has been done in that regard. The party NMED, excuse me, that the petitioners NMED EIB exhibits 1 through, pardon me, this is the NMED exhibits, excuse me. NMED EIB exhibits 1 through 18 will be admitted, and that community, that is petitioners exhibits 1 through 9 will be admitted. Certain portions of community exhibits 10 will be admitted as specified in my order ruling on that matter. And I have also indicated I will allow a community exhibit exhibit EIB 11, which is Mr. Schneider's resume, be admitted, which wasn't expressly addressed in the various discussions that have gone on before that. I have ruled that certain exhibits of the petitioners will not be admitted, and those are listed in the procedural order. In addition, we've had several additional exhibits that have been identified yesterday and this morning. I'm going to reserve ruling on those at this point. I would ask, we'll rule before you propose that they be entered, counsel. So be prepared to identify those and identify them, and please explain the nature of the exhibit and why you are moving to admit it. I'm assuming they are all rebuttal exhibits at this point. we will have as specified in the procedural order, we will have a public comment taken at 1 p.m. and 5 p.m. each day. That will be subject to change depending on availability of the persons who are wishing to testify. Persons who would like to testify, members of the public who would like to submit non-technical testimony should send a chat message to the host of the meeting, and the hearing administrator, who is also the host, will keep a list of people who want to submit public testimony, and we will call on them when we get to those time periods. You can also request the opportunity to submit public testimony by emailing the hearing administrator at the same email address I gave previously. That is pamela.jones@state.nm.us. That's pamela.jones@state.nm.us. And when you either email or send a chat message, please indicate which session you would prefer to submit your testimony at. Excuse me. I intend to ask the public witnesses to limit their testimony to approximately 5 minutes. If there is a special reason why more time is needed and you give an explanation of that, that appears to be satisfactory, we will let you exceed the 5 minutes. But the general rule is to please limit yourself to 5 minutes in terms of your presentation. The hearing is being recorded at least today by a court reporter. We'll see what arrangements will be made by the subsequent days. And we will establish a deadline for receipt of the transcript and for post-hearing submittals at the end of the hearing. I intend to take one break in the morning and one break in the afternoon each day of the hearing for around 10 to 15 minutes. We'll make that determination when the break is taken. I will allow 1 hour for lunch around noon, and the hearing may continue in the evening or evenings after the public comment at 5 p.m. is given, in order to continue to make progress in regard to the hearing. And that will depend upon how much progress, in fact, we are making. Are there any questions about those preliminary matters and procedural matters?
Mr. Hearing Officer, this is Chris Beal, New Mexico Environment Department. I had a question. I was maybe a little unclear about how we're going to do the additional exhibits from the department and the petitioners. Did you want us to authenticate and offer documents as they come up, or are we going to do them as a group, as a preliminary matter? I was not certain. In either case, the department's prepared, and I can do all the exhibits now if that would save time.
Okay, Ms. Locke, are you prepared on your exhibits?
Mr. Hearing Officer, we are, and I would just suggest that maybe if we can just stipulate to the admission of all the additional exhibits. We've had the chance to look through the environment departments, and I think, I can't speak for Mr. B. Hill, but if he's looked through ours, that might be the easiest.
Okay, and yeah, let's do that now then. If you've both reviewed the exhibits and are prepared to stipulate, can I get an acknowledgement of the stipulation as to the admission of those exhibits?
The department stipulates to the additional exhibits submitted by the petitioners.
Okay, and Ms. Locke, can you identify those?
Communities exhibits, Mr. Hearing Officer?
Correct. I don't believe they were numbered. They may have been. When they came in on my email, they were not numbered. So you could give us a number and a general title.
Certainly. If they're not numbered, I'll send them around again. But the first one is an EPA air quality analysis checklist. It's labeled Community EIB Exhibit 20. The second one is an EPA release about re-examining health standards for the rules that the previous administration have left unchanged. It's Community EIB Exhibit 21. And then the third one is an email to NMED employee Kathy Prim. It's labeled Community EIB Exhibit 23, and it has to do with Associated Asphalt's permit violations.
Okay, those are admitted. Those exhibits are admitted by stipulation. Mr. Vigil, you want to identify your exhibits and we'll formally admit them?
Yes, thank you. We have NMED EIB Exhibit 20, which is the statement of basis for LM concrete pumping. There is NMED EIB Exhibit 21, which is 40 CFR Section 50.1. NMED Exhibit 22, which is an EPA letter from December 19, 1980. EIB Exhibit 23, which is an EPA letter of October 17, 1989. NMED Exhibit 24, I'm sorry, NMED EIB Exhibit 24, which is December 2nd, 2019, EPA letter of December 2nd, 2019. NMED EIB Exhibit number 25, which is a new source review workshop manual. And NMED EIB Exhibit 26, which is a comparison, an EPA comparison of regulatory design concentrations. And I'd like to take just a second for the benefit of the board and the hearing officer that for at least for the department, we will distinguish between NMED Exhibit 1 and NMED EIB Exhibit 1. For example, the NMED Exhibit 1 would be referring to the administrative proceeding prior to this, and the EIB exhibits will be referring to exhibits that were introduced in this proceeding. I just wanted to make that distinction so everyone is able to find the documents that they need as we go through this. Thank you.
Okay, thank you for that that clarification. Mr. Vigil, does NMED have an exhibit number 19? I didn't see one. I saw that you submitted 1 through 18 before, and that was stipulated to, and then you started with 20. I didn't see a 19. Did I miss something, or you have to present?
There is an exhibit 19 that was submitted with the statement of intent to submit technical testimony, and that is the petition. I'm sorry, that is NMED's answer to the petition. And the reason why that's an exhibit is because it has documents referring to the use of AP 42 throughout the United States. So the petition itself as a document is not going to be used. It's the attachments, which are a number of AP 42 related documents from around the Western United States.
Okay, we'll include exhibit NMED.
Mr. Hearing Officer, we actually intentionally didn't stipulate to that based on the fact that it's our argument that those attachments that include different permits from states that aren't New Mexico are irrelevant to this proceeding.
Mr. Hearing Officer, of the 2 surviving claims in this, One of their claims is that AP 42 is inappropriate. And their witness, in his testimony, Dr. Sahu calls New Mexico's use of AP 42, and this is a direct quote, he calls it regulatory malpractice. So the petitioners are attempting to construe New Mexico's use of AP 42 as some sort of, out of bounds use. And what our exhibits show is that not only is it regular, but the vast majority of the states in the Western United States use AP 42. And so this is a cross-examination document. And they're, I understand that they don't want the doctor to be cross-examined on his statements, but he made the claim, they brought the claim on AP 42, and we have to be able to respond to it.
So Mr. Hearing Officer, this is Eric Jantz. I think that Mr. Vigil's characterization of Dr. Sahu's arguments are incorrect. I think that that Dr. Sahu will testify not that AP 42 is inappropriate in all circumstances, but under the circumstances in this case, it certainly is. So it's the way in which the Environment Department used AP 42 emissions factors rather than the fact that they used AP 42 emissions factors that is the argument. And so these particular permits from other states have absolutely no bearing on how an MED used AP 42 in this case.
Mr. Hearing Officer, it has direct bearing. And what it will do is it will show that Dr. Sahu doesn't know what he's talking about. And that's what we intend to do.
I'm going to allow Exhibit 19 to be introduced on the grounds that the use of AP 42 in other jurisdictions is relevant to this proceeding, and the witness can explain why he thinks it was AP 42 was inappropriately used in this case on cross-examination. So I'm going to admit Exhibit 19, and I'm also going to admit the other exhibits that were just identified. So they are admitted. And at this point, I think all of the exhibits that have been offered have been admitted. Or not necessarily admitted, but admitted or disposed of.
Mr. Hearing Officer, can I ask just sort of a clarifying question? I think to both you and maybe the department. The regulations ask that the department or require that the department formally move into evidence the administrative record pursuant to a section of the code that doesn't actually appear in the code anymore. So I would just ask for clarification about whether or not the hearing record itself, which includes the administrative record, needs to be moved formally into evidence. It sounds like both petitioners and NMED are going to be referring to exhibits from the proceeding below. So maybe if that just needs to be clarified, we can clarify that now.
Thank you. It does. It does need to be moved into. And in response to that, the department moves that the administrative record from the proceeding below, from the matter on which this appeal is based, I don't remember the number, I'm sorry, be entered into evidence, and that the record proper, maybe that takes care of everything, by the way, in the proceeding below, be entered into evidence.
Okay, I believe the administrative record includes the hearing record and the record proper. So that picks up everything below. And I believe the administrative record has been filed already in this proceeding. So we're just making sure it gets admitted into the record of the testimony. Is that correct?
That's correct.
Okay, thank you. So the administrative record will be admitted into evidence.
And just for clarification, Mr. Hearing Officer, that's everything, the transcripts from below, everything filed with the hearing clerk from below, and the original administrative record the department relied on.
That's correct.
Thank you. And then, Mr. Hearing Officer, I actually have one more procedural point, just based on the sort of schedule you lay out. We do have one expert witness that's going to be unavailable tomorrow morning. So sort of depending on where we go, we can figure out where to put him, whether or not it's for cross or rebuttal or however that looks. But I just wanted to flag that for everyone.
And which witness is that, Ms. Locke?
It's Dr. Sahu.
Dr. Sanu, okay. Okay, we'll address that when we get to that point. And we need to do that piece of scheduling. And if we do not get to him today, I mean, can you present him today and we can,
Yes,
present
certainly.
him first? I think he was listed first. And
Yeah,
if need,
we'll
and
be
if,
our first.
yeah, let's do that. And then we'll address his unavailability in terms of cross examination and rebuttal after he's done his direct, and we'll see how the timing is going.
That's good. Thank you, Mr. Hearing Officer.
Mhm. Okay, with that, Ms. Locke, please present your first witness.
Oh, and Mr. Hearing Officer, I actually have a brief opening if that's.
I'm sorry, I apologize. Yeah, each council may give an opening statement and then we'll turn to presentation of evidence. So Ms. Locke, please proceed.
Thank you. Good morning, Chair Sweeney, members of the board. As you've heard, my name is Maslin Locke. I'm a staff attorney with the New Mexico Environmental Law Center. I'm here with my co-counsel, Eric Jantz, on behalf of Community Earth Care New Mexico by Miguel Acosta, which is an organization that serves thousands of residents on Santa Fe's south side, nearest both the current and proposed associated asphalt operation, as well as Linda Marianiello, who is another south side resident of Santa Fe. And we're here today challenging the New Mexico Environment Department's decision to issue a construction permit for the consolidation and operation of currently existing associated asphalt materials plants. As you all know, NMED is the state agency charged with protecting human health and the environment. The way they do this in air permitting is by ensuring that permitted operations do not violate ambient air quality standards, which are set by both the US EPA and the state of New Mexico at levels that are intended to be protective of humans and the environment. This permitting process, however, has demonstrated that NMED seems to care more about industry success than the impacts that industry success has on humans' quality of life. NMED today stands by their assertion that this consolidation reduces associated asphalt emissions to just barely below the national ambient air quality standards. The air dispersion modeling relied on by the department, as the testimony today will show, at best indicates that we don't know whether associated asphalt will violate these standards. At worst, it indicates that the operation almost certainly will, resulting in detrimental impacts to the nearby community. The community understands that consolidating the sites may well move the operation a few thousand feet away from surrounding neighborhoods, but this does not address the fact that these residents in Santa Fe bear a burden of air pollution that does not plague the more affluent, wider areas of Santa Fe, New Mexico. Ultimately, the community is here today because NMED's permitting of industrial operations on Santa Fe's south side is disproportionately negatively impacting Santa Fe's communities of color. The testimony today will show that NMED is failing Santa Fe's south side when it comes to environmental justice, which the department itself defines as the fair treatment and meaningful opportunity of involvement for all New Mexicans regarding the development and enforcement of environmental laws and regulations. This definition comes from both Title VI of the 1964 Civil Rights Act and NMED's implementing guidance for that act. The community living closest to this operation, and in fact, most of Santa Fe's industrial operations, and the community you will hear from today, is one of the most densely populated, primarily Hispanic communities in the city, made up primarily of young, low-income families. It is this community that bears the brunt of NMED's reckless permitting decisions, and it is this community that asks you, the members of the EIB, as the body charged with reviewing NMED's decisions that cannot exist outside of the context of equal protection of the law, to reverse NMED's decision to issue permit number 8585 to Associated Asphalt and Materials. With that, I will present our first witness, who is actually our non-technical witness, Mr. Miguel Acosta.
Okay, if you'll have him identify himself, the court reporter will swear him in.
I think you're on here, Miguel. see him.
Get my video on. Am I on? Hello?
Yep.
Hello,
Good
Mr.
morning, Miguel.
Acosta. Would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you.
All right, Miguel, can you tell the hearing officer, members of the board, and everybody here today just a little bit about yourself?
Yes, thank you. Madam Chair, Mr. Hearing Officer, members of the board, my name is Miguel Acosta, and I live on the south side of Santa Fe. I'm currently co-director, part of the leadership team of Earth Care New Mexico, and I've been involved with healthy communities movements for the majority of my life.
Thanks, Mr. Acosta. And how long have you been working with Earth Care?
Formally, about 4.5 years now. Informally, I've been a partner. I was with other organizations previously. I've been working with them probably about 15 years.
And as co-director or in your work with Earth Care, what are some of your job responsibilities? What are you doing with them?
I work we have a couple of different projects or programs within Earth Care. I work on the side that we call Poder Familiar. So I work directly with families and communities and young people primarily on the south side of Santa Fe, building leadership, capacity, and community engagement around issues that impact their health, their wellness, their futures, education, housing, etc. The last year and a half last couple of years, we've been focusing a lot of our work on our community response to COVID, which took the form of Santa Fe Mutual Aid. We've probably put out about $600,000 that we collected from neighbors and shared with neighbors. It was neighbor to neighbor support through Santa Fe Mutual Aid. We do a lot of work around envisioning and organizing around healthy futures and healthy communities. That's how this came to our interest.
And where do all of these programs typically serve in Santa Fe?
Primarily, the ones I work with primarily on the south side. We have a youth program, a youth-led program that does work on climate justice and policy work, and they work both locally, regionally, and statewide. But most of our work, most of my work in our office, etc., is based in the impacted area.
Mr. Hearing Officer, this is Chris Vigil. I'd like an opportunity to voir dire this witness.
Okay, you may.
Good morning, Mr. Acosta.
Good morning.
So, can you tell us about any experience that you have with air quality permits?
That I have?
Yes.
I don't work for the permitting agency, so I don't really have any experience granting permits.
Okay, thank you.
I do have experience with the impact of those granted permits. The folks that complain about the pollution and the impact.
Answer my question, sir. Thank you. Do you have any engineering experience?
Objection, Mr. Hearing Officer, Mr. Acosta has been presented as a non-technical witness. He's not offering technical testimony.
If he veers into technical testimony, I have to have a grounds to object. So I'm laying the grounds to protect the ability of the New Mexico Environment Department to defend itself on an appeal. I have to have some grounds to do this. If Mr. Acosta veers into any kind of medical or technical speculations, then I have to have some grounds to object. And so we need to authenticate him. There was no resume. We know nothing about where he comes from, what his education is, and he, we objected to the inclusion of his testimony. I respect that it was included, but we know the department knows almost nothing about Mr. Acosta.
I would suggest that you can object if or when he presents technical testimony. He's not being offered for that purpose. This testimony has already been ruled admissible as non-technical testimony.
Mr. Hearing Officer, I'm not here to argue with counsel. I'm addressing you, so I don't want to have an argument. This is a legal proceeding.
I'm going to allow Mr. Acosta to proceed with his testimony. If he starts discussing technical matters for which he has not laid a foundation, you can certainly object, Mr. Vigil.
Thank you.
Thank you, Mr. Hearing Officer. All right, Mr. Acosta, can you tell me a little more about EarthCare? Does EarthCare have membership?
Yes, currently we've got about 4,000 members and supporters. The great majority of them here on the side of Santa Fe.
All right, and one more question, Mr. Acosta. Where do you live?
I live at 6128 Monteverde Place, here on the south side, near Cesar Chavez Elementary School.
And you're personally familiar with the Associated Asphalt operation?
I'm not familiar with the on-site operations. I'm familiar with their locations. I'm familiar in a non-engineering way. I'm familiar with the impacts of the visual evidence of impacts and also the other physical impacts from our members who complain about the smell, the soot on their cars, noise, the trucks, all of those. And as I said, in a non-engineering way, we're familiar with what we see and what we hear and what we feel and what we breathe.
Thank you, Mr. Acosta. I have nothing further, Mr. Hearing Officer.
Okay, Mr. Vigil.
I have no questions. Thank you.
Okay, is there anyone else on the call or attending the meeting, the hearing, who has questions for Mr. Acosta? Okay, hearing none, Mr. Acosta is excused.
Thank you, sir.
Ms. Locke, call your next witness.
I'm sorry, were those supposed to be questions, the board's opportunity to ask those questions?
Oh, I'm sorry. Yes. My apology. I thought I should have been clearer. I thought I was allowing the board members to ask questions of him when I asked the question. So we will recall Mr. Acosta and allow questions from board members.
I have a couple of questions. Thank you, Mr. Acosta, for taking the time to talk with us. I know the type of work you're doing with your community is really important. I'm curious, what does somebody have to do to become a member of EarthCare, and are there membership requirements, and could you explain what those might be?
The membership requirements is just that they participate or show interest in being a part of our communications, that they participate in any activities or projects of ours, or that they ask to be a part of our communication system. So at that point, we consider them members of the organization. For Santa Fe Mutual Aid, there was a specific action that people would take, and that's that they would submit a very short half-page form saying that they wanted to be a part of the mutual aid network, which then it put them in a position to either receive support or give support in a neighbor-to-neighbor solidarity fashion. Well, we also have sort of our area of interest, right? So folks, so since this area for very many historic and current contextual issues is an area of concern for us, we extend the benefits of membership, and in other words, extend our interest in acting on behalf of the community, to the entire South Side, and anybody that's impacted by structural issues where income, race, ethnicity, or gender create barriers for their equal protection under the law.
Do your members, how many of your members live in this particular area? And do you have like a voting structure or anything like that for issues that such as this?
We don't have a voting structure in the traditional sense. We operate on a collective, participatory, direct democracy kind of model. So people participate in conversations on a regular basis and determine, or we're member led. So members themselves are the ones that determine the directions and the positions that we take on projects, on issues like this, etc. The majority of those 4,000 people that we currently have on our membership or communications list that live in this area.
So I apologize. I'm not sure I understood that completely. How do you determine, how does your membership determine what issues to continue with and how they want to proceed with those issues?
So issues oftentimes that we act on or that we take on as campaigns are presented to us through the members themselves at meetings that we have, at gatherings that we have. Like in this case, one of our members said, "Hey, do you know that this is happening?" And we investigated, shared information. This goes back now, what, 3 years or more. We presented information to our board, who are all members and former students and youth in our programs. Shared it at our membership meetings, and people said, "Yes, this is something that we want to move on." So it's more. It's not like a party vote. It's not like elections or that kind of voting, right? It's more the will of the people that are coming together and discussing a particular issue that determines the direction that we'll go.
Thank you. And just one last question. Do members pay dues or anything that helps support the administrative portion of your advocacy group?
No, we don't ask for membership dues. We operate on the basis of collective action and solidarity. So people participate in our work, and those are the dues that we pay for. Those are the dues that all of us pay for creating a more socially just world.
That's all the questions I have. Thank you, Mr. Acosta.
Thank you.
Madam Chair, I have a question, if that's all right, to follow on to Member Davis.
Please proceed.
Mr. Acosta, I was wondering, you got 4,000 members. How many people actually typically show up to a meeting?
The membership meetings vary, and the meetings themselves are not the only way that people participate, as I was saying. The majority of our people work 2, sometimes 3 jobs. The majority of our folks have been highly impacted by COVID and the economic recession from that. So we don't measure, like I said, we don't measure participation by how many people can attend a meeting. Although the variety, the several projects that we have going, they individually have meetings. So the majority of folks in that 4,000 will participate via responding to correspondence and to calls for action. They will respond by being a part of a membership meeting. They participate by donating to Santa Fe Mutual Aid. They participate by showing up at a legislative hearing. They participate by showing up at city council meetings. They participate by collaborating with another organization on a cleanup day or what have you. That's the kind, we don't demand or expect people to show up to a meeting to demonstrate membership. We expect them to participate in the betterment of their community.
So you don't have a quorum requirement, then a minimum number of folks that need to show up to act.
No.
That's all I have. That's all I have, Mr. Hearing Officer. Thank you, sir.
Okay, thank you. Are any other board members have questions?
Yes, sir. I got a couple here, just to
Okay.
follow on with some of the questions that my fellow members were asking there. So, sir, are you guys a 501c3? You're a nonprofit, right?
Yes, we are. Yes, we are. Thank you. Yes, we are.
Can you tell us a little about your budget, your funding? Do you have any notion of what your annual budget is?
Our annual budget is just under $500,000, and it's grown. It's probably doubled in the last couple of years, primarily because of the funds that we had been repurposing for in support of families suffering from COVID and the economic impacts of that.
Right, right. And so I'm guessing that you have a board, correct?
We have a board, sir. Yes.
So what kind of folks are on the board?
The majority of folks on the board are all of them are members of this community. Many of them are alumni of our youth programs, or they've come through one of our parent leadership programs. We don't construct or support a board like other nonprofits may do, making sure that there's a lawyer, making sure that there's a financial expert, etc. We want our board to be reflective of the community that we work with. So there's young people, there's not so young people, but all of them have a commitment to the work that we do because they came up to do that work.
And you have staff, right? You pay salaries. Is that correct?
Yes, sir.
Is most of your budget? Does most of your budget go to salaries? I'm guessing it
Most
does.
of our budget has gone to supporting members of our community.
Oh, I see. In terms of grants and financial support, is that what you mean?
Yes, yes. In the last few years, the majority of our budget has gone for supporting our solidarity efforts with people suffering the impacts of COVID and the economic depression.
Where do you get your money? I'm guessing on this one that you received some foundational grants and such, right?
We receive foundation grants, individual donations, some fee for service when we're partnering with, like, say, the city or the school district on particular projects.
Is it possible to say who your biggest funder is?
I don't do that side of the work, so I couldn't really say who right now the biggest funders are our community that's been donating individually to the Santa Fe Mutual Aid efforts. But aside from that, in terms of foundation,
okay.
So the biggest funders
are individual.
Right.
So then what you're saying is your biggest funders are collectively are individual donors. Is that right?
Right.
So you're not a tool of the Rockefeller Foundation or something, right?
We're a tool of our community, right?
Okay, sir. Thank you very much. Appreciate it.
Thank you.
Are there any other questions from board members? Okay, hearing none, I will excuse Mr. Acosta again, and we will proceed with the next witness on behalf of petitioners.
Mr. Hearing Officer, Madam Chair, members of the board, petitioners would like to call next Dr. Ron Sahu.
Okay, if you'll have Mr. Sahi identify himself, and we'll have him sworn in. Sahu, I'm sorry.
Sir, I think you might be on mute.
Indeed, I am. Thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
So, good morning, Dr. Sahu.
Good morning.
Would you introduce yourself to the board and the members of the public who are here today?
Sure. My name is Ranajit Sahu. I'm from India, so I go by Ron. I have my background and training is in engineering. I have a bachelor's of technology with honors from the Indian Institute of Technology many years ago. I have a master's followed by a PhD in mechanical, chemical, and environmental disciplines. It was interdisciplinary from the California Institute of Technology, Caltech, in Pasadena, also many years ago. I have worked as a design and research engineer in the early part of my career. For about 10 years, I worked for a very large multinational engineering company based in California, where I'm based. First starting in their environmental consulting group and ultimately heading that group before I left the company about 20 years ago. I have been on my own, providing a range of environmental and engineering consulting services to a diverse group of clients, broadly speaking, which includes what I call my industrial or private sector clients. It includes a number of states and has included a number of states in the past as matters have required, including New Mexico, I might add, sometime in the past. I have throughout also provided both consulting and expert testifying work to the EPA, including its enforcement of certain matters through the Department of Justice. Actively involved in about 5 such matters right now as we speak. I also work with community groups. I work with both national and local non-governmental entities throughout this country and few outside the country. So that's kind of a broad overall overview of my background. We'll be happy to
Excellent.
discuss any details.
Thank you, Dr. Sahu. Can you talk a little bit in a little more detail about the topics on which you consult with government, private industry, and community groups?
Focusing on the air quality side of things, I do other work besides air, and that's not relevant to this particular matter. Focusing on air quality matters, I have done permitting work for a long time, starting in roughly 1990, about 31 years now. I have done that for my industrial clients, minor source permitting, major source permitting, development of emission inventories, running a stack testing group, doing work for health risk assessments, dispersion modeling, for work with the government as expert. I have done work for about 20 years, beginning 1999 and continuing through today, across a number of enforcement matters, including new source review, PSD, the appropriateness of best available control technology, the assessment of the impacts due to excess emissions as a result of not having excess or best available control technology, monitoring matters, stack testing, continuous emission monitoring, the representativeness of such monitoring in characterizing emissions, and enforcement matters, which I probably cannot get into in great detail.
Understood. So have you been, you mentioned that you've worked in other legal proceedings. Have you been qualified as an expert in those proceedings?
I have in a number of not only administrative proceedings, but also in state and federal courts.
And what were the topics on which you testified in those hearings as an expert?
But covers the range that I just spoke, but certainly for this particular matter, dealing with permitting, emission inventories, development of monitoring or verification programs, best available control technology, which is not directly relevant here, and related matters, including overall regulatory compliance.
So is it fair to say, Dr. Sahu, that you have familiarity with the Clean Air Act, its regulations, and EPA guidance on the Clean Air Act?
I do.
Okay. At this point, Mr. Hearing Officer, I'd like to move to qualify Dr. Sahu as an expert in air permitting, emissions, air pollution controls, monitoring, compliance, and modeling.
Are there any objections?
No objections. Thank you.
Okay, hearing none, the motion is granted.
Thank you, Mr. Hearing Officer. So, Dr. Sahu, let's start to talk about your testimony today. So I just want to reiterate that you submitted a written report with a statement of intent. Is that correct?
I did.
And that was that's Community EIB Exhibit 1, I believe. So let's talk about AP emissions factors. Dr. Sahu, can you tell us a little bit about the background of AP 42 factors, what their purpose is, when they were promulgated, and how they're intended to be used?
Sure, happy to do that. AP 42, sometimes the full name is Air Pollution-42, is a document that began somewhere around 1970. And the Clean Air Act, Federal Clean Air Act, although there were a few previous incarnations, really the first major version of the act was also in 1970. And EPA, federal EPA, actually was formed in 1970. So right about that time, AP 42 began. Of course, we didn't have the internet as paper versions of a compilation of emission, what we call emission factors or emission estimation methods. In air pollution work, that is the beginning of how you do any assessment, whether it's for permitting, whether it's for developing air pollution planning efforts in an area to see if it meets standards. Everything begins with doing what's called an emission inventory, sort of who is emitting what pollutant in what quantity, at what time, at what location, and how that varies over both time and space. Before you can do any assessment, you need to do that quantification, that building of the emission inventory. When the Clean Air Act was enacted and began in 1970, we were faced with very high levels of pollution throughout the country. And the idea was to reduce that. And so a lot of effort went to assessing just what pollutants would need to be controlled and to what degree. And developing these regional emission inventories was very important. I live in Southern California, South Coast Air Quality Management Basin, as many of you may have heard, one of the smoggiest sort of parts of the country. There's Houston, there's Dallas, there's Atlanta. Every place needed to develop emission inventories. So EPA put out what they thought was a helpful compilation of techniques to be able to do that. And that was the genesis of the beginning of AP 42. I won't take you through the details. And over time, so it bifurcated into two volumes. One was for stationary and area sources, and the other one was for mobile sources, for things like cars and buses and trucks. And so those documents, EPA put out to practitioners, to state agencies, to whoever really wanted them, if they were developing emission inventory for whatever purposes that they were doing so. Right from the very beginning, EPA had cautionary words about what the intended purpose of AP 42 was, which is to develop these regional planning inventories. In any case, they went through updating that over time, and I'm going to fast forward. 1995 was the 5th edition of AP 42, and that is the current edition of AP 42, and that is now available and has been for some time over the web. And so if you go to AP 42 on EPA's website, there are about 200 different chapters dealing with different type of sources, for which there are maybe 5 to 50, depending on the complexity of the industry or the sources that are being characterized, discussions about what that source is and what emission factors or techniques EPA has received from others, and they have put that into a compilation. And there's an introductory portion of what AP42 is that's also available on the web. And all of this has to do with the stationary source portion. We're not dealing with the mobile source aspect in this manner. So that is the broad genesis of AP42. What EPA does is periodically, as they have funding, as they have time, and as they have a new information that comes to them, they consider updating individual chapters. Just for everybody's benefit, the last time AP42 got updated, any chapter out of these couple of hundred, was 2011, about more than 10 years ago. And since 1995, they've updated several other chapters, but probably about 20 or 30 chapters, some more than once. But that is not required that they do that. They solicit information from anybody really that is doing work in air pollution. And if they get enough information and they have enough priority and enough funding, they can put out an update. And that's how the process has worked for at least about the last 3 decades that I've been doing air pollution work in this country.
So, Dr. Sahu, given what you're saying, is it fair to say that AP42 emissions factors are a conservative method for estimating potential to emit from a specific source?
No, they're not. They're exactly the opposite. And in this case, the word conservative, as you intended, is to provide an upper limit, if you will. Conservative in the way we do things in air pollution is to look at impacts in sort of a worst case basis or in the upper bound basis and see, and there's good reason for doing that. If the impacts are not adverse, if they're acceptable when you do it that way, then you don't have to worry about any impacts that are less conservative, that are less than that upper bound. That upper bound is potential to emit. How much can a source actually put out? That upper bound can be an allowable limit, which is limited by permit, as long as that is verifiable and enforceable. It can be any of these upper bound limits. AP42 is not designed and has never been designed to be used to develop these because every factor in AP42 is an average. And that is simply how EPA has done it since its inception. And that average is fine because when you're developing regional inventories and area-wide inventories, so if you want to look at NOx emissions from all sources in general from all of the state of New Mexico or in a particular part of New Mexico, using an average makes sense. Or if you're developing a permit fee program, how much the agency money should be collected from people who are putting out air pollution, an average makes sense. It was designed for that, has never been designed as an upper bound, whether it's an allowable or whether it's a potential to emit, to be used in individual sources and individual permitting decisions. EPA puts out these compilations and says, use at your own risk. And they do it in a certain way that cautions the user that if they are going to take these factors and use them in a different way for their own purpose, nothing prevents you from doing that, but you need to be very careful about how you're taking a factor from a particular table from AP42 and plugging it into a calculation and what you're going to do with that calculation.
So you talk about in your report, Dr. Sahu, about uncertainty with respect to AP42. And you touched on that a little bit, but I wonder if you wouldn't mind going a little more into depth about why AP42 emissions factors are unreliable.
Sure, happy to do that.
Excuse me, I'm sorry to interrupt. Is there any way to increase Dr. Sahu's volume?
Yeah, is this better? Can speak up a little louder. Is that clearer?
That is a little better. Thank you.
And I will have my volume on my laptop at the maximum. So please do tell me, Ms. Gibson, if you can't hear me still.
It may be a WebEx thing too. Thank you.
Oh, yeah, I mean, I can hear you perfectly. So I will I do tend to trail off at the end of my answers, and if that is happening, do let me know. So if I remember the question, it's about uncertainty. And with just a minute here, how does a number appear in AP42? I mean, it begins with that. EPA doesn't create these numbers by running computer programs. EPA doesn't create these numbers by doing engineering analysis. Most vast majority of AP42 numbers come from testing that has been done at one or more sources, like a stack test. If, somebody goes out and measures something at a source, we call that a stack test or a source test, and they do and get some numbers, and then there's a source test report. EPA is either provided that, either because they went to collect that kind of data, making a request of different people in the country, or they were simply provided that type of data, or in some cases they have made a concerted effort to go gather data, but all of it from stack tests. And EPA then takes that data. In some cases, there may be just one stack test, literally, that an AP42 number is based on. It may have 3 runs and 1 stack test. In some cases, it may have 100 stack tests. But all that stack test information is digested, is then analyzed by EPA, and EPA makes a recommendation. And when it makes a recommendation as to what that average for that particular type of source may be, it does so by providing what's called a rating factor, a alpha rating, A, B, C, D, U, and A, B, C, D, E, and EPA used the U rating factor for somewhat different that we won't get into, but at least A, B, C, D, E in AP42. That's how EPA tells the user that these factors have certain uncertainty associated with them. It does not quantify the uncertainty. It doesn't tell you what the plus or minus error is when you pick a factor in AP42. For the most part, you will get just a number, and then there'll be a rating assigned to it. You can go back to the underlying documents where that came from. EPA does provide, in many cases, things called background information documents, which do contain either directly or points to other primary sources like stack test reports from which you can get that information. And that is very important because when you are looking to apply an AP42 factor for a particular source, it is the obligation of the user to decide if that factor applies to that source. Just because there's a test done for a different source, it doesn't mean you can simply grab that without considering that uncertainty and use it for your current application. And that is the whole purpose of those rating factors. And that's one way EPA has conveyed rating factors. Even with the A-rated factors, the highest rated factor in AP42, there is uncertainty and significant uncertainty with even the A-rated factors. And of course, that becomes worse as you go to the B, C, D, and E-rated factors.
And so can we go back to this idea of these being averages, Dr. Sahu? I mean, practically, what does that mean in terms of uncertainty?
Practically, what that means is if you have more than one test and more than one run, even from a single test, it is never true, and I will say that as an absolute, that you will have the 3 numbers in a test be exactly the same. You will have differences, just the way emissions are created, the way emissions are measured. Even if the source is running as close to perfectly during the test, you will still have variability because that reflects the complexity with which emissions are generated and come out into the atmosphere. So if you have, so we think of it as distributions. In other words, if you have a number of different tests, each with a number of different runs, you have a distribution of what those emissions were. And when you have a distribution, as all of you know, you can create an arithmetic average out of that. You can say, if I have 5 numbers, 6 numbers, 20 numbers, I can simply create an arithmetic average. I take the standard average out of all those numbers. It represents a sort of a central tendency of that distribution. You can do other averages. You can do a geometric average. You can do a median. You can do a mode. So there are all these statistical ways to characterize the center of that distribution. But once you've done that, you've lost all information about the distribution itself. If I tell you the average of something is 3, I don't tell you much about whether the underlying distribution had 1s and 2s and 3s and 4s and 5s. All you know is the average was 3. You don't have any idea about its spread, its standard deviation, or even the shape of the distribution. And so that's why an average is, while it represents a central tendency, cannot represent the distribution. And in particular, it cannot represent the upper part of the distribution, where we need to do that for our worst case analysis when we're doing things in permitting, when we're doing things in risk assessments, when we're doing things in dispersion modeling, to look at how things compare with national ambient air quality standards, where we want to look at that worst case. If not the extreme maximum, at least what is the 95th percentile of that distribution, or the 90th percentile of the distribution that should be used in these other uses of those emissions, not for area-wide inventory or for air quality planning or for collecting emission fees, but for permitting and permitting at individual sources. We are interested in that upper bound. That average cannot give us that upper bound, and the average by definition will be much lower than the upper bound.
So it sounds to me, and correct me if I'm not hearing you right, Dr. Sahu, that even the most highly rated AP42 factors have a large degree of uncertainty. Is that correct?
Yes, even the A-rated factors have uncertainties, meaning differences between that 95th percentile and the average, or that difference between that upper part of that distribution and the average, that can be very significant. And that is readily ascertainable if you look at the underlying data. And I think EPA has done that in a few instances to see how much that upper end value might be different than the average, which is an AP40.
And EPA has issued an enforcement alert on this, hasn't it?
EPA issued, I heard some of these soliloquy. I'm sure we'll get into that in cross-examination here. AP42 is widely used. AP42 has been used since 1970. It's illogical to, of course, then say, therefore, it is perfect. It is not. And for all the reasons that I've mentioned in my report and happy to discuss here. But recognizing that AP42 does get used a lot doesn't mean that it is used accurately or properly or even appropriately. And EPA put out an enforcement alert in November of 2019. And that's important because that was actually done in the last administration, in the Trump administration, towards the very tail end of that. That EPA put out this enforcement alert, cautioning everybody because they saw widespread abuse of AP42. And if you look at that enforcement alert, and it is cited in my documents, it makes it clear that it is directed towards particularly how AP42 is being misused in permitting and enforcement matters, and it is being misused by not just consultants who are helping sources, but also various states. It makes that very clear. And that document has been out there as an enforcement alert on EPA's website for a little over 2 years now.
And Mr. Hearing Officer, I just want to check with the board. I can share my screen and put up that enforcement alert if it would help the board follow along. It's Community Rebuttal Exhibit 1 as part of the hearing record that was admitted earlier this morning. Whatever the board's pleasure is. I think you're on mute, Mr. Hearing Officer.
Would the board members like to have the EPA alert put on the screen? It has been admitted. Okay, I'm seeing we have Ms. Garcia would like to see it, so let's put it up.
Okay. Can everybody see that okay?
Yeah, I think you need to scroll up to the top if you can see the title.
Yes.
Yeah, now I can see it.
Okay. So,
So that is the enforcement alert we were talking about.
yes, this is the enforcement alert we were talking about. It's already been admitted into the record. So let's go through this if we can, Dr. Sahu. According to this, using AP 42 emission factors, and I'm looking at this underlined sentence. This underline is from the EPA, not from me. Using AP 42 emissions factors because they're averages would result in half the sources being in non-compliance. Does that track with what you've been talking about, Dr. Sahu?
Yes, a couple of things. That quote that is in the enforcement alert, by the way, is actually from AP 42. It's from the introduction to AP 42, which has been around since at least 1995, when that introduction was updated. And some form of that quote was there even since 1970. So that quote has been around for 50 years in its, essentially, as if you're counting years. And all it is recognizing is, yes, if you have a distribution of values, if you have that, you will have half the values higher than the average and half the values lower than the average. So if you're going to use it for compliance purposes, that is what will happen. You will not be reflecting that underlying distribution. If you can go up slightly on the on this page, Chance, I want to just point out in that opening paragraph, that purpose of why EPA is reminding people about the inappropriate use. And that's the whole point, inappropriate use of these factors, willy-nilly, indiscriminate, and without any consideration, blind use of AP 42. They say, make that very clear, that EPA is concerned, and I'm reading here, that some permitting agencies, consultants, and regulated entities may incorrectly be using AP 42 emission factors in place of more representative source-specific emission values for Clean Air Act permitting and compliance demonstrations. This is a 4-page document that reflects what is already in large part in the introduction to AP 42, and it's a reminder and an alert that this is going on. Its use is widespread enough, this inappropriate use, that they felt like they had to send out a general sort of a red flag warning to everybody who is doing that.
So let's go down a little bit further, Dr. Sahu. Let's start with this paragraph where the EPA cautions against short-term NAAQS compliance and emissions estimates being unreliable. Is that something that you agree with as well?
I do, and to provide a slight bit of context, we are taking a lot of time. If you can go up to the previous paragraph above the quote, just as a lead-in, the one that it begins under the consequences of using AP 42 factors. And so here, this is something really important here, and that's relevant, directly relevant to this particular permit. And that's the subject of my report. That the first sentence says that even emission factors with more highly rated grades, those ratings I talked about of A and B, they are also based on averages. And then it says, I'm not reading the whole thing, accordingly, even these A and B factors, by the way, are not likely to be accurate predictors of emissions from any one specific source, except in very limited scenarios. And then again, it sort of goes back to the quote. And as an example of that, in the paragraph that you were just pointing me to after, they point out that especially when you want to look at short-term averages, and they give an example of 1 hour, because now we have national ambient air quality standards for at least NOx and SO2 that are 1 hour. We do have a PM standard, PM 2.5 standard, that's 24 hours. In other words, these are relatively short-term averages. They're not annual averages. These uncertainties become even more magnified. And when AP 42 began, by the way, in 1970, or even in 1995, when it was last updated, its 5th edition, there were no 1 hour national ambient air quality standards for any pollutants. So this idea of using AP42 without regard to uncertainty, without regard to how it was intended to be used, it has just gotten worse. When you then take those emission numbers and feed them into models and then predict these short-term concentrations that you compare with national ambient air quality standards, it just does not make any sense. And it makes particularly little sense when your predictions are very close to those national ambient air quality standards, because that process is not designed to absorb this huge uncertainty in the input and somehow clean it up to have a less uncertain output. It doesn't work that way. Uncertainties only get magnified further through that analytical process. That's the basis for EPA's concern in that paragraph.
And just for clarification, Dr. Sahu, is it your understanding that AP42 emissions factors were used to calculate short-term potential to emit in this case?
AP42 factors for the vast majority of the calculations. There were a few that used some engine emission factors, but the vast majority of emissions estimates in this permitting action were based on AP42 factors, and that is what I have critiqued in my report very carefully, looking at what was done. Yes, AP42 factors, and without, maybe further ado, the vast majority of the AP42 factors that were used were not even A or B rated factors. They're mostly D and E rated factors, the lowest of the rated factors, even within AP42.
Okay, and so the uncertainty involved with AP42 also goes to the drop equation, which you mentioned in your report. Could you explain the drop equation, Dr. Sahu, and why that's relevant to this permit?
So one example of a calculation that is done in this permitting action is what we call in the business a drop equation. A drop equation is when you're trying to estimate emissions of particulate matter. Now, this is not NOx or anything else, gaseous pollutant, it is PM. And as all of you know, PM has different sizes. There is PM 2.5, which is the very fine particulate matter, 2.5 microns and smaller, PM10, and so on. So when you drop material from one point to the other, and that happens widely in all kinds of material handling, you have a conveyor conveying some material and then it drops into a pile, or you're loading a truck with some material that can create dust. That activity can create PM emissions. And the idea is, how do you quantify that rate of PM emissions? And it is done through a set of formulas that are provided in AP42 collectively, called the drop equation. And that's what I mean. I've given that as an example where AP42 makes a prediction and has that in AP42 of how you should go about estimating your PM emissions, whether it's PM10 or PM2.5, or even total suspended particulate, which is PM30 roughly. And people use that drop equation, and they use it for any time material is dropping. And I've given that as an example of this uncertainty because there was some testing done to compare what that emission prediction would be from AP42 with some measurements of when you do drop material of different types and you actually do that field measurement, sort of a stack test, but not quite a stack, but looking at what is being released as a result of the drop. You can do that type of testing in the field, by the way. And that is an example I've given to show you how different the actual test results are compared to what AP42 would predict when you use that drop equation.
And that's attached as exhibit, community EIB exhibit 3. Is that correct, Dr. Sahu? A PowerPoint of that study in Florida?
This study was done in Florida. It was done over 10 years ago. And exactly in Hillsborough County, which is where Tampa and, still Clearwater, that area where they were looking at, and they did experiments actually testing to see how AP42's drop equation, since it is so widely used, compares with the actual measurements. And that I have enclosed that in my report, whichever exhibit you mentioned.
Yeah, and again, what was the conclusion of that study? How did the AP42 factors compare with the monitored evidence?
So they did a series of tests. There's not just one test, different circumstances and different types of results. The best case that they got, and this was best case meaning where the actual measurements were closest to what AP42 would predict. The actual measurements were over 8 times higher, a factor of 8. And I don't want to misspeak here. I want to just look at my report, and I have it handy, and I will just go to that exhibit if you give me a second, because I don't want to go by memory here. And the worst case, which is where the emissions were highest, was 393 times higher than AP42. So they had a range from somewhere around over 8 times to as much as little less than 400 times more than AP42. And their conclusion, rather not surprisingly, was AP42 continuous drop equation grossly underestimates PM emissions up to several orders of magnitude. Orders of magnitude, as you know, are 10, 100, that's how we do orders of magnitude. 10 times higher is 1 order of magnitude, and so on, up to several orders of magnitude. And so this is an instance where there was an attempt of comparing what you would get from AP42. And by the way, that drop equation is not rated, E or D or even one of the worst ones. So here is a stark example of how much uncertainty there would be and how underestimated AP42 would be. And there is simply no way you can take that level of uncertainty, put it into a model, and claim that somehow the model can absorb that level of uncertainty and underestimation in the emissions input to that model. It doesn't work that way.
Okay. So with all the shortcomings of AP42 that you've identified, Dr. Sahu, is it your position that AP42 factors should never be used in estimating source emissions?
Nope, not at all. It's illogical to draw that conclusion. AP42, as I said, does have A and B rated factors. AP42 has factors that are A and B rated. You can use them for developing inventories. State could decide what is the total amount of NOx coming from all boilers in the state of New Mexico. You can use AP42 quite, the average in that case doesn't, is an appropriate metric to do that kind of inventory work. You want to develop, other programs, fee payment programs, you can use AP42. If you want to look at all of these sort of planning type of work, AP42, especially the higher rated factors, they get used all the time. There is nothing wrong with them. Whether it is the Western United States or Central United States or Eastern United States, doesn't matter. AP42 can be used in any of those things anyway. It's not geographically restricted. The problem is when you bring it and start using a factor without considering the rating, without making adjustments to that factor based on the underlying data, where it came from, without considering whether you could do a test from an existing source that would be far more accurate at all times. When you just skip over those steps, that's when you get in trouble by just grabbing something from AP42 and running with it.
So when you say that the Environment Department in this case has committed regulatory malpractice, why do you say that?
I say that not because I want to say that. I say that because that accurately reflects what has gone on here. I've been doing expert work for over 20 years now. I use my words as carefully as I can. In this instance, I start my report by showing that even the application as was submitted to the permitting authorities at NMED, the applicant itself said, using AP 42, and that's all laid out very clearly in the application, I am coming to within a whisker of exceeding national ambient air quality standards. Take PM 2.5, it was something like 97 or 98% of that standard. In other words, you would have to be accurate in your emission estimates, considering all other uncertainties, setting them aside through meteorological data, through how you characterize your source, all the other assumptions you have to make in your air mod modeling. Even if you assume that every one of those was perfect, you would need to basically be only off by 2-3% in your emission input to be able to exceed the standard. This was not a case where you had used AP 42, but you were so far below the standards. You were so far below, meaning you were maybe at 10% of the standard or 5% of the standard. You are far from the standard that you could say, all right, if I have some uncertainty in the emission factors that are used, I have a lot of margin, I have a lot of headroom that I'm not at risk of exceeding my standard. Here, that was not the case. And you had, of course, there are issues regarding background and whether that was appropriate or not, but collectively, you're very close to the standard. And so close that the first thing that a permitting agency would do is go back and look at the appropriateness and the care with which you've estimated the emissions. Now, when I looked at the record beyond that, I saw that what the permit engineers had done was check the arithmetic that was provided by the applicant. In other words, whether a multiplication was correct, whether a number from this table was correctly multiplied by a different, maybe a production number to come up with a hourly estimate or an annual estimate. I think there was an attempt, as I can see in the notes that are in the record, of checking the arithmetic. And I'm not saying that checking the arithmetic is bad. Of course, that is important to do. But checking the arithmetic is not the same when you simply don't question or don't inquire as to whether the numbers that are going in your arithmetic are appropriate or not. The same checking of the arithmetic clearly shows in the record that those rating factors were right next to those numbers that were being checked. There are pages from AP 42 that are in the record where staff from the department went and said, was the right number pulled? And right next to it, you'd see an E rating emission factor. That number was an E-rated factor, the lowest in AP 42. So it's okay to say that 2 times 3 is 6, but if that 2 itself could be 20 or 200, it doesn't matter that you check that 2 times 3 is 6. I mean, this is rearranging the deck chairs on the Titanic. That is why in this instance, and that is very important to remember, when you're so close in your own analysis to exceeding those national ambient air quality standards, to simply not even be aware, or if you are aware, not consider that that is a very large problem. And until you cure that problem, you can't go back and turn around and say, as the department has done, that we are in the clear because we are below the national ambient air quality standards. That conclusion rests on what emissions you fed into that model to reach that number. That is the big problem here. And that is such a big problem that it actually swallows the other problems, quite frankly, that could otherwise be problematic, but we don't have to get there because if you're off by 10, 20, 30 times, or 100 times, or 400 times in your emission estimates, you can't turn around and claim there is no technical basis. There is nothing in the record. There is nothing in the procedure. There's nothing in the methodology or in the modeling that will simply absorb that type of huge uncertainty to then claim to the public and to everybody that we are okay in granting this permit because we are below the standards, ambient standards that we have to stay below. Thank you.
So thank you for that, Dr. Sahu. Well, let me ask you this. You've had the opportunity to review the record, which includes the permit that was issued. Is that right?
Yes.
So let me ask you this. The permit that was issued has a lot of different conditions, some of which bear on either confirming the AP 42 estimates or ensuring compliance with the NACs, right? So one of them
Well,
is...
let me add a clarification. There is no condition I found that confirms an AP 42 emission factor. I mean, I think there are some conditions that attempt to verify what the mass emissions might be that might be coming out of some of the stack sources.
Okay, so thank you for that clarification, Dr. Sahu. Verifying that the emissions estimates. So part of those are compliance testing. B1 section condition B111 at page B11 of NMED's Exhibit 16. This has to do with the initial initial compliance testing. Does that give you any additional comfort about whether or not this operation will violate the NACs or not?
It does not, but I should clarify. The permit has two broad sort of sections. One is source specific sections and limits, and they are A numbered, and then there are general conditions that are the B numbered conditions. In the first part of the permit, where you talk about the source specific conditions, there is a requirement in several instances to do a single initial stack test. That's not uncommon in permits. And so that requirement is there. You shall test initially for certain pollutants coming out from certain sources. I must make it very clear that there's nothing in the permit I saw that would require testing of all sources. And of course, many sources are fugitive emission sources, and they produce huge amounts of emissions, particularly the PM emissions, for which the NACs is very much at risk. There is no testing requirement that I saw for those sources, but there are some stack sources. There is an initial requirement, not a continuing requirement, just an initial requirement that I saw to do a test. And then the B condition that you alluded to kind of provides some detail on how that initial testing should be done. Sort of the general idea of how that initial testing should be done is clarified in the B conditions.
Okay. In addition to those testing requirements, and could you, I think, expand a little bit about why you don't think that those are sufficient to ensure compliance with the NACs?
Happy to do that.
Mr. Jantz, could you give us an estimate of how much more direct examination you have for Dr. Sahu?
I think that we're about 2/3 the way done, maybe a little bit more.
Okay, we've been going now for over 2 hours. Let's take a 10-minute break and we'll come back and have you wrap up your direct and then go to cross by Mr. Vigil and see where we stand at that point. Okay, so we will come back at 11:25.
Thank you, Mr. Hearing Officer.
Ms. Gibson, is the sound any better or are you still having trouble hearing me?
I wish it were louder, but I'm afraid to mess with it because I'm not really familiar with WebEx.
Yeah, okay, okay. And if you have trouble, please ask me.
I think it's going to be fine if everyone speaks up. I don't know, Pam, do you know, is there anything I should do to get my sound up a little?
Well, have you done the obvious and turned the computer sound up? I've
You
had to
know,
do that this morning.
I hear everyone except the witness, and he's just a little soft.
I have my computer sound turned up as high as I can, so I don't.
Yeah, oh well.
Okay.
That's okay, I am hearing, so.
Perhaps getting as close to the microphone as possible.
Yeah, I'm trying that without.
I know it looks like you're pretty close, but sometimes.
Yeah, cut my head off here, so.
Okay, let's go back on the record. Before you start, Mr. Jantz, my intent here is to have the direct examination of Dr. Sahu completed and then break for lunch. Based upon your estimate, we should be around noon, maybe a little bit after. That's just for everybody's information. So let's try and get that done. Thank you.
Absolutely. Thank you, Mr. Hearing Officer. Shall we proceed?
Please proceed.
Thank you, Mr. Hearing Officer. So Dr. Sahu, we were talking about whether or not you thought the compliance conditions, the initial compliance test conditions in the permit gave you any additional comfort about whether or not this plant will ultimately violate the National Ambient Air Quality Standards. So if you wouldn't mind repeating your conclusion and giving us an explanation about how you arrived there.
Sure. I have looked at the permit and the compliance or testing or verification conditions, and it is my opinion that the conditions that are included will not provide the assurance that you would continuously comply with the National Ambient Air Quality Standards. And so I start with that, is there's an obligation to comply, not just at one time or even at the initial time, but at continuously. In other words, that's the expectation in air permits. So at the very least, you need enough verification about your emissions, more than just on a one-time or initial basis, to be able to make that judgment. If you are not measuring emissions other than that one time, for example, for many sources where you're not measuring them even that first time, fugitive sources, or even for the stack sources, you're not measuring them but just once, and then relying on other parameters, and I saw at least a few, like opacity or a pressure drop from a control device, a bag house. In other words, you would track those surrogates, let's call them, those other parameters. Then you have an obligation to show how those surrogates are related to those emissions that you are going to be effectively indirectly relying on those parameters for. Take opacity as an example. If it is most often thought to be a surrogate for particulate matter, PM type of emissions. Even so, there is no universal correlation that if you measure opacity at a certain level, you will always have an emission rate from a stack at a certain level of PM10 or PM2.5. And those relationships are not established. And those relationships are not linear. Those relationships are dependent on many other variables, just even for opacity. The size of the particles, the angle of the sun, whether you're doing a particular method the right way or the wrong way, the certification of the observer, all of those things get into, those complexities get into even relating what is in the permit, like an opacity, and it presumes that as long as my opacity is okay, my PM would also be fine. Similarly, the baghouse pressure drop, it doesn't really relate to the actual emissions. Those things are good predictors of the condition of your baghouse. If you have a big leak, you'll see an opacity, you'll see some changes in pressure drop, and you can go back and do maintenance on them. You can go back and say, hey, something's wrong, fix it. But not as a predictor of emissions. And in any case, whatever prediction is not there in the permit. And then for these other pollutants, NOx or SO2, I mean, there is really no reason to expect, something like opacity or pressure drop of a baghouse to even provide any information on those. So I did not. Looking at it carefully, I saw the permit not contain conditions that would provide compliance assurance.
Thank you, Dr. Sahu. So it looks like we're going to be a little bit ahead of schedule. Let's wrap up, Dr. Sahu, with your thoughts on ambient air. You talk about that at the end of your report, and you say that NMED's misinterpretation of ambient air is likely moot. Why do you say that?
Well, mainly because I have pointed to such significant underestimation and problems with the emissions that have been fed into the dispersion model, that until you go back and do a much better job on that, those dispersion model predictions are inaccurate and, in my view, grossly underestimated the way they have been done, using averages, not accounting for uncertainty, using poorly rated emission factors, all of those reasons that we briefly touched on in my direct testimony here and in my report. And it is only after you do the modeling analysis correctly, i.e. with proper inputs, at least on the emission side, not to mention whatever else choices have been made in the modeling. It's only at that stage, after you have those predictions, those concentrations around the facility, that you can begin to have a meaningful discussion about making adjustments for ambient air, which really is an adjustment for excluding certain portions of those concentrations that may happen in an adjoining property due to that property owner's activities, where the public has no access. So, but if your emissions calculations are so off that your concentration predictions are equally off or even more off, then I think that discussion is premature. And that's why I said it's moot.
Okay. Thank you, Dr. Sahu. I appreciate your testimony. And that's all I have, Mr. Hearing Officer.
Okay, thank you. Let's turn to cross-examination of Dr. Sahu. We're running a little ahead of schedule, so we'll go ahead and move in that prior to breaking for lunch. So the department would be first up on cross-examination, and we'll just start with that and see how it goes and break at an appropriate point for lunch.
Thank you, Mr. Hearing Officer. This is Chris Vigil, New Mexico Environment Department. Madam Chair, members of the board. Pam, can I have sharing capabilities? I'm not sure if I'm able to do that. Let me try really quickly, but I have some documents I'd like to share.
You should have sharing access.
Okay, thank you. Thank you. Let me see here. Let's see. Can everyone see what I'm sharing?
I can see it.
Dr. Sahu, can you see this?
Yeah, I just want to sure. Yeah, I can see. Is this something that looks at Romans 6 conclusion and then some highlighted text?
Okay, thank you so much. Thank you so much, Dr. Sahu, for your testimony. You said in your testimony that, well, just preface it by saying, let's talk first about your views on AP 42. You said in your testimony just prior to my cross-examining you, towards the beginning, that it was your opinion that AP 42 should never be used as the only emissions factor. Is that correct?
What I said is, in this permitting context, if you simply use AP 42 without regard to the fact that you're using average emission factors, that is inappropriate.
Okay, thank you.
There are other rating and other uncertainties. I'm sorry, I didn't want to interrupt you.
No, that's no problem. Thank you so much. I want to look at your conclusions. But let's take a look at the first conclusion. And let me just ask you really quickly. Do you recognize this as your testimony?
Yes, it is.
Okay. So here you say your first conclusion is the use of AP 42 and its worst ranked emission factors to estimate emissions from existing source like associated asphalt, whose emissions can and should be tested and measured, is regulatory malpractice. Is that your? Do you agree that that's what's in this document here?
That is in this document. Yes.
Yes, and Mr. Jantz asked you during your direct examination why you said it was regulatory malpractice, and your response was because it is. Is that correct?
Well, I don't think that was my response. I think I gave my reasons why I carefully used that term and reluctantly so, quite frankly, but it seemed to fit the facts. And I gave you my reasons. I didn't say because it is. That is plainly incorrect. And we only had that discussion literally less than 30 minutes ago. I said because it's in the beginning of my report, I first established the predicate.
Mr. Sahu, I just asked you if it was correct. I'm not examining you directly, with all due respect. Okay, so I'd like to ask you, I've never heard this term regulatory malpractice. Where did you get this term?
What do you mean? I haven't cited to anything. That is the term. It is my description of the state of affairs leading up to this permit.
I see. So this is a term that you've made up yourself, and you're introducing this term. This is not a term of art in the industry. This is just a term you're using in this permitting, or let's just say in your testimony. Is that correct?
I haven't looked at the industry broadly and whether it's a regulatory term of art, so I cannot say. I've not done that inquiry.
Okay. And so you're here as an expert on AP 42, and you give testimony under oath, and I appreciate that. It's been interesting listening to you. But I'd like you to define regulatory malpractice. Or let me just ask you this: how do you define regulatory malpractice?
Well, I think it's right there in that very text you've highlighted. So first of all, it is in this context. Okay, it is what happened in this permit. So in reference to a source like AAM, it is dependent on the fact that here is an existing source. It is not a new source for which you don't have the ability to verify some things and assumptions you're making. It's an existing source. It's a consolidation of operations into one location, all of which are existing operations. And you could test and measure things. If you're aware of these big uncertainties and the shortcomings with AP 42 that I've outlined here in my report and in my direct testimony, you could cure, or at least attempt to cure that by collecting the measurements from these existing sources. There was no discussion or consideration of that. And then the fact that the AP 42 factors that have been used.
Well, Mr. Sahu, you've given lots of testimony on AP 42. I'm just focusing on this phrase, regulatory malpractice. Now, malpractice, it seems to me that the word malpractice indicates that there is a preferred or regular practice, a standard practice. Would you agree with that?
First of all, I'm not a lawyer. And yes, the standard practice is what I'm describing there. The emissions could have been tested. Emissions could have been measured.
I see. So, okay.
I think, Mr. Riddle, you have to let me finish my answer. You ask a question and you interrupt me, and I think that is, that is not fair. If you're going to ask me a question and I'm going to be in the middle of explaining it to you, you can't be cutting me off. Can I?
Okay.
And I will do the same thing and ask for your forgiveness if I accidentally cut you off. So I'm using the word malpractice because there are other steps that could have been taken here. Not one, not two, multiple steps to assure better quality emissions information to be fed into the model, since that is ultimately the tool that was being used to judge whether something is in compliance, whether the sources emissions would be in compliance with the National Ambient Air Quality Standards. I've given you examples of that. So you want to spend time on whether what malpractice is? Yes, I've given you examples of proper practice would have been to consider the ratings of the emission factors that have been used from AP40.
Mr. Sahu, I know you don't want me to interrupt you, but I am the one asking the questions, and you're being cross-examined. You're not giving a direct examination. You've had that opportunity, and so I really just would like you to answer my questions. Okay, so this phrase malpractice, I want to spend a little bit more time on this, because based on what I'm hearing you say, you're not saying it's malpractice at all. It sounds to me like what you're saying is that the use of AP42 is something that you don't recommend, but you're using the word malpractice as a substitute for saying that you just don't recommend it. Is that a fair summary of your use of the word malpractice?
It is not, and I will just go with what I've stated there.
Okay, thank you. Now, again, going back to this word malpractice, to my mind, I'm thinking, malpractice indicates that there's some sort of standard. Now, is AP42 used by other states in the United States?
Yep, I'm sure AP42 is used by other states in the United States.
You had mentioned the state of California. Are you aware of whether or not AP42 is used in California?
I think California is one of the United States, so AP42 is used in California.
Okay. You also mentioned Florida. You gave an example of Florida. I believe that there's a PowerPoint in your testimony talking about some tests that were done in Florida. And it seemed to me that it was being used to bring into question the usefulness of AP42 or the protectiveness of AP42. Is AP42 used in Florida?
I didn't understand your question about protectiveness. If you could elaborate so I can answer your question properly.
I'm sorry. It seemed to me that your testimony on the tests that were done in Florida indicated that AP42 maybe wasn't the best way to go. Is that a fair way to briefly summarize your point on Florida?
Well, first of all, it's not a question about all of Florida. I pointed to testing done, which happened to be done in Florida, showing that the AP42 predictions were much, much lower than the testing actually showed.
Okay, thank you for that clarification. Does the state of Florida allow the use of AP42 emission factors?
Yes, I think we can establish that AP42 is widely used in the United States.
Okay, thank you. I want to do that right now, if we can. Can you see this document?
It's a City of Albuquerque Environmental
Objection, Your Honor. Mr. Hearing Officer, Dr. Sahu didn't testify about the City of Albuquerque's Environmental Health Division permit application checklist. If Mr. Vigil wants to use this as a rebuttal exhibit, he should be able to, but this goes way beyond the scope of direct.
No, it doesn't. These are the exhibits that we discussed that were admitted specifically for cross-examination on AP42.
But Dr. Sahu didn't testify to this in his direct testimony. So this is beyond the scope of direct, by definition.
This is not being used to discuss the City of Albuquerque. This is being used to discuss AP42.
I'm sorry, Mr. Hearing Officer, you're on mute.
Me, I don't think we need to have more argument on this back and forth. This is an exhibit that has been admitted, and I will allow questions to be asked on it insofar as they relate to the use of AP 42. The witness did testify about the 42 by various regulatory agencies.
Dr. Sahu, this is, do you agree that this is a permit application checklist from the City of Albuquerque's Air Quality Division?
That's what it says in the title. That's the upper part of the document I can see. That's correct.
Thank you. And could you read the highlighted portion of this checklist? It's itemized number 16.
It says contain the basis or source for each emission rate. Within paren, include the manufacturer's specification sheets, comma, AP42 section sheets, comma, test data, or other data when used as the source, end of paren, stop.
Okay, thank you very much. Let's see here. I seem to have lost a document here. Let me see if I can get this up.
Sure, take it.
Mr. Hearing Officer, I think maybe this would be a good time to break for lunch. I have a large document that I need to bring up, and I mean, I'm happy to do it now. I just don't want to keep anyone here from a, or I don't want to have anyone sit and watch me do this, but I'm happy to do it now if you want me to keep moving forward.
Well, let's keep moving forward. Let's see if you can get the document up. If it's taking considerable time, we may recess for lunch, but I'd like to get as much accomplished this morning before we break as we can.
Okay. Okay, I want to move to, I think this is EIB exhibit number 19 for folks who are following along here. I'm hoping it pops up here in just a second. Here we go. And this is NMED EIB exhibit 19. And I'm going to go to page 21 for those who want to follow along. We've done page 21. Dr. Sahu, can you see this document?
It's scrolling. Is it the one from the Arizona Department of Environmental Quality?
Yes, and this is application completeness checklist for hot mix asphalt plants. Is that correct?
That's right.
Okay. We go to page 32 of this document, the application instructions. Let me see here. Dr. Sahu, could you read what's in yellow in this document from Arizona?
Sure. Just the highlighted portion?
Just the highlighted portion, yes, thank you.
If the above calculation spreadsheet is submitted, the applicant is not required to complete tables 1 through 25 of Form C of this application. Otherwise, the applicant must complete tables 1 through 25 of Form C. These tables provide worksheets to assist the applicant in calculating emission rates. Emission factors are based on AP42, compilation of air pollution emission factors by Environmental Protection Agency. There is a second full paragraph that goes into other things that is not highlighted.
Okay, thank you very much. And could you, this is a permit, do you agree that this is a permit application for significant modification for a permit, a hot mix asphalt plant that's in Hawaii?
I'm just reading that, and that's what it's saying. Whether I agree with it or not, I have not reviewed this, but I can
Mr.
read
Hearing
that
Officer.
exactly.
I'm sorry to interrupt, Dr. Sahu. Mr. Hearing Officer, I'd like to object again. This time on the grounds asked and answered, Dr. Sahu has stipulated that AP 42 standards are widely used in other states. It seems like Mr. V. Hill is wasting our time here.
I'm going to sustain that objection. The witness has acknowledged that it's used in several other states. These exhibits that have been admitted and can be referred to in briefing if you so choose.
Okay, thank you very much. So Dr. Sahu, of the exhibits that I had here, and your counsel was very compassionate towards you because I was going to take you through about 10 more of these. We have, they all say the same thing essentially. So, and you have stipulated to the fact that AP 42 is widely used. The exhibits that I have, it takes up most of the Western United States. That's what I was going to walk you through. So is it your position that about 25% of the United States is committing regulatory malpractice?
So it is, those are your words, and I will put it this way. In every instance you have showed me, the two that you have walked me through and the 10 that you haven't, AP 42 is a tool that is allowed, that people use. I've acknowledged that. Every one of those instances also says words to the effect that if you use other sources, if you use tax sources, if you use manufacturers' literature, provide those details. That is very common practice. There is no state that I know where it requires the use of AP 42 and AP 42 alone, exclusively, for estimating emissions. So that's number one. Number two, AP 42, as I said, is used for, is a compilation of all kinds of sources with different emission factor ratings. Some are A rated, some are B rated. I am talking about when I use my critique of AP 42 in this instance for this source with the specific chapters and verse and emission factors used in AP 42 that have the ratings that I've discussed, which are E and D ratings. So you want me to take my critique, which is specific here, and my criticism of that, what happened here, and say that the same thing must be happening everywhere, and therefore everybody is committing regulatory malpractice. That is illogical. And I'm going to point out the illogicality of that. So that is not what I'm saying. And there are places, as I've said in direct testimony, when one can use AP 42 for other purposes.
Well, Dr. Sahu, you and I can agree that that statement is illogical. Okay, so let's move on to, let's talk about your contention that, let's go back to your testimony. And what you say here is that the NMED and AM's adjustments to the definition of ambient air to account for NAAQS exceedances in the vicinity of the facility is opaque at best, and this lack of transparency has no place in the public record. So I want to ask you, first of all, are you aware of what the actual basis of the appeal with regard to the definition of ambient air is?
Just what I've read and what I have understood is how an adjustment was made to account for ambient air. So there's an interpretive issue, and then there's the calculation issue. My statement here pertains to the numerical calculations and the lack of support for that. That's the opaqueness and the lack of transparency that I'm talking about here. There is some calculation adjustments which I have seen and I have discussed in my report, and that statement pertains to no details being provided for those calculation adjustments.
I see. So do you agree then? I mean, you are an expert witness that is here with counsel. There is an actual substantive matter that's being appealed here, and you refer to this alteration of the definition of ambient air. Do you stand by your assertion that the definition of ambient air was altered by the department?
If you could point to my report and point me to where I say that the definition of ambient air was altered, that would help me.
Sure. Right here, it says the adjustments to the definition of ambient air. If you could see that right there.
Yes, adjustments to definition of ambient air to account for the NAAQS exceedances. That whole sentence, you have to read that entire thing up to and including all the parentheticals. I just pointed out and clarified for you that number 5 pertains to the numerical adjustments. The adjustments I'm talking about are the numerical adjustments that have been made in order to account for the definition of ambient air. That's how I interpret my writing there. You've made adjustments numerically to account for ambient air. So that's what I clarified.
Well, that's interesting because you're saying adjustments to the numbers, but that's not what you say here. It says adjustments to the definition. And that ties to the petition, because what the petition says is that the department unlawfully changed the definition of ambient air. So are you changing your testimony, Dr. Sahu?
No, I'm not changing my testimony, and I've clarified it. I have said, go back before, I've said, first of all, because of the emission problems, this is a moot issue. You have not reached the point where you have to even look at ambient air and make any adjustments, whether it's on the definition or whether it's how it's been applied, which guidance has been used, whether it's the more recent guidance. I've asked questions in my report, if you go back to before, on that section saying it is not clear which guidance is NMED actually consistent with EPA guidance. So I have raised those as separate issues about how the definition of ambient air has been applied here, giving you citations from the record, including what is the definition, the guidance, what is the testimony of departments, witnesses. It is not clear. So that part is a separate opinion, and I've stated so. In this last opinion, I'm saying further that there have been some adjustments made numerically. That's what I was clarifying. If you look at all of it together.
Okay. So you are not saying that even though your testimony says adjustments to the definition of ambient air, are you retracting that? You don't think that there was any change to the definition of ambient air. Is that correct?
That is not correct. Please go back. So since you're sharing this document and I can't see, if you can go back to the previous.
No, Dr. Sahu, I'm not going to go back. I'm asking you, I have my own thing that I'm doing here.
Okay,
I don't represent
I disagree
you.
with you. Then my answer is I disagree with you. That's
all. You disagree with me on what?
Whatever your question was, I disagree with you. In the last question, you can have them repeated. I disagree with your interpretation of what words you're putting into my mouth.
Okay. Well, then let's just walk through the definitions of ambient air here. Maybe we can get an answer together.
Sure.
Okay, this is, can you read, well, rather than torture you doing that, do you agree that this is 40 CFR Chapter 1 and that the definitions, Section 50.1 that have been admitted into evidence, is this the document you're looking at? Can you see this?
I can see it, yes.
Okay, thank you. And so definition E, can you read the definition that's in that is in yellow there?
Sure. Ambient air means that portion of the atmosphere external to buildings to which the general public has access.
I see. And that's a pretty broad definition, wouldn't you say?
Yes.
Yes. And now this federal definition, and I understand you're not an attorney, but based on your experience, do you know, is there a fencing requirement that would keep the public out of this? Well, out of, say, the property for definition of ambient air?
I just want to clarify what I heard. Are you talking about, is there a fencing requirement at the AAM property? Or are you talking about, is that the definition include a fencing requirement, just to be clear?
Well, the definition does not include a fencing requirement, and it's very broad. But in your experience, um, is a fencing requirement in place in order to keep the public out for purposes of defining ambient air?
Well, many times there is a fencing that a fence denotes the limit of that public access. It's just a convenient way. In fact, we use the term fence line for that very reason when we're looking at the boundary of a, whatever source or site that we may be interested in. So a fence certainly as a barrier, if it's effective, is used to caution the public that they don't have access beyond that.
Okay, thank you. But it's not in the definition that you see here, is that correct?
It is not in this definition, correct?
Okay, thank you. I have a document here, Dr. Sahu. This is a letter from a lawmaker, December 19th, 1980. What this document is, this is EPA guidance on the definition of ambient air because of the ambiguities you and I just spoke about. Now, can you read the highlighted section of this letter from December 19th, 1980? And this is NMED, let me see, I want to say this is NMED EIB exhibit, I can't get it. Let me go to the bottom here. Exhibit 24, I'm sorry. Would you please read the highlighted section, please?
Sure. I think you said this was written by a lawmaker. I think this was written by EPA to the lawmaker, but is my understanding. But it says we are retaining the policy that the exemption from ambient air is available only for the atmosphere over land owned or controlled by the source and to which public access is precluded by a fence or other physical barriers.
Okay, and so just a second ago, you and I had a discussion about some of the ambiguities that are in the federal definition. This is a EPA guidance, and do you agree that in this EPA guidance as of 1980, or the end of 1980, at least for a period, the EPA required a fence or a physical barrier?
Well, they're providing guidance that's one way of dealing with public access or precluding public access by a fence or other physical barriers which they don't specify.
Yes. Okay, I want to jump ahead now. This is another EPA guidance letter from October 17, 1989. This is NMED EIB Exhibit 25.
Sure.
Have you seen this document before, Dr. Sahu?
I'm sure I have. I mean, I've looked at a lot of guidance documents. I'm not sure I saw it in the preparation for this deposition, rather this hearing, but certainly I'm sure I saw it.
Okay, thank you. And could you read the highlighted portion of this letter, please?
Region 6 and the Texas Air Control Board propose that prevention of significant deterioration within PSD and modeling for Mitsubishi Industries can discount the contribution of a background source to the predicted concentration as follows. And then it has 3 numbered items. Item number 1, assume Mitsubishi and background plants B and C. Number 2, Mitsubishi and plants B and C are modeled and total concentrations are estimated. And 3, where a receptor is located on plant B's non-ambient air property, the contribution from plant B within paren only may be subtracted from the total concentration.
Okay, thank you. And one last document on EPA guidance. This is a memorandum, EPA memorandum from December 2nd, 2019. This is NMED EIB exhibit number 26. And could you read the highlighted portions beginning at the first paragraph? We could skip the subject.
Oh, okay. The U.S. Environmental Protection Agency is updating its policy on the exclusion of certain areas from the scope of ambient air, which is within quotes itself. And then there is some non-highlighted text. And then the next highlighting begins from the middle of a sentence. The EPA has long followed a policy that allows excluding certain areas of a source's property located outside of a building from ambient air. As described in the 1980 letter from then Administrator Douglas Cossell to Senator Jennings Randolph, this, quote, exemption from ambient air is available only for the atmosphere over land owned or controlled by the source and to which public access is precluded by a fence or other physical barriers, end quote. And then there's some more non-highlighted, and then we move on into the next highlighting, which is this revision to the ambient air policy, like the 1980 letter, considers as eligible for exclusion only the atmosphere over, quote, land owned or controlled by the within square brackets stationary source, end quote. While the 1980 letter said such areas may only be excluded when public access is precluded by a fence or other physical barriers, end quote, this limited revision more clearly recognizes that a fence or other physical barrier is not the only type of measure that may be used to establish that the general public does not, quote, have access to an area of land that is owned or controlled by the source. And then there is a non-highlighted sentence, and then we move to further highlighting, which is, thus, the EPA's revised ambient air policy, consistent with this discretion available under the regulatory definition of ambient air, is that the atmosphere over land owned or controlled by the stationary source may be excluded from ambient air where the source employs measures, which may include physical barriers that are effective in precluding access to the land by the general public.
Now, Dr. Sahu, based on what you've read in this letter so far, and I understand that maybe this is the first time you've seen this. Based on what you've read, does it seem to you that the EPA is opening up the definition of ambient air to include other types of preclusion measures other than having a fence or a barrier?
Well, first of all, I didn't say that I had not seen this before. I have seen this before.
Oh, I'm sorry.
Second, this letter is more than just a page here. But yes, the portions you had me read, EPA is saying you could effectively control or preclude general public access by more than just a fence or other physical barrier. That's my understanding.
So a little bit more here. Now it seems this letter goes through and describes some of the newer ways that you could construe a denial of public access. Could you read the highlighted section here?
In recent years, industry representatives have argued that the long-standing ambient air policy is overly restrictive because it purports to require the use of a fence to preclude public access and justify excluding an area. And then there's some non-highlighted, and then we go to the highlighted. It says, industry representatives have requested that given the advances in surveillance and monitoring capabilities and the variety of ambient air situations that have arisen since 1980, the language from the 1980 letter should be updated to more readily allow regulatory authorities to consider additional types of measures that are effective in precluding public access to a source's property, consistent with the regulatory definition of ambient air.
Thank you. A little bit more. Could you read this highlighted section here?
Sure. The EPA no longer, again, this is from the middle of a sentence, the EPA no longer considers, quote, a fence or other physical barriers, end quote, to be the only type of measure available to a source in order to preclude public access in a practical or physical sense.
Could you read the first highlighted section here?
For example, 5 years after the 1980 letter, the EPA allowed an ambient air exclusion based on the cumulative effect of a company's extensive property holdings, installation of fences, posting of no trespassing signs, security patrolling, and the rugged mountainous terrain. And full stop.
Oh, I'm sorry. And could you read the next highlighted section, please?
Sure. For example, there may be situations over land where it is also impractical or unduly burdensome to require a source to install a fence or other physical barriers when other means of precluding public access may be equally effective.
Okay, I'm going to move on, but I do want to ask you a question about this particular document in general. Now, based on what you've read in this document, and it sounds like you've seen this before, is this EPA guidance somewhat liberalizing the requirement for preclusion to open it up, and maybe be a little bit more permissive and expansive with regard to the methods needed to be established in order to exclude the public for the purposes of definition of ambient air?
Yeah, my understanding of this sort of updating or refreshing of the guidance is to, as you had me read, is to react to industry representatives who wanted such liberalizing, to use your word, of what that EPA's longstanding guidance has been. But while it recognizes that you could have more means or other means than fence or physical barrier due to advances in technology and any of those other reasons we've talked about, or you had me read, that it still says that they have to be equally effective. In other words, a fence is effective in a certain way. And so, yes, it's liberalizing in the sense of means, but not liberalizing in sense of the effectiveness, is my reading of this.
Yes, no, thank you very much. Okay, I want to move on. This is the EIB. This is
Mr. Vihel, I think this is a good time to break for lunch. We're at 12 minutes after 12. We're going to break for lunch until 1:15, and we'll reconvene and take public testimony at 1:15. And when that's concluded, we'll resume your cross-examination.
Thank you so much.
We'll be back on at 1:15. Thank you.
Thank you, Dr. Sahu.
Thank you. Yes.
Meeting where we're going to have our first segment of public non-technical testimony. We have 3 persons who have signed up to testify during this segment. I would remind those persons that are testifying that there's a limit of 5 minutes for your testimony. And I would encourage anyone else who's on here to also submit. If you do not want to submit oral testimony, you have the right to submit written testimony, and that can be sent by email to the host of the meeting. With that, the first witness we have is Ms. Linda Marianiello, and we will have her sworn and then she can present her testimony.
Okay, yes, I just unmuted myself. Can you hear me?
Yes, Miss Marianella, would you raise your right hand, please?
Yes. Can you see me, by the way? Because I don't have any video on my computer. It's kind of an older model.
Yes, we see you.
Yes, we can. I can see you.
Very good. Thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
Before I begin, I would like to say that as along with EarthCare, one of the people who is, let's say, centrally involved in this process, I would request that I possibly, if I'm not quite finished in 5 minutes and I run 10 seconds over or something, that I be allowed to please complete my comments.
Please, yes, you certainly may.
Thank you so much. I really appreciate it. Hello, my name is Linda Marianello. I'm a resident of Tierra Contenta. Thank you for this opportunity to speak. I'm going to address 4 topics in my comments today. The first one is Captain G.M. Gilbert's definition of evil from the Nuremberg trials. The second topic is a photographic tour of industrial areas on the south side of Santa Fe. The third is environmental racism and environmental justice. And the fourth is independence of the Environmental Improvement Board from New Mexico Environment Department. Captain G.M. Gilbert, a U.S. Army psychologist, was assigned to watch the defendants at the Nuremberg trials from 1945 to 1949. At the conclusion of the trials, he wrote, quote, "In my work with the defendants, I was searching for the nature of evil, and I now think I have come close to defining it: a lack of empathy. It's the one characteristic that connects all the defendants, a genuine incapacity to feel with their fellow men. Evil, I think, is the absence of empathy." Unquote. By taking a decision to expose low-income people of color to serious known health risks, it is my view that this fits Captain Gilbert's definition of evil as a lack of empathy. I cannot imagine that it would be possible to knowingly expose people to harmful pollution while also considering their lives of equal value to my own and that of others who I care about. Let me be clear. Associated Asphalt and Materials LLC initially operated in Santa Fe at a time when few people lived in the area where their two current asphalt plants are located. In the meantime, the South Side has continued and continues to grow at unprecedented rates. It is also my understanding that the New Mexico Environment Department does not monitor AAM's emissions at either plant, and that AAM has not filed emissions reports with the New Mexico Environment Department for 20 years. This being the case, residents may reasonably assume that this same situation would exist with the expanded asphalt plant that AAM proposes to build in the near future. Topic number 2, photographic tour of industrial areas on the south side of Santa Fe. I have documented a small portion of the new and existing neighborhoods in close proximity to the two AAM plants, and have taken 72 photos of the industrial commercial areas west of Route 599, running north and south of Airport Road. These photos are posted on Sync, and a link has been provided in my written comments submitted to the EIB for the purposes of this hearing. I reference my email of February 17th, 2022, subject first set of comments. A partial list of current industrial operations is Santa Fe Regional Airport, Santa Fe Wastewater Treatment Plant, Hanstein Oil Company, Concrete Pumping, Roadrunner Ready Mix, CBD, Subsurface Contracting, Santa Fe Classic Rock, and Santa Fe Concrete. And I do emphasize this is only a partial list. Third topic, environmental racism and environmental justice. Addressed in my second set of comments submitted to EIB on February 19th, 2022. I provided examples of other US cities and states, namely Newark, New Jersey, and the state of New Jersey, and Los Angeles, California, both of which are currently addressing the issue of environmental justice. And so I refer to those comments since I can't go into detail in my oral presentation today. In my email and third set of written comments of February 21st, I discuss New Mexico Environment Department's motion to disallow community and its technical witness, Michael Schneider, to include cumulative impacts of pollution and environmental justice in his testimony, and to prohibit community's non-technical witness, Miguel Acosta Munoz, from testifying about EarthCare's interest in this matter. And fourthly, independence of the Environmental Improvement Board from the New Mexico Environment Department. I believe, if I understand correctly, that the legislature's intention in creating the Environmental Improvement Board was to create an independent body rather than a rubber stamp for decisions rendered by the New Mexico Environment Department. Firstly, I witnessed Mr. Christopher Vigil of New Mexico Environment Department attempt to what I would describe as strong arm the Environmental Improvement Board into denying our community this hearing, which we are thankful that the Environmental Improvement Board granted in spite of clear pressure not to. The second instance took the form of the above referenced motion to prevent one technical witness for the community, Mike Schneider, from speaking about cumulative impacts of pollution and environmental justice, which I consider central to the entire purpose of our work to prevent harmful health effects in the places where we live and work and go to school and recreate. The motion also sought to prevent a non-technical witness, Miguel Acosta Munoz, co-director of EarthCare New Mexico, from presenting, quote, EarthCare's interest in this matter, unquote. In reading through EIB-248, Community Response to NMED Motion in Limine, one again becomes concerned about the perceived lack of separation between the New Mexico Environment Department and the Environmental Improvement Board. Thank you again for this opportunity to speak. I appreciate it.
Thank you, Ms. Marian Yellow. Are there any questions from NMED of her? Hearing none, we'll ask if there are any.
No questions from the department.
Okay, thank you. Are there questions from other members of the public other than the board members? We're going to go to board members next. Other members of the public that have questions? Okay, hearing none, we'll go to questions from board members. Are there questions from any of the board members?
Good afternoon. I don't have any questions, but except to thank the public commentator.
Okay, hearing no further comment, board members, Ms. Marianella will excuse you and thank you for your presentation. It was very well organized and thoughtful, and those kinds of presentations are very much appreciated.
Thank you so much.
Okay. The next public testimony is from Franz Vogt. If he can be identified, we'll have him sworn in.
Could you spell your last name, sir? Is it V-O-G-T?
No, it's just like what happens in November every 4 years. Vote, V-O-T-E.
Thank you. Would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
With my wife, Linda Marianiello, I spent several hours on February 16th, just a few days ago, touring and photographing the areas west of 599, running north and south of Airport Road on Santa Fe's south side. At the conclusion of our tour, I was rather shaken by the magnitude of the pollution sources that currently exist there and operate within a mile or two of my own home in Tierra Contenta. The amount of truck traffic we witnessed during our tour was rather overwhelming, and we photographed a number of trucks to document this fact. These are included in our first set of written comments submitted to the EIB for the purposes of this hearing. I saw that residents on the front lines of AAM's asphalt plant pollution include Cottonwood and Riverside mobile home trailer parks, El Camino Real Academy, new apartment construction north of El Camino Real, which we understand is intended as housing for LANL employees. The amount of new construction going on currently on Santa Fe's south side is, in my view, entirely incompatible with the constantly expanding number of industrial facilities operating in the above-mentioned industrial commercial zone that we photographed. Further, Linda informed me that residents of Tierra Contenta who have recently purchased homes near us were not informed of the asphalt plant issue under consideration here, nor were they informed about all of the current and future sources of pollution of their air and water. They were aware of the proximity to the Santa Fe Regional Airport, but were not informed about the many other polluters just across 599 from their homes. I told Linda that had we known what was planned for the south side of Santa Fe in terms of these polluting industries, we would never have moved here some 12 and a half years ago. Neighbors we spoke with expressed similar feelings and were angry that the realtors and sellers did not disclose this information to buyers. Finally, I believe that approving the air quality permit for Associated Asphalt and Materials without consideration for the cumulative effects of pollution from all of the sources I've mentioned, and without regard for Santa Feans who are largely low-income persons of color, is morally wrong and unacceptable. And so I ask you to reverse NMED's decision to approve the air quality permit for Associated Asphalt and Materials, because it unjustly favors business over the health and lives of Southside Santa Fean residents. Thank you.
Thank you, Mr. Vogt. Are there questions from NMED of this witness?
No questions from the department. Thank you.
Okay. Are there questions from members of the public? Hearing none, are there questions from board members?
Mr. Hearing Officer, I don't have any questions. Thank you for the testimony.
Okay, hearing no other board members indicating they would like to ask questions, Mr. Vogt, you are excused. Thank you for your testimony. The next person is Catherine Shera. Let's have Ms. Shera sworn, please.
Ms. Shera, would you spell your last name, please?
Yes, it's Shira. S is in Sam, H is in Henry, E, R, A is in Apple.
Would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
Good afternoon. My name is Catherine Shira, and I'm a resident of Santa Fe. I do not myself live in a neighborhood of Santa Fe that will most feel the effects of the industrial activities under consideration today. However, I believe this is an issue of serious concern to many engaged residents throughout our city and across the state of New Mexico. Some years ago, when Associated Asphalt began operations on the south side of Santa Fe, the plants it constructed might legitimately have been regarded as being located on the periphery of the city, at a safe distance from populous areas. Since that time, however, new homes, schools, and services have sprung up in the immediate vicinity of the company's operations, and nearby neighborhoods have become some of the most densely populated in the growing city of Santa Fe. Despite these significant changes in population distribution within the city, Associated Asphalt now seeks to consolidate its activities at a site not far from its current operations. Rather than selecting a new site at a safe distance from population centers, the company seeks a permit in the same location that many members of our community, mostly low-income families and people of color, now live, work, attend school, and call home. NMED is charged with the responsibility of protecting air and environmental quality for all New Mexicans. During last year's hearings on this issue, it became apparent that when the department considers new air quality permit applications, it has some latitude in specifying the methods that will be used in evaluating compliance with relevant standards to determine whether to approve a new permit for a particular operator and location. In the present case, a new asphalt plant that might someday be in operation 24 hours a day is proposed for a site in an area of the city that many vulnerable community members now call home. Given the hazards that the proposed asphalt plant poses to nearby residents and the serious environmental justice concerns involved, it is reasonable for the people to expect NMED, first, to object to the new plant siting, and second, to uphold the most stringent standards for air quality protection possible by employing the most conservative tools at the department's disposal. Setting the highest possible bar for air quality permitting and later compliance would reflect NMED's commitment to protecting our most vulnerable communities and also set a strong precedent for enforcement of New Mexico's air quality standards moving forward. Rather than using the strongest, most conservative method at its disposal, however, NMED seems to have made a choice in this case to lay the regulatory bar regrettably low. By using weak AP 42 factors to estimate emissions from associated asphalt's proposed new facility, for example, NMED has adopted a stance that places polluting industry over protection of vulnerable communities. In its subsequent response to the appeal petition, NMED continued to defend its selection of AP 42, flatly stating that the use of these factors is acceptable for the EPA and that these factors are employed in emissions calculations in at least 25% of the United States. What NMED has neglected to mention, however, is that some of the states cited as employing these factors are home to some of the most notorious air polluters in the nation, states where residents are witness to severe air quality degradation and where grave environmental injustice goes unchecked. In my view, this is not the sort of regulatory company the state of New Mexico should aspire to keep. It is time for NMED to side with the people, especially those residing in our most vulnerable communities, and to turn away from the industry-friendly permitting practices of the past. I urge the Environmental Improvement Board to reverse NMED's decision to grant permit 8585. Such an action would send a clear message to the department, set a bold precedent for future air quality permitting, and finally give strong encouragement to the development of more environmentally friendly methods of paving material production. In my view, NMED's mandate, in quote, to foster a healthy New Mexico for present and future generations requires nothing less. Thank you very much for your attention.
Thank you, Ms. Shira. Does the department have any questions of Ms. Shira?
The department has no questions. Thank you.
Okay. Do other members of the public have any questions for her? Okay, hearing none, we'll turn to board members. Are there board members that have questions of Ms. Shira?
Mr. Hearing Officer, I don't have any questions, and I'd just like to thank Ms. Shira for her testimony.
Okay, with that, Ms. Shira, you will be excused. And I've been informed that we have one more non-technical witness from the public. And I'd ask the host to please identify that person, and we'll have that person sworn in.
Yes, it is Domenica Nieto. If you would unmute and turn your camera on to be sworn in, please.
Hello.
Hello, would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
Thank you, hearing examiner, members of the board. My name is Domenica Nieto. I am an organizer with EarthCare, whom you heard from earlier today. As you heard, we've been working to inform our members and community of the proposed expansion and air quality permit sought by the Associated Asphalt and Materials, LLC, the Environmental Department hearing and decision, and this proceeding. Through door-to-door canvassing, neighborhood meetings, notices, and presentations in schools, we've been making sure to engage our community, raise the questions they ask, listen to their concerns, and make space for their voices in the process. I'm testifying today on behalf of more than 200 community members who submitted comments and testimonials into the record through a community input filing we made last night. These EarthCare members and residents of the area could not all be present for the hearing today, but shared their words of concern and support of the appeal for us to submit on their behalf. We hope that the board members will have a chance to read the submission and review the hundreds of comments from the impacted community. As part of the same public comment filing we made last night, we also included a community petition signed online and in person by close to 600 Santa Fe residents, the vast majority of whom live in the immediate impacted area. The petition reads, "We residents of the impacted neighborhoods are concerned about the negative impacts this large operation will have on air quality, noise and vehicle traffic on public roads, that it will degrade natural beauty and quality of life for residents, exacerbate public health issues, and threaten wildlife, historic structures, tourism, water quality, water conservation, and property values. We are concerned there are more polluting industries coming here, increasing the impact on our children's lungs. Homes, parks, and schools may become full of harmful dust, fumes, and residue. We are concerned about environmental racism. More and more polluting businesses are coming to the south side of Santa Fe. This is the most densely populated part of Santa Fe and is home to the greatest number of youth, low-income, and immigrant families. Our community is already the most impacted by COVID, and now we may see increased rates of asthma and other diseases in our children. We do not believe the current permit adequately addresses the human and environmental concerns or the current EPA standards. We are concerned that the current operations of the company may not be compliant with air quality standards and that sufficient monitoring and oversight do not exist to protect our community's health. Given the absence of this information, we are asking the EIB to reverse the permit approval because Associated Asphalt's operations have not been sufficiently monitored, compliance has not been proven based on appropriate standards, and the impacts to the community of the consolidated plant operation should be studied in the context of COVID-19 and cumulative air quality impacts in the area. We do not believe there was enough information nor data for the NMED to approve the Associated Asphalt Plant's permit request. We ask the Environmental Improvement Board to reverse the NMED's decision. Each signatory represents a household, family members, loved ones whose interests are at stake. That is a substantial number of people in our community that support the appeal and oppose the permit. When we filed last night, we included 596 petition signatures. Earlier today, I went to El Camino Real Academy and picked up signature sheets with an additional 42 signatures that were collected by sixth graders who are taking action to protect the health of their neighborhood and their future. The community is clearly asking for the reversal of the NMED decision and reconsideration based on more stringent air quality standards and more appropriate data. Thank you.
Thank you, Ms. Nieto. Does the department have any questions of Ms. Nieto?
The department has no questions. Thank you.
Are there other members of the public that have questions of Ms. Nieto? Hearing none, do any of the board members have any questions of Ms. Nieto?
Mr. Hearing Officer, I don't have any questions. Thank you for your testimony, though.
Okay, Ms. Nieto, hearing no more questions, or persons who want to ask questions, you're excused. Thank you for your testimony. Okay, we are at that point of returning to the technical part of the hearing. We were on cross-examination of Dr. Sahu by the department. So let's return to that now. Mr. Vigil, you may proceed.
Sorry, Dr. Sahu, can you hear me? I was muted. I apologize.
I can hear you now. Can you hear me as well?
Yes, I can. Thank you. Ms. Jones, can I have the share capability again, please?
Yes, you may. Let me find you on my screen here.
Thank you.
There you go.
Okay, so this is where we left off, Dr. Sahu. This is Title 20 of the Environmental Protection Construction Permits, Air Quality Construction Permits. You may not have seen this document before, but do you agree that that's what this document purports to be?
It's a 40-page document, but this is the beginning of that, is what I see.
Yes, thank you. Thank you very much.
Excuse me, Mr. Vigil, is this an exhibit?
No, this is not an exhibit. This is the actual, these are the actual rules. I didn't think I had to enter them as an exhibit. These are the governing rules of this proceeding.
Okay. Thank you for that clarification. Proceed.
Thank you. And I'm sorry for not stating that beforehand.
No.
Dr. Sahu, could you read the definition of ambient air here in yellow? And that's all we'll do with this document.
Sure. Ambient air means the outdoor atmosphere, but does not include the area entirely within the boundaries of the industrial or manufacturing property within which the air contaminants are or may be emitted, and public access is restricted within such boundaries.
And in your opinion, based on having read this, does this definition of ambient air seem similar to the federal definition of ambient air?
I think they are similar in the intent, but obviously there are specific terms of art being used in these different definitions.
Okay, thank you. Thank you so much. Okay, and this is NMED. This is actually a document this is administrative record number 7, and we are at Bates number 00493. But I will take us to the beginning of this document just to take a look at that. Dr. Sahu, could you read the title of this document?
Sure, it's the New Mexico Air Quality Bureau Air Dispersion Modeling Guidelines, revised on October 26th, 2020.
Thank you. Get to where I want to be here. Okay, and Dr. Sahu, we're back here. This is just for the folks who are following along, AR number 7 from the administrative record at Bates number NMED 000493. Dr. Sahu, could you read the definition of ambient air here highlighted in yellow from the New Mexico modeling guidelines?
Sure. Ambient air is defined as any location at or beyond the fence line of the property, of the facility. The fence line must restrict public access by a continuous physical barrier, such as a fence or a wall. If plant property is accessible to the public, or if any residence is located within the restricted area, receptors should be located on property. There's a footnote citation. Public access is interpreted to include housing, schools, hospitals, and similar areas that are frequented by family members of employees, but the remainder of the restricted area is excluded from public access if such family members do not have access to excluded areas. For example, receptors should not or would not be placed in dormitories on military bases, but would be placed in family housing areas.
Thank you. And based on, we've looked at 3 different definitions here and some EPA guidance. Based on what you see here, is it your opinion that the New Mexico modeling guidelines definition of ambient air is somewhat more specific than the federal definition?
It appears to be, at least insofar as it provides a little more color on the public access portion of that definition.
And sticking with the public access portion, did you notice that a fence requirement is still in the New Mexico definition of ambient air? So in other words, New Mexico appears to retain the 1980 definition of ambient air. Is that correct?
Well, it does say such as, so I don't know how to interpret that from a legal sense. From a plain English standpoint, it certainly recognizes that that barrier could be a fence or a wall.
Right, and it's good, but it has to be a continuous physical barrier, correct?
That is correct.
So it can't just be some cameras, correct?
This would seem to exclude a camera.
Okay, I won't belabor that point, but just one more point on this, and then we'll go to something else. So, is it fair to say that the New Mexico modeling guidelines definition of ambient air on its face, or just the words themselves, are more restrictive with regard to its definition of public access and more restrictive than the federal definitions?
Well, the federal definition is quite short. So I can't say that the federal definition would not necessarily encompass the New Mexico definition. This particular modeling guideline definition, let me put it that way, that it certainly has a little more color. As I said, it does seem to allow for public access, for example, to parts of a facility, a manufacturing facility, such as family members, that are spelled out in a little more detail here.
I see. Thank you. And now let's just think about the federal guidance we spoke. Would it be your opinion, just based on this, that this definition, the New Mexico modeling guidelines definition, is somewhat less permissive than EPA guidance?
I mean, again, because they all rest on interpretation of certain phrases in relation to the actual facts, it is hard for me to say more or less permissive. All I'm saying is this particular definition in the modeling guidelines seem to go further on the public access portion by giving examples of what would not be ambient air, because they would allow public access, such as by family members of employees, for example, into a facility.
I see. Okay, thank you. Thank you. Okay, I want to circle back to one last document. Well, second to the last document. I want to circle back to New Mexico EIB Exhibit 25. This is the October 17, 1989 EPA guidance from Robert Bauman to Gerald Fontenot. And you read this into the record before. Now, I just want to walk through this a little bit. Under this particular guidance, is it your understanding that this guidance is seeking some input on how Mitsubishi Industries should be counting background sources, in particular background plants for a particular permitting process?
Yeah, I did read this into the record, as you highlighted here. I have not studied this in its entirety or the context that goes into it. It seems to talk about a few different things. As you said, it talks about something called a background source. We don't usually use that type of phrasing currently. I mean, a background is used in a similar different way in modeling, but it certainly talks about contribution of a background source. My interpretation of this is they mean sources other than Mitsubishi, other than the source that is at sort of at issue here. But that's all I'm taking from that is what they mean by background.
Yes, yes. And in this case, do you agree that the background sources are two hypothetical plants, plants B and C?
Yeah, that seems to be the example here, how they're referred to as.
Okay. And this memo, under this hypothetical guidance scenario, it assumes that Mitsubishi Industries and the background plant B and background plant C are modeled, and the total concentrations of emissions are estimated for all three plants at this point. Is that correct?
That's what number 2 seems to indicate.
Okay, and let's move to number 3. Number three, do you agree that number 3 says that the non-ambient air in plant B's property may be subtracted from the total concentrations of Mitsubishi and the 2 background plants?
Well, let me read it just one more time, if you would indulge me.
Okay, thank you.
Yeah, what this is saying to me is if you've modeled plant B is impacts and only plant B's impacts, you may remove that from the non-ambient portion of plant B's air.
Yes, thank you so much. Well, no, that's fine. Thank you very much. Let's see here. Let me move on to the appeal petition, and this will be the last document. You've been very generous, and everyone's been very patient. I do want to ask you a couple questions about the petition. You're here as an expert witness, and you are the witness that's testifying to this particular claim in this proceeding. And what's here in this document is essentially what's on the table with regard to this issue on appeal. So can you read that first sentence? There's three colors there because there's three different sentences I want to go through. Can you read the first sentence there, please?
You mean the one in orange there?
Yes, yeah, the one in orange. I'm sorry, yes.
Okay. Petitioners raised concerns about the Bureau's definition of ambient air because the Bureau was inappropriately expanding that definition to allow the applicant to exclude National Ambient Air Quality Standards NAAQS exceedances found at nearby properties.
Thank you. Now, we just looked at the EPA guidance from 1989. Isn't it true that that document allows exactly that? That allows the applicant to exclude NAAQS exceedances found within their own property?
Well, it's a little difficult to say without the facts. As we just discussed in all of the guidance, the issue of how general public or public access is being defined is part and parcel of that definition. In other words, what is ambient air and what is non-ambient air depends on that effective barrier that is in the federal definition, and the effectiveness of any barrier coupled with the modeling guidance we just saw from New Mexico, which says members of the families, for example, of employees could come into a plant and that would be ambient air. Those factual issues matter. So it is not simply a matter of, how you're applying it, but those facts that pertain to barrier, effectiveness, general public, and therefore how those enter into what is ambient and what is non-ambient are part of that definition of how you apply it. And that's not clear that that's in the record that I've seen.
Thank you very much. Thank you. And going back to your comment on the effective barrier, we spoke a minute ago in a comparison with the federal definition supplemented with federal guidance on the issue of what a barrier is. And we compared that to the EIB definition of ambient air and the New Mexico Environment Department's modeling guidance. And it was your opinion that I think was your opinion that on the issue of the effective barrier, that the New Mexico Environment Department was more detailed, I think more color is what you used, and somewhat more restrictive. Do you still have that opinion?
I do, and let me clarify because I don't want to leave a misunderstanding. Let's say you have a fence and it is a continuous fence, and that is in the New Mexico modeling guidance, the continuous barrier fence being an example of that. But then let's say you have a gate. Obviously, any facility will have breaks in that continuous fence for access of a variety of different things. The access that is afforded by a gate, let's say, allows family members, visitors, other types of persons who don't work at that facility. Let's say they allow those folks to come right up to the front door of that facility for whatever reason. They can't go into the plant beyond that point, but they can come crossing that fence line, going through that gate, and coming all the way to the different portions of the plant. Then the New Mexico definition seems to allow and say explicitly that that is no longer non-ambient air. I mean, that part of it is still publicly accessible, giving those examples. And then I would
I
also
see.
add that there's the latest EPA guidance, the memo from 2019 that seems to have come out, adding further guidance and color even from EPA beyond the 1989 guidance.
Yes, yes. And that coloring was more permissive somewhat, correct?
Just the portions you had me read, but it did not detract, as I said clearly, from the basic idea which has been true about the effectiveness of all this. The goal of restricting public access, I don't think it became more permissive in that regard.
Okay, thank you very much. Okay, and I'd like you to read the last sentence. We'll skip the green sentence. It's a kind of a filler sentence, in my opinion. Could you read the final orange sentence in item A?
Sure. The department, in approving permit number 8585, has expanded that definition to allow for exclusions at sources not in the applicant's control, in direct contradiction to EPA's longstanding definition.
And I'm going to go ahead now, Dr. Sahu, I think maybe the spirit of their question, I think I understand. I'm not sure who drafted this question. I think it seems to be a typographical error. I'm not going to get you to weigh in, but it seems to me that what they're saying is not the longstanding definition, but longstanding guidance. I'm not sure. I mean, we read the definition, and there's nothing in the definition that says, well, let me ask you, is there anything in the definition that bears on in the federal definition, not the federal guidance, but the federal definition that would prohibit the department in approving a permit that excludes contributions from background plants?
Well, I'm trying to remember the federal definition which you showed me a few hours ago, and as we both agreed, the federal definition doesn't contemplate the mechanics of how you'd implement it. For example, it doesn't, I believe, contemplate exclusions of anything. It simply states that you are allowed to consider as not ambient air portions of your own plant that to which general public access is effectively restricted. And I don't think the federal definition, frankly, by itself gets into this question of the plant in question, neighboring plants, each plant's ambient air, each plant's effective barriers, each plant's ability to restrict public access. I don't think the federal definition gets into any of that.
Okay, thank you very much. And one last question, I think. So this says the department expanded the definition to allow for exclusions. Aren't exclusions allowed under the guidance that we just looked at? In other words, background plants, in the Mitsubishi example, background plants B, which was not under the control of Mitsubishi Industries, was under EPA guidance permissible to remove from the total concentrations. Isn't that correct?
In that guidance, that is what EPA may have meant. I will just say, and I think you're well aware of this, that EPA has produced lots of different guidance over the years, and sometimes the guidance has evolved, just like we saw with the 2019 guidance. EPA felt that it needed to further clarify whether it is, in whatever way, guidance, especially guidance that is old. What I did not see in this particular instance is if this was a matter of such import that there was any request to Region 6 to go back with these particular facts and get that interpretation, even if it was the reaffirmation of the 1980 interpretation or something else. And further, as I have said in my report, honestly, given the much bigger problems with emissions, this entire sort of effort that has been expended on, trying to get under the wire, so to speak, of the National Ambient Air Quality Standards by making adjustments and excluding and including certain portions is really inappropriate.
So in other words, what you're saying is that if a plant or a prospective entity wants to construct some sort of facility, that you think it's impermissible for them to adjust the calculations that are afforded to them under the law in a lawful manner. And when the Environment Department approves a lawfully developed application and permit, issues a permit, all under the law, under the standards, that based on what you're saying, it could still be construed as regulatory malpractice. Is that correct?
Well, we're back to that. Okay. No, I'm saying that there is a difference between standard and practice, and you're conflating that. The standard is that you would have to do your emission calculations using a hierarchy from most accurate data to the least accurate data. That standard has been there in AP 42. It's been there in every single EPA guidance going back to the beginning of that guidance. You use site-specific emissions, you use testing, you use those things, and you go back down the list, you go back to AP 42, and even that, you go back down to, the worst factors are the sort of the E-rated factors or the D-rated factors. That guidance, that standard rather, is not new. The standard has been there for a long, long time. And the practice, you've been trying to basically suggest that other people, Western United States, and I've said every state, just because other people have used AP 42 in practice, therefore that has become some kind of a standard. And that is wrong. If that was the case, then EPA would not have had the need to put out in 2019 the alert, which cautioned against misuse of that widespread application of that practice. EPA knew that was going on. EPA didn't send a letter to a particular agency or a consulting firm or an air quality, or a particular source saying, oh, look, you're doing something that is different. They said they put out a nationwide alert being very specific. The alert has the standards that say you shall use this hierarchy. And so the fact that those emission estimates that have been used in this particular instance have been so underestimated, all I'm saying is fix that problem first, then look at the impacts, and then see how to apply these fact-specific ambient air adjustments to the extent they're warranted.
One absolute last question. Now, the AP 42 enforcement document, which you just referenced, that is against abuse of the use of AP 42. That is not a prohibition on the use of AP 42, correct?
Right. EPA is putting people on alert that they may be getting themselves into trouble. EPA does say that in the purpose. EPA obviously is specifically cautioning about how that is being used or is being used in the permitting and compliance context. And so, yes, it is that. It is EPA is alerting everybody that this has been going on, and here's the problems with that.
Thank you, Dr. Sahu. You've been very patient. I appreciate it. I have no further questions on cross for the doctor. Thank you.
Thank you, Councilor.
I think you're muted, Mr. Hearing Officer.
Sorry about that. I was stating that I was moving to questions of Dr. Sahu from members of the public. And I asked if there were questions from members of the public. And I didn't hear any, and I'm going to wait for a minute to see if I hear any now. And I don't. So I'm going to move to questions from board members. Are there board members who have questions for Dr. Sahu? Yes, we have Ms. Garcia.
Yes, can you hear me okay?
I can hear you, yes.
Okay, thank you very much. Thank you, Mr. Hearing Officer, and thank you for your testimony, Dr. Sahu. I have a couple of questions regarding what we were just talking about, in fact. you brought up the EPA alert regarding the use of AP 42. And I understand that the EPA alert is basically saying there are instances where it can be misused, and they're alerting regulatory agencies about that. They expressly indicated that AP 42 emission factors should not be used to calculate PTE emissions. Is that correct?
Yes, that was one part of their concern, is to not use them because they're average factors, as we talked about, and a PTE is an upper bound end of the emission estimate. So the two are incompatible. That's what they were pointing out.
So I just want to be super clear on this point, that they said they should not be used to calculate PTE emissions. And is that exactly what NMED did, contrary to the alert?
NMED, and like all permit applicants, the applicant itself was under an obligation to estimate maximum emissions. In other words, that's typically what is done. You look at a source, you try to estimate the actual, but you also, more importantly, try to estimate the maximum, because that's what you're really asking for in a permit. That's where you use production rates that are maximum, whether or not you use that production rate. That's why you use 8,760 hours per year as the total number of hours that are available in which to estimate emissions. Even though we all know you could run a few hours less, most sources do. So all applications tend to estimate the maximum or the potential to emit estimate, both on a short term, in this particular case, on a tons per year, which is the annual, as well as on a pounds per hour basis. That's what they've done. And so using the average emission factors from AP 42 is incompatible with that.
Okay, thank you, sir. Another question I have is, you also stated that the associated asphalt used AP 42 and NMED approved factors that are rated C or lower. I'm not sure I quite understand that, but does EPA caution against using factor C or lower? I mean, is that a problem?
Yeah, no, that's a separate reason, and even equally problematic reason is, as I mentioned, AP 42 factors, EPA assigns these ratings, A, B, C, D, and E, 5 ratings, A being the highest, and then going down, and E being the lowest. And what I have shown in my report is example after example where the applicant's calculations and NMED's acceptance of that, because they don't question that, uses factors that are at the bottom of that ranking, E's in many cases, and D's in a few cases, and occasionally C's. So I've given many examples where the factors that are used, setting aside that they were average and therefore inappropriate based on the first reason you asked, is they've used factors that are really poorly rated. EPA puts them out there because it has that data, but EPA is almost completely red flagging that by giving them these D and E ratings. And those factors with those ratings have been used throughout in this particular permitting project.
Okay. Okay, so it's not prohibited by EPA. It's just a matter of realizing that the lower you go, the less reliable.
The less reliable, exactly. And why I'm cautioning is, if you recall, and that's my report begins from that, is the overall conclusion by the department is that they are meeting the air quality standards, even though it's by a whisker. Okay, and I mean literally. I mean, if the standard is, they are at something like 97% of the standard, let's say, for particulate matter. And that is no margin, especially when your emission calculations include, as you said, these unreliable factors that are E-rated. You can't use that. There is no way the process self-corrects for that kind of inaccuracy and says, even though you use these E-rated factors, you can conclude that you're barely under the standard based on your model.
Thank you. And one last question that relates to the reliability of the data used. And I probably need to ask the hearing officer if I can ask this question, because it may not be exactly related to direct testimony by Dr. Sahu, but it does relate to the use of background data, which they did talk about here recently. So let me ask it, and you can let me know if it's a problem. My question is, I noted that in the petitioner's other witness report, Michael Schneider's report, he noted that the monitor at the Santa Fe airport was not used, rather the Runnels building monitor was used. And are you familiar with that report?
I am, and please ask the question, because I think I know how I'm going to respond to it. But why don't you finish your question? I am familiar with the report.
Okay, so relating to reliability of data, I guess my question is, Mr. Schneider brought up the fact that they didn't use closer monitoring data, which would be at the airport. Do you see that as a problem with this analysis of the application?
Sure. So let me answer this one. I'm trying to be very upfront. So I have focused on the sources on emissions and the impacts that their model has given them, rather. In other words, AAM's own sources, many different sources, from plant 5, from plant 2, from their different screening operations, and what those emissions and what those impacts have been in the surrounding areas. Mr. Schneider talks about background, which you customarily add to that sources on impacts. And then the sum of those is what you compare against the standards. So I think it would only be fair for me to leave discussion to this particular question about the background to Mr. Schneider, because he's going to be before you on that. What I'm simply saying is, even if there was not an issue on background, just the fact that the sources on emissions have been so poorly estimated and underestimated, their own impacts would have been many, many times higher. In other words, over and above even considerations of background, of which there are legitimate questions that I'm sure Mr. Schneider would come in and be able to better answer. Does that help you with?
Yes, that's helpful. Yes, thank you very much for answering my question, sir. That's all I have.
Thank you.
Are there any other questions from board members? Ms. Davis.
Thank you. And I just wanted to follow up. I have some of my own questions, but I wanted to follow up on one of Member Garcia's questions. I'm not sure I understood the answer completely. And I'm looking for more of a direct answer, but are you contending that, or are you saying that NMED, maybe I should rephrase this, I'm sorry. Did NMED use AP 42 to calculate the PTE?
Yes, I'm trying to be direct. The applicant calculated its emissions, NMED checked the calculations. NMED therefore used the same process and accepted the applicant's calculations, which used AP 42.
Now, is PET generally calculated on the emissions inventory?
Yeah, PTE in this case is potential to emit. So it's an emission calculation, whether it's on an hourly or an annual basis. Those are time dependent things, but yes, the idea that you're trying to estimate the highest emissions that you might produce, that's an emission inventory phase of the calculation. If I understood your question correctly.
So the emissions inventory, which I would assume is provided by the asphalt company, were those numbers derived from AP 42, or were those numbers derived from their own facility operations?
No, they were all derived using AP42. There was no testing. And that is one of my questions is they could have done their own testing from their own operations and used those to estimate their emissions. That is not what is done here. If you can look at the record, Good Place is their own application. There is also testimony, I think, by their consultant, and maybe that's I saw in the record. Yes, it relies in very, very large part on AP42 to estimate the asphalt plant's emissions. And in fact, uses, even within AP42, some of the lowest ranked emission factors to do those estimates.
Okay. And so the overall message that I think I'm getting from your testimony, and so please tell me if I'm understanding you correctly, is that your issue is not so much the use of AP40, that AP42 is used, but how it was used?
Correct. AP42, like I said, has other applications. You can use them for doing other things. Here, AP42 is being used for permitting. So, and when you do AP42 for permitting, and that is part of the how it was used, you cannot go blow by all these concerns about using average factors, using poorly rated factors. And therefore, it is how AP42's average values, regardless of their ratings, have been used in this permitting exercise. That is the point.
And just for my clarification on the AP42 as a document, is it specific to like, could you look at it and say we're using the section of AP42 that is specific to asphalt plants and so on?
Yeah, there are about 200 different sections of AP42 for a variety of different types of industries. There are sections for some, there's an asphalt plant section that deals with certain asphalt plant sources. There are also separate sections for, let's say, emissions from paved or unpaved roads that may apply in many different plants. And so if you have those in your plant, you could use that. So the AP42 document several different sections, about 4 or 5 or maybe even 6 sections have been relied upon, different pieces of it, if you will, from different sections to do the emission estimates for this overall permit. And I have provided examples from a variety of all of those sections showing that those emission factor ratings are very poor.
Okay, thank you. I appreciate you answering my questions, and I do not have any more. Thank you.
Thank you, board member.
Are there questions from other board members? Okay, hearing none. Mr. Jantz, do you have any redirect?
From what it, excuse me, Mr. Hearing Officer, members of the board. From what it sounds like, there may be some clarification needed about how the Environment Department misused AP42 standards, emissions factors. So I'd like to reiterate a couple of points with Dr. Sahu based on the commission's questions or the board's questions, as well as cross-examination. So, Dr. Sahu, I just want to make perfectly clear, AP42 standards generally are unreliable. Is that a fair statement for permitting purposes?
Correct. For permitting purposes, you have to be very careful about simply accepting those average factors and using them in permitting.
And within the AP42 standards, there's a rating system, is that right?
That is correct.
And so that adds another layer of uncertainty based on the rating system. Is that a fair understanding?
Yeah, and very large uncertainties, frankly, given that rating system, because EPA points out that even the best rated factors still have uncertainties. And of course, that becomes worse as you go down that rating scale.
So even with the A and B rated factors, there's at least a 50% chance that the actual emissions are going to be higher than the NACs. Is that fair to say?
Yeah, I mean, you said compared to the NACs. I mean, we use AP42 for the emission part of it. Of course, the NACs assessment will be when you put that into the model, but models are basically linear in terms of the impacts. You double the emissions, you typically get double the impacts for most pollutants. So AP42 in that sense, because they're using average factors, will be very up, at least 50%. That's what EPA says. But EPA has also done other analysis of uncertainty for A and B factors, where it has shown that even for A and B factors, the maximum factor which you should be using in permitting, or the 95th percentile factor which you should be using in permitting, can be 3, 4, 5, 6, 10 times higher than the average factor. So even the best factors can have much more than just a 50% difference between what should be used in permitting and what is used if you don't, consider that properly as the average factor.
And when you're talking about the EPA's evaluation of those A and B factors, you're referring to the 2007 EPA uncertainty emissions factor uncertainty assessment. Is that right?
Yeah, EPA did that around 2007. EPA, a contractor at EPA was asked to look at even the A and B factors, rated factors. They only looked at mostly A actually, which is the highest rated factor. And they looked at, well, here we have averages, and they picked several different sections of AP42 as board member previously asked about. And they said, even for those highest A rated factors, what is the ratio of the 95th percentile in that distribution from which you got that average to that average? In other words, what is the ratio of the high end estimate, which you should be using in permitting, divided by the average? And they found, even for the best rated factors that they looked at, that ratio varied 3 times, 4 times, 5 times, all the way up to 13 times, if memory serves, for certain HAP emissions, for certain air toxic emissions. So that tells you how inappropriate it is and how much it would be underestimating those high-end estimates that should go into permitting, should go into modeling, when you're simply using the average factors.
So let me make sure that I understand this and hopefully put it into lay terms that everybody can understand. Are you saying, Dr. Sahu, that even with A-rated factors, the EPA found that they may have underestimated actual emissions by 5 to 13 times?
Not actual emissions. They may have underestimated the emissions that should be used in permitting, which is these 95 percentile emissions. They would have underestimated that by many multiples. Exactly.
Okay. Thank you, Dr. Sahu. That's all I have.
Okay, Dr. Sahu, I believe we're at that point in the proceeding where your direct testimony has ended. Thank you for your testimony. And we will now turn to the petitioner's next witness.
Thank you, Mr. Hearing Officer. We would call Dr. James Clark.
We have Dr. Clark, or Mr. Clark sworn.
Doctor, would you raise your right hand, please? Do you
Yes.
swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
All right. Hi, Dr. Clark. How are you?
Nervous?
It's already been a long day. Yeah. Well, this won't be bad. But just to start, could you briefly introduce yourself to the board and the members of the public that are here today?
Sure. I am an environmental scientist who specializes in air modeling, multimedia modeling, toxicology, which is the study of poisons on individuals. And in particular, a focus of mine has been on quantitative risk assessment, which is the application of toxicology to come up with a probability that an adverse health outcome will occur. And this can be done for a community, it can be done for an individual. The risk assessment process is frequently used by regulatory agencies, and it's well understood as, in addition to standards, a way to go ahead and quantify potential problems that you might have in the environment. I've been doing that for the last 32 years in Los Angeles. I originally came out to Los Angeles to do air pollution research, where I was involved at that other university in Los Angeles, not the one that Dr. Sahu went to, UCLA, that we were looking at a long-term study of the impacts of the air pollutants in our area, specifically nitrous oxides, oxides of sulfur, and particulate matter, and ozone. So we are the smog capital, and we have had a long history of health impacts that have been well documented.
Thank you, Dr. Clark. And I'm sorry, just backing up real quick. Could you just say your full name for the record?
Yes, my name is James Joseph Justin Clark.
Thank you. And so, Dr. Clark, in this work you're doing with air modeling, where are you currently employed?
I have my own company, Clark and Associates, and I do a variety of work for clients. My clients include regulatory agencies in the US, outside the US, industrial clients. I do work with advocacy groups. I do work for attorneys. I've done work for industries. In a past life, I was employed by another company where I was, in addition to doing all the toxicology for them and assisting in the air modeling or directing the air modeling for permitting, I was a remediation manager for environmental sites that had sensitive populations. In this one particular case, it was a school that was built over a brownfield site, something that had been impacted. So I am a generalist who's got a lot of experience related to how to move pollutants from point A to point B, to determine what the concentration is going to be, and also to come up with an idea of whether that is a significant impact or not.
Dr. Clark, and can you talk just a little bit more about sort of your education and experience related particularly to air dispersion modeling?
Yes. So my bachelor's is in biophysical and biochemical sciences, and I have minors in chemistry and psychology from the University of Houston. I came out to Los Angeles to do air pollution work, where I worked for the Department of Medicine in the pulmonary division. I worked for the head of the pulmonary division, looking at the effects of oxidative chemicals on the lungs. So what does smog do to, I worked with cells, I've worked with rats and mice and all the way up to humans. And after that, I attended the UCLA School of Public Health, where I got a master's and doctorate in environmental health sciences with an emphasis on air pollution. And within that, my specialties were the toxic effects and dispersion modeling.
Thank you, Dr. Clark. And in all that work, is it safe to say that you have a pretty good familiarity with the Clean Air Act and EPA guidance surrounding air dispersion modeling?
Yes.
And have you been qualified as an expert witness before for air dispersion modeling?
I have been. I have been on federal cases and state cases. Most recently, I was doing a dispersion model of a refinery here in Los Angeles that was being used, the results of which were being used for class certification related to the impacts of those emissions on the community surrounding the plant.
And you, in preparation for today's hearing, also wrote a report. It's labeled Community EIB Exhibit 4 and has accompanying attachments.
That is correct.
At this point, Mr. Hearing Officer, I'd like to move to qualify Dr. Clark as an expert witness in air dispersion modeling.
Motion is granted.
All right, Dr. Clark, so let's talk a little bit about your report and what you did. So looking at your report, it looks like the first thing you did was review the New Mexico Environment Department's air dispersion modeling, or the applicant's air dispersion modeling reviewed by the department. Is that right?
That is correct. So the question that comes to mind when reviewing a model is, what were the steps that the modeler went through? What were the input values that the modeler used? How valid are they? How much uncertainty is in those values? Dr. Sahu was talking a lot about the issue of AP42 and the uncertainty that's associated with certain values along the way. For a model, what you are doing is taking the source terms. How much is there going to be emitted? And it's assumed that it's emitted at a certain rate. So the applicant's going to be releasing X number of tons of particulate matter per hour over the course of the year. In their model, a lot of this was being limited to nighttime emissions. The importance on that is that has an effect on the ceiling level of the air column. As we go along, as that ceiling height changes, that can have an impact on the ground level concentration that we're monitoring along the way. There's some very technical issues that are related to all of this, but it's incumbent upon the reviewer to look at the source terms and identify where the uncertainty could be. If a particular critical value, let's say it is the major source of particulate matter coming off the site, is using an AP42 value that has a low certainty, it's got that E rating, it's got a D rating along the way, you have to keep in mind that there's a plus or minus that will go with it. If you're saying it's going to be X number of tons, the reality of it is that it could be X tons plus some percentage along the way, depending on how it's maintained and operated. So that should be kept in the back of the reviewer's mind along the way. And if you stack these uncertainties up, you create an issue for yourself down the way. So if you're thinking, I'm going to push this facility to the limit, it would be an example of, you set your cruise control at 69 miles an hour and you're driving down the freeway and you happen to go down a hill. You say it's set at 69, but the cop pulls you over and says you're doing 73 miles an hour. You weren't putting enough uncertainty into your analysis to say this is going to be health protective along the way. So that was the first step in what was going in my analysis, was to look at the uncertainty values that are associated with their analysis.
Okay, and so just to clarify, the uncertainty values, are you talking about related to what's put into the model? Those things have uncertainty values?
Correct. So the assumption, the math that is done by the applicant says, I'm going to put through X amount of material through my system, and I should get Y amount of emissions on the backside. It all assumes a static, a fixed amount coming out. And the reality of it is there will be variable amounts coming out depending on how they operated, how new the system is, what the emission controls are in place along the way. So I'm bringing this up because as you get closer to that total emission level, there is less cushion in the model on the outputs for what's going on. And you could create unwittingly create a situation where you are going to exceed an X.
Okay. So, and just sort of taking a step back so that we can make sure everyone is sort of on the same page with what this modeling really looks like. There are inputs that go into the model on top of just emissions, right? That impact the output. So can you talk a little bit about what those are? You mentioned them in your report, I know.
Okay, how much time do we got? This will be fun. Sorry. So what what happens is that you are trying to use math to describe time and space for the concentrations that the community will be affected by. So one of the first steps is to identify all the sources. That was done in their analysis, to quantify how much is coming out. Then you put it into the model and you spread it throughout the community. If you set the model up, and it's called the model domain. That is, imagine a sheet of paper that you're just spilling all the material on top of. That's the environment in Santa Fe, New Mexico. We're spilling this all out there. And you're going to come up with some hourly concentration, some daily concentration, some annual concentration along the way. Those are the outputs that were given by the model. So in this modeling exercise, you have to have certainty about what the sources are, where they're located, what your modeling domain is, and then very importantly, what is the weather like? Because the one value that changes that is beyond the control of the permittees is what happens in the environment. How strong is the wind? How high is the inversion layer that might be created along the way? Is there precipitation? All of that data gets incorporated into the modeling output. So having the most robust set of meteorological inputs along with the most robust set of source terms gives you more certainty. And in that, then you can then make a comparison against the standards. And let's keep in mind what a standard is. The standard was created by EPA and handed down to the states to say, this is a concentration that we find if you exceed, you're going to either cause problems to the environment or to the individuals who live within the environment. If you look back at just one standard, if we look at the particulate matter, which is 2.5 microns, it's a very small dust particle. And the question is, why are we concerned about this? As that particle gets breathed in, you get a response from the body along the way. So in 1997, the threshold value for particulate matter in 2.5, I believe it was 97, it's either 97 or 2006. I apologize if I've got the dates wrong. The annual, the 24-hour average was 65 micrograms per meter cubed. That value a few years later was lowered to 50 micrograms per meter cubed. And now it's been lowered again to 35 micrograms per meter cubed. So what the regulators have recognized is that this is a significant air pollutant. Exposure to this can cause problems, and the standard only gets lower as you go along in time.
So, Dr. Clark, looking at your report, you looked at what NMED approved, and you seem to pay most attention to receptor grid spacing and MET data. So I want to first talk about receptors. Can you just tell everybody what receptors are?
Okay, in the simplest terms, a receptor is a geographic location. But the way that it should be thought of is it could be an individual, it could be part of the environment, it could be a school, it could be a house, it could be a bunch of different things. But for the standards, or not the standards, for the modeling practice, you create a grid of receptors. You've got graph paper in your mind, and at the intersection of each one of those locations, there could be somebody there, or there could be some significant environmental resource that is located there. So it's a way to identify the field that you're going to talk about, and you can either place somebody there or not place somebody there. This becomes important because if you space the receptors far apart, if you're dealing with the idea of receptors that are a kilometer apart, 1,000 meters apart, the definition that you will have with that when you draw the graphs afterwards is very crude compared to when you put the spacings closer together. So as the spacings get closer, the distance between each one of those points gets smaller and smaller, you can refine the actual contours of impact along the way. EPA and most regulatory agencies come out with an idea of start with a coarse grid, start big, and then start bringing it in when you've identified the areas that have particular concerns for you. Maybe you've got a school there, maybe you've got a housing development there. You want to bring the grid in as far as possible, as close as possible, so that you can really define what the issues are going to be. Now, the output, which constitutes what the concentration is at each one of those points, is calculated within the model. The model doesn't add anything to it. It doesn't interpret the data in any particular way. It just says, what's the distance in this line and how far out to a different space is this? And which way is the wind blowing along the way? So it can be very precise as to what a concentration will be. It really depends on what the input values are along the way. So it's a long answer of saying, I can estimate what the concentration is going to be. I shouldn't say estimate, I can calculate what the concentration will be given the assumptions that we know about the site.
Okay, thank you, Dr. Clark. And then another input, as you mentioned, is meteorological data, right?
Correct. So the meteorological data is important as a consideration of where the wind is blowing, how it is blowing, how much wind is, or how much rain is going through. There's a number of factors, how much solar radiation is going on, which stirs the air up, which causes different events within the air column along the way. So it's incumbent on the air modeler to not use one particular year. You can't, the guidance does allow you to, there's a range of values. The gold standard is to use 5 years of meteorological data that has been vetted and has enough representative identification for an area. The next level would be predictive modeling. So it incorporates all of the variables that you typically see within the area. And that's usually a 3-year value. And then they talk about site-specific value, meteorological data. You can use 1 year of that if this is really meant for a location that's far away from a monitored site that has continuous data along the way. So the use of site-specific is really kind of limited, and you have to still meet the same requirements that EPA would have for the other meteorological data. Is it representative? Is it continuous? Do we have the specific values which are important in the air model represented well in this?
Thank you, Dr. Clark. And then the other sort of input into the model is basically the facilities emissions coupled with this background concentration data, right? All of those impact the model.
Correct. So in the model, you locate where the sources are. You've got the boundaries of the facilities, and normally for under EPA rubric, what you'd want to do is you cite where your sources are going to be, and you create what's called a fence line boundary. And EPA recommends using a spacing between each one of the fence line receptors of no more than 25 meters. And 25 meters becomes important because you really want to see what the impacts, it's closest to the source, and you're going to have the greatest impact. So you want to see where the pollutants are going. Then, I'm sorry, I lost my train of thought for a second here. So we're talking about the source and the impacts, and then you want to be able to evaluate what the impact alone of that source is. And then you also want to be able to evaluate what the impact of source A, in this case it's AAM, what it would contribute to the whole area. So there are major sources within the area that they propose to put this new facility. You need to look at what is the cumulative impact of all of those sources on the community. Then to that very important question that you have, you also want to consider what the background value of a particular pollutant is. In this case, we're looking at particulate matter, which is less than 2.5 microns. So getting that background value becomes very important. Where is the sampling located? How much data do you have? And how representative of it, of the conditions currently, is the data that you've got? If you've got very old data that doesn't represent the conditions of Santa Fe right now, it's not going to be very helpful. It would likely underrepresent what the background concentrations would be, and therefore you wouldn't be doing your due diligence to answer the question. Ultimately, this whole exercise is, will the emissions from this facility create a situation that will violate the National Ambient Air Quality Standard?
Right, thank you, Dr. Clark. And just in running this model to figure that out, if the facility would violate the NAAQS, does the model run based on sort of, best case scenario it's not going to violate the NAAQS, or is it more worst case scenario it will violate the NAAQS?
The model doesn't make that judgment. What the model does is take the source data that you provided and say, run it out there. Here's your meteorological condition. Here's your time and space. Throw it into the community. Tell me what the concentrations are going to be. So to get to that judgment part, you have to understand what the current background conditions are moving forward in time, and what contribution source AAM is going to have within the total airshed of the Santa Fe, New Mexico.
All right, so I want to talk a little bit more about your review of associated asphalt modeling that the department reviewed and approved. Okay.
Okay.
We'll start with, since we're talking about it, the background concentration data. So what are your observations about the background concentration data that NMED used and actually provided to the applicant to use in their modeling?
So the commissioners have seen part of the guidance already that was provided to Dr. Sahu. Within that guidance is a page which provides them with what they've determined to be the background concentration for Santa Fe, New Mexico. In the footnote to that particular reference, it says this represents a 3-year condition. Further investigation into that, this is at the Runnels building downtown.
And actually, Dr. Clark, sorry to interrupt you, but if it would be helpful to the board, I can show everyone the chart that you're looking at within the modeling guidelines if you would like to see it.
That would be great. That would be helpful.
Can you all see that?
I can see it. If you could scroll down a little bit so we can see the bottom right there.
Yep.
Okay. So in the guidance on page 49 out of 83 for the guidance, there's a reference there for the North Central. Oh, I'm sorry if you can go back right there. Okay. North Central section of New Mexico. And it identifies the city as Santa Fe. And the sampling location is the Runnels building and provides the address. Footnote 1 to the table says, based on averages from 2013 to 2015. Footnote 2, which doesn't reference our particular site, we're not going to worry about. So this is indicating that NMED feels like they had 3 years worth of data. An investigation by myself and others into the reported PM2 data shows that the Runnels building was shut down. The sampling site was shut down I'm sorry, can you show me, sorry, I'm blanking on what year it was shut down, but what we've got instead of 3 years of data is actually 18 months of data. for that particular site. So the guidance is misrepresenting what the length of the time for the site and what the concentration at that site would be. So that was issue number one that I had with that.
And Dr. Clark, why would that be problematic if they only used data from 2013 and part of 2014?
Thank you for clarifying that. 2013, 2014. It doesn't, first of all, it doesn't represent 3 years worth of data. So you're suspect as to how they came up with this validated data saying that it's 3 years worth of data and this is what the background value is going to be. Secondly, there's an issue of integrity and honesty in this, that you're not really representing what's going on there. There are other sources out in the community that started around the same time, which would provide us with current background values. And that's more important. What is the current background concentration of particulate matter in the area? Because these things may change over time. As more industries move into a particular area, the background value is going to increase because there are additional sources of particulate matter which are being emitted in that area. So in that particular case, I've identified that what is now being reported by New Mexico Environment Department to US EPA in their air quality assessment is a monitoring station over at the Santa Fe Regional Airport. And that site has continuous data that goes back from 2016, but it is typically reported from 2017 on. So that would represent the more recent conditions in the environment for Santa Fe.
Okay, and Dr. Clark, you're saying that did you say that airport monitor has been existing since 2017?
It's been reporting since 2017, yes. It was existing prior to that, but because of the method they were using, they've updated the method. So it's now a continuous reporter. There was an old standard that was being used at the Runnels building, kind of the gold standard that's going along. But just like our telephones, where we used to have the old Nokia where there's nothing but buttons, now what they're running is an iPhone 10 to measure what's going on out there. So they've updated the technology, they have better reporting, and the impact on this is that when you go back and calculate the annual average for that site, you see that it is actually higher than what is being reported from 2013 for the Runnels building. This is important because the model that was run was maximizing the amount of emissions that were coming off of AAM. That's the whole issue here. They were trying to maximize the emissions coming up and not violate the NAAQS. When you substitute the new background data, the more appropriate background data, which is being reported by NMED to US EPA, you can say that the max concentration that they're reporting off-site when the background value is added is going to exceed the annual average. So now you've got a NAAQS value or a NAAQS issue along the way. So the permit allowed too much emission and you're going to get a violation.
Okay, Dr. Clark, and I want to ask you a couple questions about this airport data, just briefly. Is that data, approved for use for this kind of thing by EPA?
Yes, it's reported by NMED to US EPA. And when you go to the air data, when you go to the publicly available reporting site for US EPA of the monitoring station in Santa Fe, New Mexico, what you pull up is the active monitoring site is at the airport. And the 98th percentile value, which will be an important consideration later on. 98th percentile is typically what is compared against the NAAQS for the 24-hour average. And the annual average value are reported for each one of those years. So I've got in my report, I reported the concentrate, that those values from 2017 to 2021. Now, a difference in this data set is it's much more robust. In 2017, there were 280 samples that were taken at the airport. In the next year, there are 357. By comparison, if you look at the old data from the Reynolds building, there were no more than 118 samples that were taken over in any particular year. And in fact, in 2014, the year it was closed down, there were only 53 samples taken. So I'm offering this to you to say the data that is being generated is more representative of the conditions that the community is going to be facing.
The airport data.
The airport data, yes.
And you got this data from the Environment Department themselves?
No, I got this from US EPA. And the reason it's important I got it from US EPA is that this is the data that NMED has to report to US EPA. So the source of the data is the air quality monitoring station located at the airport, but it has to be approved and reported by each state agency.
So NMED presumably then has this data available.
Correct.
Okay. All right. Continuing on with your review of what NMED and the applicant did, what were your observations about the meteorological data that was used in the modeling?
In their analysis, they talk about using only 1 year of Met data, 2016. And the issue with that is if you are calling that a representative year of meteorological data, it has to cover all variabilities along the way. It's got to have the most highs and the most lows, the strongest winds, whatever the case may be. And what that does to the output is it limits the opportunities to create situations where you're going to have high values. So it's a very crude measuring tool of what the output will be along the way. It completely ignores the issue that environments change, and EPA has said you really need to be using 5 years. That's a much better representation of what is going on in the community. And the importance in that, you can have 2 years right next to each other that will have completely different concentrations through the model. But if you didn't understand that, you would miss the highs and you would miss the lows along the way. So it's a limited analysis, which ultimately, if I go back to the idea of what is the purpose of this evaluation, the purpose was to say, will there be any condition that would allow AAM to violate the NAAQS by putting more pollution out along the way? And the short answer to that is by using 1 year, by using the wrong background data, yes, you miss the opportunity to see that this was really going to create a problem.
And does 5 years of meteorological data, exist? Could the department have used that data?
Yes, quite easily. The data is easily obtainable, and you can run it in series so that you can just run 1 year right after the other, so you can see what the impact of each year would be along the way.
And you say it's easily obtainable. Where would you get it?
NMED used to have it, or the air quality division used to have it up on their website. They've now archived that data, so it's no longer there. There are a lot of resources out there that you can identify data for that particular site and pull it up and plop it into your model. I shouldn't say plop, incorporate it into your model and understand better what's happening in the environment.
Okay. Let's see. All right, let's talk a little bit more about the grid spacing and the air dispersion modeling done by NMED. What did you notice about that?
So the applicant took the standard approach to use a very wide grid to identify the hot areas and then use a narrower spacing along the way. They did not go finer than 50 meters apart. 50 meters is much higher spacing than what EPA suggests for fence line monitoring. So imagine you're trying to focus your analysis on where are the greatest areas of impact along the way. And what the model does is calculate the concentration at each point. And there's a separate piece of software that helps you interpret what the concentrations are between those points. The farther apart those points are, the less accuracy you have about the concentrations along the way. So if the grid spacing is too far, you miss the opportunity to identify where the highs and the lows really are. And you can, it should be run iteratively, and there's caution from EPA about running it so many times. But the reality of it is, with the software that we've got now and with the computers that we've got now, it is not a difficult exercise to rerun a model with a finer grid to really dial into where the issues are for any particular facility.
And you said at the fence line, why does the fence line matter?
Fence lines are typically in the guidance, the first point of contact that a community may have with pollutants coming off of a site. It's been my experience over the last 35 years that while fence lines are great demarcation points, they don't particularly stop anything. So the pollutants that are being emitted, whether it's a brick wall or a chain link fence or something else along the way, are not going to prevent the materials from moving off site along the way. So when you move through all the guidance, the question is, what is the first point of contact that we may have with the source coming off site? And if you really dial into where the highest concentrations are, then you can go back and identify what particular source was causing the problem. And then if you're doing a permitting exercise, you can say, I need to dial this down. If this particular source causes most of the issues, then this is what we have to focus on remediating. And that doesn't appear to have been done at this point.
Okay, so from what I'm hearing from you, and I mean, you didn't refine their modeling grid, didn't use a complete set of meteorological data, and didn't use an accurate background concentration data amount as inputs into the model or as parts of the model, right?
Correct.
And even with that, what did their modeling show?
Their modeling showed that, as Dr. Sahu referenced, they were that close. They were within a hair's breadth of exceeding the National Ambient Air Quality Standard. And if anything within the system is upset, or if there's any variance within the system, if you have a crusher that puts out a little bit more particulate matter than is typically being estimated, you're going to violate it. But the assumption is that we've covered that uncertainty along the way. So the impact would be, if we just went with their model, the community could be impacted, but it won't be until we get out there and monitor it and actually see what's going on. In that case, the horse is out of the barn. You can't get him back. The pollution has already gone through the community. This should be an exercise to say, how do we prevent any of these? And how do we limit the polluter to make sure that there won't ever be a condition where they exceed this?
And do you remember what percentage of the total annual PM 2.5 NAC standards they were permitted to operate at?
I want to say it was for the 24-hour average, they came within 97.2% of the NACs. And for the annual average, they came up to 99.3%. So if you think about how close that is. That's back to my analogy. They set the speed, the cruise control at 69, but they're going down a hill and they didn't bother to consider the variance that's going along the way. And now they're going to be stuck with a ticket.
And I ask, I think specifically about the annual, because you remember the, and I won't probably say this right, but the amount of micrograms per cubic meter that amount was?
So the modeled concentration was, for the maximum offsite was 11.9 micrograms per meter cubed. The background concentration, that's the total. So with the background and with what was modeled, they came up to 11.9. The standard for the annual average is 12. So it won't take much to tip it over to get to 12 and have an exceedance along the way.
And I ask particularly because you mentioned, you know, the PM 2.5 threshold values have been reduced over time by EPA, right? They've lowered what was an acceptable amount of PM 2.5. They've lowered the standards over time, right?
Correct. And really what this is being driven by is our understanding. If I take off my modeler hat and I put on my toxicologist hat, I will tell you that the issue that's coming up is that we've gone from gross effects of impact. Is this killing people? Is this causing excessive rates of respiratory distress, to a consideration now of we've got finer tools to evaluate what the health impacts are going to be. That's what's happening with the national ambient standards along the way. We've got a better understanding. We're not relying on outdated data and outdated outcomes. So it's clear over time the standards only get tighter. And if you are permitting a facility at 99% of the permit condition, what's going to happen is when it is reevaluated, and these standards do need to be reevaluated over time by EPA, you're likely to set up a situation where that facility will then be out of compliance down the road. And the impact is the community has been breathing this air with excess concentrations of particulate matter in it.
And so are you familiar, Dr. Clark, of EPA, you know, proposing to reduce the PM 2.5 annual standard anytime soon?
I am familiar with the conversations that are occurring with that. There hasn't been a specific value that's been promulgated yet, but it is incumbent on the regulatory agencies to review the existing data and to determine whether they need to refine it or not. And my reading of the literature over the last 30 years now is that we've got a much clearer understanding that particulate matter in itself is a health hazard. That's why it's on it's one of the criteria pollutants. And at the same time, we need to consider it is a great vehicle for delivering other pollutants along the way. So if it's a co-contaminant, if there is polyaromatic hydrocarbons, or if there happens to be a toxic metal in there, then what you've done is take a very fine particle and deliver it to somebody, and then there's going to be a response to that. Moving back to the idea of the standards, we keep moving down. So we've gone from 15 micrograms per meter cube as an annual average, now down to 12, and it's time to start evaluating whether we need to lower it from there.
So, and just to ask, if they're at 99.2% of 12, what would lowering it mean?
That really depends on how much they lower it. Let's speculate and say that they want to lower it just 2 microns, and make it 10 micrograms per meter cubed as an annual average. Then clearly the emissions would be at least 16% higher than the new NAAQS standard. That's speculating that a new one will come out along the way, but this is setting AAM to fail along the way by allowing them to be that close to the standard.
you, Dr. Clark. So let's talk about what you did after you reviewed their modeling analysis. You reran the modeling analysis, and what did you do instead?
So initially what I did was update the meteorological data that was being used. And I tried to use the most representative data for the last 5 years. So that essentially goes from 2016 to 2020. So now instead of dealing with just 1 year, I've got 5 years of data, and I updated what the background concentration of the particulate matter would be within Santa Fe. So looking at the airport, there within an appendix to my report, there are the outputs that NMED has reported to EPA, which it now reports as the annual average concentration in Santa Fe, or the 98th percentile for the 24-hour average. And I recalculated what the 3-year average would be for that data. Now, there is a note in the latest values reported for the day for the airport that they're still validating the data. It's been reported, but I took it at face value that what they're going to do is going to say this is what the value is. And what I found is that starting in 2017, the annual average value reported at the airport was 4.3 micrograms. It drops down over the next couple of years, but then in 2021, there's a reported uptick. All of a sudden, instead of being 3.7 like it was the year before, it's 4.4. So this is important to consider that even over a short period of time, there's a variability in the background. There could be a lot of reasons for that. I'm just dealing with the data. The data says the annual average is 4.4. The reported 24-hour average, the 98th percentile of that, is 11.3 micrograms per meter cube. Why do we care about this? When we model, you add the background in to consider what the impact is going to be on the community. This represents, I believe it's a 10 to 14% increase in the background concentrations as compared to what NMED was using from their reported value from 2013, 2014. Remember, we were less than 1% off for the annual average, and we were 3% off for the 24-hour average. So if you increase that background by 14%, it cascades down into the model and says you're going to end up with a violation. And that violation could be right on the AAM property, it could be right off the property, or it could be elsewhere in the community. That's where the analysis of the output of the model becomes important.
Okay, so you used new background and you talked briefly about new Met data, and that changed everything too. You did those things separately, or talk a little bit more about how you did?
No, I did those together. So what I did was to updating the Met data is step one. Identify where the Met data is, get that Met data, make sure that it's representative of the conditions, that there's not a lot of missing data. Sometimes these systems will go down and you have to worry about, well, did I miss some big event along the way? I validated the data. It is appropriate. It meets the conditions from EPA. I went back and I updated what the issues were about background, saying the background really is represented by what's coming out over at the airport. I took the input values, it's actually a little script. I am near Hollywood, so it's not exactly that kind of script, but it is a logical line of commands that are given to the machine that says, here's what the meteorological data is, here's what the background data is. And I did not alter the source terms at all. So I reran it with the source terms that were permitted or allowed in the permit that we're talking about today. And then ran that model. Takes about 7 hours to run the model. I've got the output from there, but now what I've got is not just an average value for 1 year, but I've got 5 years of data that I can look at and say, was there a condition that showed there was an exceedance of the NACs? when I look at the 24-hour average or the annual average along the way. I'm sorry, I missed something along the way. Another step that I'd done along this was I identified particular areas that were higher based on the original modeling, and I put a finer grid in that area to kind of really dial in what does the contour of pollution coming off look like. And it was important considering what is the impact of AAM on the industrial facility right next door, and what would that impact on down the line.
Okay, so, and before we kind of get to the grid, I just want to make sure I understand that all other things being equal, meaning if you run the model exactly the way NMED ran it, right?
Yeah.
But you include background data that came from the airport monitor that was more recent and more nearer, it was nearer the facility, right? And more reflective of what was going on in that actual background. And you also included meteorological data that you're much more sure would capture all different sort of meteorological conditions in the area. That showed NACS exceedances or?
Yes, what happened is that NMED has already stated in its review of the initial document, there would be what would be a NACS exceedance in the property next door. But because the property next door is industrial, they were allowed to go ahead and subtract the concentrations. Here's what the reality of this. Pollution moves from AAM, it moves to the site next door. Because of that, the two combine, and then you've got a concentration that you estimate or you calculate as a source value. That value will exceed the next. That's an interesting issue related to how two neighbors interact with each other. Looking back on the totality of the model, what I did was go through and identify where were there concentrations that exceeded the NACS. The 24, I was focused on the 24-hour. The annual average came close, it didn't exceed it. But for the 24-hour, I found that there was an area in the river basin right outside of the facility that exceeds the NACS. And it does it on multiple years. And one year, the concentration is 30 micrograms, then it jumps up to 36, and then it jumps up to 40. So there's a whole variable list of concentrations along the way. This is the important thing for the community to understand, that by getting the breadth of the items which cause variance, because in the permit it's saying we're only going to emit X amount and keep it that. So the thing that changes is going to be what is the background in the area and what is the meteorological condition? How does that impact it? So this is the extra flavor that I've added to the analysis to say, did you really consider everything that's going on there? And the result of it is that I found there's an area to the southwest of the entrance of the site in this river basin that people can easily walk up to and be exposed to this material.
And the idea being with the Met data that 5 years would cover, you know, all possible conditions. So looking to the future, if those conditions exist, there would be an exceedance in those areas. Is that correct?
Correct.
Okay. Okay. And then with that, once exceedances were identified, you refined the grid spacing further.
I did do the refining the grid, and the areas that I was focusing on were the entrance and the area to the west to the adjacent facility. The exceedances occur outside of that, so that I could easily have gone back to refine that grid to say how big a blob of pollution are we dealing with along the way. But I'd identified the issue up front. Does the permit allow a condition where you're going to exceed the NACS? And the short answer is yes.
Okay. Okay. And talking a little bit more about this grid refinement at the fence line, right? You might remember from last year, we had a similar discussion about refining the grid in such a way that could be considered an abuse of the model, right? So is there a problem in refining the grid to something that would be 25-meter spacing or less? What does that look like?
I found that language to be very colorful. Abuse of the model, no. The model will, as I said, it represents the concentrations based on a number of factors that move items from point A to point B, and it gives you a concentration. The refinement that we're doing really is to look at the environment in toto. If you are saying 50 meters is the minimum amount of spacing that you can do, that's all you can do along the way, and anything below that, then you would be in conflict with US EPA in their modeling guidance checklist, which says that at the fence line, it needs to be 25 meters or less, and you'd be in conflict with your neighbors in Arizona. I noticed we pulled up some stuff from Arizona earlier on. Their modeling guidance suggests 25 meters as a tight area to look at along a fence line. So no, it's not abusing the model. What it does is provide an extra amount of information related to, is there a particular hotspot that we're not getting along the way?
And I actually want to show this air quality checklist if I can, Ms. Jones.
Ms. Locke, can you give us an indication of how much longer you're going to need for direct examination?
Oh, much like I think when you asked Mr. Jantz, we're about 2/3 of the way done. So, but I can try to be
2/3 of the way done.
Yes.
Okay. Well, we'll be hopeful that it ends the way it did with Mr. Jansen. It didn't take that long. But
Quicker, yes.
I think in light of that, we'll take a break now. It's 3:25. We'll take a 15-minute break and come back at 3:40. Thank you.
Thank you.
We're back on the record. Ms. Locke, you may proceed.
Thank you, Mr. Hearing Officer. All right, so Dr. Clark, you mentioned an air quality checklist, and if I could, I want to show the board sort of what we're talking about. You all see this? Yep.
I see it, yes.
This is Community EIB Exhibit 20, Air Quality Analysis Checklist. So Dr. Clark, can you tell everybody what this is?
This is a document provided by US or on EPA's website to assist modelers in the preparation of air quality analyses for new source review or prevention of significant deterioration compliance reviews. So essentially, it's a guideline for individuals preparing the necessary documents to make sure that they meet these minimum requirements as outlined by EPA.
Thank you, Dr. Clark. And I just want to go down to the part where it talks about grid spacing.
Page 9.
Thank you. And I highlighted it so it'll catch me. Here we go. Okay, modeling domain and receptors. So first of all, is this section applicable to what we're talking about?
Correct.
And this highlighted section, can you just read that for me?
The highlight says fence line receptors with appropriately representative spacing, open paren, exemplis gratis, no greater than 25 meters, close paren. So the guidance clearly states that as you set up the receptor grid around the site, for the fence line, which is, again, the first point of contact with the community, the grid spacing should be no more than 25 meters.
And so just to be sort of really specific with what your results were when you ran the model with both more representative background concentration data, a more refined grid spacing, and a more representative set of meteorological data, what were your results?
So in the end, what I found was that when all of the appropriate values are put in, the background, the metadata, and the spacing is adjusted as necessary along the way, that there was a condition that was created by use of the standards created in this permit, which would exceed the 24-hour NACS. And it would be, instead of being just under at 97%, it was about 103%. And this is in an area which is in the river basin, just southwest of the entrance to the site. Now, I need to explain something. I don't think we actually talked about this within the testimony. What I'm presenting in the modeling exercise is the 98th percentile. So it's not the maximum concentrations that come off the site. This is a requirement under the EPA guidance that you take the 8th highest value from the model, which is equivalent to the 98th percentile. So I didn't want to give you the impression that what I'm presenting is the maximum concentration there. This is an apples to apples comparison. When you look at what should be coming off the site and how you compare it against the standards, the results that we've got clearly indicate that there was a NACS exceedance at the permit level that was set for AAM.
Thank you, Dr. Clark. And so these exceedances, you said you found them where members of the general public could be.
Correct. So just north of the highway, there's the river basin. I apologize for not knowing the river basin there. It's that big arroyo that goes just south of the facility and into the community. And it wasn't one, it was several of the receptor locations there had exceedances above 35 micrograms per meter cube.
Okay, and sorry, I'm muting periodically. I don't know if you all can hear my dog is squeaking on a squeaky toy right now, but so Dr. Clark, you were here for Dr. Sahu's testimony about PM 2.5 and the AP 42 emissions factors. Right? You heard that.
I did.
So you heard all about how there's a lot of potential in this particular case to underestimate the overall calculations of PM 2.5 emissions, right? So if the source terms for the site were based on assumptions that were underestimated for the PM 2.5 emissions, what would the impacts be in terms of modeling?
So depending on the uncertainty that we're talking about, if the value is off by 10%, then you're going to see a concomitant increase in the PM 2.5 concentration. So there's a relationship between what the source term is and what the concentration in the community is. So the larger the uncertainty, the larger the value that's going along. Dr. Sahu talked about values which were 13, it was like 4 to 13 times off, depending on the AP 42 value that they were talking about and the uncertainty of it. That you can imagine that it would be that type of increase in the modeled concentration coming off. So the model is predictive of the data that's put into it. If you've got uncertainty in the source terms and you have a plus or minus on what the real value is going to be, then you can guarantee that you're going to find a condition that is going to exceed the NACS, particularly when it's so close. I mean, as it was when I went back and evaluated what was going on, for the 24-hour value, it was 103%. The annual average value was 99.93%. So you really can't get much closer than that without having an exceedance along the way. And this goes back to that larger issue that I was talking about. I really want the commissioners to have the full bit of information. We're not talking maximum values. We're talking about the values that are required within the regulations to make a comparison to see if this is violates the conditions of the NACS.
Thank you, Dr. Clark. So just if you could just sort of provide an overall conclusion that was the result of your modeling review and your new modeling, what are your thoughts about the way AAM is permitted to operate based on the modeling?
The permit conditions are going to create a condition where there's almost guaranteed a violation that's going to occur. So given that there's my assertion that the background value is different and that the permit pushed it to the maximum amount that included a lower background value, the permit is going to create a condition that will violate the existing ambient air quality standards, and that the robustness of the review that was done didn't consider all the variables that will impact this, whether it is the uncertainty associated with the AP42 emission factors, whether it was the meteorological conditions at the site, or whether it was the background. It's clear through the math that there's going to be a violation, and that the permit as issued is creating a violation. So it really needs to be repealed and reevaluated.
All right, thank you, Dr. Clark. I have nothing further for your direct examination.
Thank you.
Okay.
Department has no cross.
Pardon me? Somebody spoke.
I'm sorry, Mr. Hearing Officer. The department has no cross for Dr. Clark.
It has no cross. Okay. Is there any cross-examination from members of the public? Excuse me. All right, we'll turn to the board members. Are there any questions from board members? Yes, we got Ms. Davis.
Yes, thank you. And thank you, Mr. Clark, for taking the time to chat with us today. My questions, I just had a few clarifying points from your testimony. One things you testified on was the available data that was used for the modeling. And I'm curious because we've heard in some other hearings that we've done about certifying data. So I'm wondering, in this instance, was the data used required to be certified by the EPA before it was, or to be used in any modeling?
I'm a little unclear on which data that you're talking about. So is it the reported air concentrations that NMED reported to EPA, or are you talking about the MET data or the calculations from the applicant on their source terms?
Oh, I can be more clear about that. I believe it's the data that was reported to the EPA from the NMED, the data from the air monitors.
Correct. And in the appendix to my report, there is the last year needed to be certified. The data is reported correctly. They just need to look for any kind of differences along the way. So yes, NMED needs to certify and report the data. And when I pulled the data from the US EPA website, this is being reported as this is what's out there and this is what's been certified, with the one caveat about 2021 being certified by May 2022.
So if I'm understanding correctly, the data used for this particular permit was, I think, 2013 through 2016. I'm sorry, I don't remember exactly the years, but I feel like it was in that range.
I'm sorry, I think we're talking different things. So the MET data was reported by, it used to be on NMED's, or the Air Quality District's website, and it's now archived. The background data had been certified and sent off to EPA, and that was for 2013 and 6 months of 2014. and that would be the background data. And that was really related to, there was an old analytical method that they were using. And now that we've updated the method, and it's an acceptable method by EPA. We'd had a large discussion previously about one versus another. And this is accepted by EPA and can be used and is being reported. And in fact, NMED is the one who's reporting it all.
Okay, so and I apologize if I'm asking the same question over again. I'm just trying to understand
No, please do.
all of this. So the background data that you mentioned, is that used in the modeling, or is just the MET data used in the modeling?
Both are used in the model. So what the model allows me to do is say, what is this, the source concentration, or what's the source term? Where's it going to go? And in that, there's a way to add the background in so that the output of the model just gives me the final concentration, so that I can look at it quickly and say, or plot the data and say, this is what it will look like in the community. And you can do that just for AAM, or you can do that in combination with all the sources around it. So the important thing is that without AAM at the site it's at, that particular couple of locations that I found that the public has access to would not exceed the NACs. When you add in AAM at those permit conditions, that's assuming everything is calculated correctly and it goes consistently through. Then that becomes a NACs violation. So that particular area is a problem for the community, and it is with the background added to it. So there's no additional math that needs to be done.
And where's the background data derived from?
The background data, so originally the background data was Runnels Building and downtown. Now the background data that's being reported by NMED for the community is derived over at the airport. So there's a monitor there.
Those are air monitors that they're taking the data from, and they're creating the background data.
Correct, and reporting that. So over time, when you look at, I think it's Appendix C to my, or Exhibit C to my report, you'll see that the tables that's pulled directly off of US EPA's website that is reported for that air monitoring station. So what was done is there's meteorological data that's collected adjacent to this, and then the sampling data that's collected to determine what air quality impacts are happening in the Santa Fe air basin.
And that background data, that data has to be certified by NMED to the EPA?
Yes, ultimately it does. It's
Okay.
certified that it was collected correctly, and this is how we're reporting it.
Okay, I understand. And so was there certified data, was there newer certified data?
That in the report, I show you all the data that was reported from 2017 to 2021. And in that, you see that the background, the annual average value is starting to increase, along with the 98th percentile value starting to increase. And in there was a footnote for the 2021 that says this needs to be validated, certified by May 2022.
Okay.
And that's just a standard procedure that occurs. Agencies provide EPA data, and they need to certify that, yes, this is a true and correct reporting of what was monitored.
Okay, thank you for clarifying that for me. And
yes.
One last question. I believe you were talking about this particular model was within 97% of the emission standard. And did I get that number correct?
So originally, when the applicant submitted to NMED, they created an emission level, a threshold. They say, we want to put X number of tons out. And when that was run through the model, it came out to 97.3% of the national ambient air quality standard for the 24-hour average. And so it was almost to the threshold value. Then if you add the new background, you see that it increases above it.
So is there a recommended percentage that modelers like to see the emissions being within of the threshold? Like, do they recommend 95 or 98%? What is there a best practices for that?
Well, the best practice is ultimately that whatever standard whatever percentage you come up with, you need to be able to come back and say, given all the uncertainties, if I think that it's going to change by 5% or 10%, whatever that worst case scenario would be, that I will still be under the standard. So it's a larger question within the community of how can we push the emission standards but still be protective? That I think that's ultimately the question that you're asking. How do we not exceed this standard? So there's no formal guidance from anybody to say, if you're at 90%, that's acceptable. But it is not a difficult exercise to go back through and check and say, hey, you said this is an acceptable level, but let me go ahead and validate that. And that's what we did. We validated what happened in the model, and we found that when you update it to include the current MET data and the current background concentrations, you're going to exceed it. So ultimately, the threshold that they set isn't acceptable. You're going to create violations.
Okay, thank you for answering my questions and
You're
taking the
welcome.
time to talk with us.
You're welcome.
Are there any additional questions from board members? Okay, Ms. Garcia.
Officer. And thank you, Mr. Clark, for your testimony. I do have a couple of questions. You mentioned that when you ran the model, updating the MET data using the airport monitor rather than the runnels and using a finer grid, it would result in the 24-hour PM 2.5 exceedance. And I think you said it was about 103% over. What is the number actually?
So the total concentration that we modeled at that point, you give me a moment, I will find it for you. The concentration ended up being that I modeled was 36.08 micrograms per meter cubed, and the standard is 35.
Thank you. My next question is, I'm interested in looking at, because I have a regulatory background, so I want to know, what did the department not do that they're required to do? Now, Dr. Sahu made it pretty clear that in his opinion, they did not follow the AP 42 guideline correctly. And in fact, they didn't adhere to the EPA alert about using the AP 42 guidelines. So I gather that information. Now, could you tell me what guidance or guideline or requirement did the department not use? You mentioned in your testimony that the background concentration cited in the NMED guidance does not represent the current conditions in Santa Fe. What NMED guidance are you talking about there? Could you tell me exactly?
Sir, in the modeling guidance that we referenced earlier, that was used in testimony with Dr. Sahu and that we provided, where I discussed the background concentration measured at the Reynolds building, That's the guidance in particular, their own guidance, what they've come up with. And the idea of that guidance is that they would be consistent with information from US EPA and their regulatory guidance. So the issue is that if you deviate from US EPA norms, and US EPA norm says use 5 years of MET data, use or 3 years of predictive MET data, or 1 year of site-specific data, and use background concentrations when considering what's going on, and use a fine enough grid to determine where the maximum concentrations are. It's all spelled out within those particular guidances, in particular the checklist that we've got going on that I was showing you. It's a layer cake of what didn't, they've followed what they had written, but it didn't follow the spirit of it, which is find if there is a problem. If you stop your analysis before you determine what the maximum concentration is, then you're not really doing your job along the way. And that's where refining the grid, using the most recent MET data, and frankly, the background data, the background concentration plays a huge part in what is going to be a violation or not. So if you're using data which is nearly a decade old and doesn't represent 3 years, which is the requirement for the background concentration, and you're representing it as a 3-year value, you're not meeting your duty as an agency to fairly assess what is going on. And that's the conclusion I'm left with. They didn't meet the higher standard, which is to determine whether this is going to create a problem for the community or not.
Understand. Thank you very much. That's all my questions.
Thank you.
Are there further questions from the board members? Okay, hearing none. Ms. Locke, do you have any redirect?
Just briefly, Mr. Hearing Officer, I think to help better clarify the questions we got from the board. I'll start with, I believe it was Member Garcia's questions. I just want to show the modeling guidelines here quickly for you, if I could, Ms. Jones. All right. So again, can everybody see this? Dr. Clark, can you see this?
I can see that, yes. It
Okay.
says section 4.4.1 uses of background concentrations.
And we're looking at the Air Quality Bureau dispersion modeling guidelines from 2020, right? We're talking about the uses of background concentrations. Dr. Clark, could you just read this highlighted section?
Of course. It is very important to use recent monitoring data, because concentration trends are likely to change over time, open paren, much more so than weather patterns, close paren, period. If hourly meteorological data does not match hourly monitoring data, then the following methods can be used to produce a concentration profile for the refined modeling exercise, period.
Thank you, Dr. Clark. And based on this, would you say that the data that you used when you ran the model, so data that was certified by NMED to EPA for background concentrations from 2017 to 2019 for a background calculation, is that more recent than the 18 months of data that NMED used when they did their air dispersion modeling?
Correct.
And then one other part of this that I just want to point out.
And actually, Ms. Locke, I want to represent that it's more recent and it's more robust. And this is an important consideration. When I walked the members through the sampling that was done at the Reynolds building, in 2014, there were only 53 samples that were collected along the way. The automated monitoring system that now is in place at the airport, and has been in place since at least 2016, provides a much greater resolution. It's got many more times. It's up to 357 or more samples collected over the course of the year. So it better represents the conditions within Santa Fe than this very limited data set, which was collected nearly a decade ago.
One other piece of this. So, and I didn't highlight this, but if you could just read the section beginning with each of the 12 months under the developing 24-hour refined background concentrations section.
Yes, each of the 12 months is represented by the maximum 24-hour concentration occurring during that month. If 3 years of data are available, comma, average the 3 values for each month and use the average for the background. If a given month has, oh, sorry. Is that it?
No, that's okay. It was the 3
Okay.
years part that I was just trying to get at.
Yes.
So Member Garcia, this is the part of the guidance that requires both of those. And then to, I hope, clarify, Member Trujillo Davis, your questions. I just want to be clear that Dr. Clark, for NMED's modeling, they used 1 year of MET data from 2016 and a background concentration data calculation that was from data collected from 2013 and 2014 from the Runnels monitor.
Correct.
Okay. And then for your modeling, you used 5 years of meteorological data, and both sets of MET data used by both you and NMED came from the same site, right? The same monitoring site?
Yes, yes, from the airport monitoring site.
So, but you used 5 years instead of 1 year,
Correct.
and you used a background modeled concentration that was based on data from 2017 through 2019. So 3 years.
Up to 2021, I reported in there, but I used a 3-year average. Yes.
Right. Okay. Okay. And just, I kind of briefly want to touch on the difference between the Runnels site and the airport site. The Runnels site was shut down at some point and replaced with the airport site, but what happened with the Runnels monitoring site?
My understanding is that the data was starting to show fewer, lower concentrations along the way, and the technology was changing so that we could report much more. And a decision was made that this isn't going to be as representative of conditions in Santa Fe. So the choice was made to move to the airport site and start reporting that.
So in 2014, when Runnels was shut down, it's your understanding that it was shut down because even in 2014, it wasn't representative of what was going on in Santa Fe?
Correct.
And just to sort of, put a bow on all of this, why does background concentration data matter?
It's a great question, because the purpose of all this modeling is to predict what the concentration in the community is going to be when all these sources are added together. First, you want to identify, is one particular source driving something, and then will multiple sources added together create a problem? You cannot change the background. The background is what it is. It is all of the pollution, all of the natural material moving through an air column. And it is an important consideration of what the exposure point concentration is. So if I was doing a risk assessment on this, I would want to know, is the emission that's coming from a particular site at a particular level, but if you add that to the background, does that create an additional burden or risk? And that's essentially what we've done here. Does the addition of the AAM emissions to everything else that's there, plus the background, cause an exceedance of the NAAQS? And the short answer is yes.
Thank you, Dr. Clark. I have nothing left for redirect. Thank you, Mr. Hearing Officer.
Okay, thank you very much, Dr. Clark, for your testimony.
Thank you.
You're excused, and we'll go to the next witness.
I think the Ms. Garcia has a question.
Oh, I'm sorry, Ms. Garcia, I didn't see you. Go ahead.
Thank you. I just have one follow-up. I'd like to clarify a point that I think is getting to be a little bit confusing, because people are saying NMED used XYZ, NMED used. NMED didn't do the modeling, right? It was the permittees, it was the permittee in their proposed application did the model, and NMED reviewed it and approved it. Is that correct?
Correct. The applicant does the model with input from NMED. They review it and they approve it. So it's a de facto blessing of what they've done.
Okay, that's what I wanted to clarify. NMED didn't do the modeling. They approved the modeling that the applicant did with their input parameters provided.
Correct. Based on the guidance from either the written guidance or verbal guidance that they may be receiving along the way.
Sounds like the guidelines, the NMED guidelines of October 2020 were not followed, is your position.
The spirit of it was not followed. I'd have to go back and look line by line to see whether where the particular thing, but just getting to the idea that it is incumbent on the air quality district to determine whether a violation would occur or not with the data that's presented to them. And clearly going back and putting in the updated MET data and the updated background data shows that it's creating what the applicant is asking for is going to create a violation.
Thank you, sir. That's all I have.
All right, thanks.
Anything else from board members? Okay, hearing none and seeing none on the screen, I will now excuse Dr. Clark, and thank you, Dr. Clark, for your testimony, and we will proceed to the next witness.
Thank you very much.
Thank you, Dr. Clark. Thank you, Mr. Hearing Officer. We would call Mr. Michael Schneider.
Okay, let's swear Mr. Schneider in.
Can you hear me?
Yes, I can.
Great.
Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Thank you.
All right. Hi, Mr. Schneider. Could you just say your full name for the record, please?
Sure. Michael C. Schneider.
And Mr. Schneider, where are you currently employed?
I'm actually not employed. I'm retired.
All right. And what did you do before you retired?
So I actually had the pleasure to work for the New Mexico Environment Department.
And what was it that you did with NMED?
So I did a number of things. I did early on. I started in 1993, and I was an inspector for 2.5 years, which involved inspecting facilities such as asphalt plants and sand and gravel plants, and responding to complaints from the public regarding air quality. And after doing that, I worked in the permitting section for 12.5 years, and reviewed permit applications such as the one in front of us today. I also reviewed permit applications in other other industries in the state, including oil and gas and electric generation and agriculture production. In 2000, right around 2007, the end of 2007, I switched to the emission inventory group, which was at the time housed underneath the modeling section. But I was an emission inventory person and worked primarily on getting emission inventory for greenhouse gas emissions in the state going, because that was something that had not been done, was an initiative of the Richardson administration at the time. And in 2017, I retired from the New Mexico Environment Department.
And with your job at NMED, were you required to be familiar with the Clean Air Act and the Air Quality Control Act for the state of New Mexico and implementing guidance, EPA guidance?
Yes, that was definitely part of my work. And additionally, I was trained and certified for evaluating visible emissions from sources like asphalt plants and sand and gravel plants and the like.
And can you tell us just a little bit about your educational background prior to your time at NMED or during?
Sure. I have a bachelor's of science degree from Ohio State University in agriculture.
And have you provided, presentations or reports on various air permitting subjects or air modeling subjects? Or
not reports on air modeling, but definitely reports on permitting initiatives and at the time, pending rule changes and those sorts of things.
And you provided a written report as part of your testimony here today as well.
I did.
It is Community EIB Exhibit 10, and I believe just the accompanying Exhibit 11 at this point. Does that sound right to you?
It does.
Mr. Hearing Officer, before Mr. Snyder gives his testimony in earnest, and when Ms. Locke is done qualifying him, I'd like to voir dire him.
Okay, we can proceed in that fashion.
Mr. Hearing Officer. And Mr. Schneider, in writing your report, you reviewed a lot of documents. You include that list of documents in your report, correct?
Yes.
And that list includes the associated asphalt permit application.
Correct.
And you said that you worked in the permitting section of the Environment Department, right? I'll let you answer that first.
Yes.
Okay. And in reviewing AAM's permit application, did you use, the same skills and everything else that you would have used had you worked at the department to look at this?
Yes. I mean, yes.
And Mr. Hearing Officer, I would move to qualify Mr. Schneider as an expert in air permitting in New Mexico.
Okay, Mr. Vigil, did you want to voir dire at this point or after I rule on the motion?
I'd like to do that at this point. I'd like to hear it at this point.
Okay, please proceed.
Mr. Snyder, you just said that in assessing the application, or excuse me, the permit in this case, you use the skills that you employed when you were working for the Environment Department. Is that correct?
Use my skills and experience, yes.
Okay, thank you. And have you ever worked as a modeler for the department?
I never have, and I never claim to have as a modeler.
Thank you so much. Have you ever conducted any modeling for the department?
I have not conducted modeling for the department.
Did you supervise any modelers in the department, directly supervise the work of modelers in the department?
No.
So is it fair to say that you are not an air quality modeler or air dispersion modeler?
I'm familiar with certain aspects of air dispersion modeling, but I am not an air dispersion modeler.
Okay, I have no further questions for Mr. Snyder, and the department opposes the motion strictly on the grounds of air dispersion modeling. Mr. Snyder's not qualified to give an expert opinion on that.
Okay, I'm going to grant the motion. I'm not recalling any specific testimony that he gave on modeling. So I'm gonna reserve judgment on any testimony regarding modeling, excuse me. Give me a chance to go back through it. But I'm going to allow him to testify on any subject related to the permit other than modeling.
Thank you.
Thank you, Mr. Hearing Officer. All right, Mr. Schneider, you said you did provide a written report to include as part of your presentation today. Are there any corrections you would like to include as in that report? We're getting started.
I do have a couple of corrections. If I can refer everyone to page 22, we have a list of basically 21 suggestions to make the permit stronger. And the second one relates to an hourly emission rate for asphalt fumes. And the department's most recent, or I should say the department's September 14th, 2021 permit does put that back in the permit, which is good. There is still some uncertainty as to whether there's a specific stack test that would verify those emission rates. So that aspect of the testimony I'd like to keep in there. And then items 3 and 4, the department has made the suggested changes to the permit language, and there's no need to discuss those further, at least in regard to my testimony. And I appreciate the department taking that input to make this permit more clear and more enforceable.
Thank you, Mr. Schneider. And I just related to that have a question about sort of when you noticed that the permit as it is today was different from the permit that was provided in the administrative record.
Yeah, with some time, I believe, trying to do my math backwards, a couple weeks ago when the department submitted their statement of intent.
Thank you, Mr. Schneider. All right, let's just talk sort of briefly about your work with the New Mexico Environment Department. So as an NMED employee, is it safe to say you followed EPA guidance?
It is.
Okay. And if EPA issued guidance that was related to a permitting process, would you have to consider that as part of your job in the permitting section?
Yes.
And how would that be considered?
Yeah, so over time, as we evolve through this air quality world, the EPA identified new sources of emissions. And one example was in the oil and gas industry, where they had not really had a good handle on the hazardous air pollutant emissions from glycol dehydrators. I won't get into the details what a glycol dehydrator does, other than that it results in hazardous air pollutants. And so there was a time where the Air Quality Bureau didn't look at those emissions, and we started to look at them after we were basically encouraged strongly by EPA to do that. So normally, yeah.
So it impacts the work that you did?
It did, yeah.
And understanding that you are not, an air dispersion modeler, in your work with the department, did the, air modeling guidelines and air monitoring data ever come into play in situations where you were reviewing permit applications?
Objection. The witness is not qualified to speak on these matters.
Mr. Hearing Officer, he's qualified to speak to the processes in permitting, and I'm asking if this was considered as part of the permitting process and the permitting.
I'm going to allow the question based upon his experience with permitting, recognizing that he's not an expert on modeling.
Thank you. I was familiar with the reports that were generated by the modeler, because I had to review basically the modeling summary, the modeling report, after the modeling section reviewed the applicant's modeling submittal. And so I was familiar with those results. I was familiar, obviously, with the pollutants and the level that they were emitting at in terms of the total concentration resulting from the permitting action. And so then it was my job to make sure that the permit had appropriate permit conditions to ensure that the modeling that was represented would be enforceable essentially through the permit. And additionally, I had awareness that there was background concentration data from air monitors throughout the state. And I actually worked next to somebody who reviewed the data for that for a number of years. And so I had some awareness as to what went into air models and how the results were used, and what my job was to make sure that the permit would be reflective of those results.
Thank you, Mr. Schneider. And so in your work at NMED, did you review asphalt plant permit applications?
I did.
And, how many would you say you looked at?
I would say between asphalt plants and sand and gravel plants, dozens of them. And so those were kind of a bit of a outcome of my efforts and others' efforts in the Bureau at the time in terms of getting those sources to come in for permits in the mid-90s. And so I had a good amount of experience working with them.
And you said you reviewed AAM's application, so and the draft permit, but what impressions do you have regarding, the equipment that Associated Asphalt is proposing to use at this facility?
Sure. So from what I saw in the application, the equipment's fairly old. One of the asphalt batch plant is from the 60s, and I believe and that's a 150 ton per hour plant, and a 300 ton per hour plant is from the late 80s. And so these plants have been around for a while. And I would say, that's crushers, screens, conveyor belts, those sorts of things. I'm not sure the age is so much of a factor, but for the asphalt plant, which, is one of the primary emission sources for this facility, I think age is a factor in regard to that. A plant that old does not necessarily incorporate the technology that's available today in a newer plant.
And why does this old equipment matter in terms of, emissions?
Yeah, so one of the pollutants that's emitted from asphalt plants are asphalt fumes, and that basically asphaltic oil is sort of the heaviest. It's basically the bulkiest, most unrefined product from a refinery, and so it's used in conjunction with rocks, sand and gravel, and mineral filler to produce basically the asphalt that goes on the street. And so the older technology plants may emit more asphalt fumes than the newer plants. And I say may because it is somewhat dependent on the type of materials being processed. But in general, the newer plants are more efficient in terms of eliminating the fumes, the asphalt fumes, which are also the odors that surround these type of plants.
Okay, and in your experience, is this sort of outdated equipment, pretty standard? Is it used in other states by other asphalt plants?
So I can't speak to recent times in New Mexico, but I mean, it was fairly standard, 15 years ago when I worked for NMED. In my review of this application and looking around at other areas that had concerns about asphalt plants across the country. I found out that the state of Michigan actually doesn't allow the, it's basically called the parallel flow technology asphalt plants because of the concerns related to higher emissions or VOCs and asphalt fumes.
Okay. So in your opinion, is there a better way to do this than what AAM is proposing to do that would result in lower emissions?
Well, I mean, there's new technology, yes. And so, you know, the rules don't necessarily compel them to do this, but I think that there are other, there are issues obviously that have been outlined by our prior two witnesses that speak to perhaps the need to revisit what's being proposed.
And you said, as you're in your position working with the air permitting division with the department, you were familiar with the air dispersion modeling guidelines. They help sort of guide your assessment of the modeling results so that you could draft stronger permit conditions.
Well, I was
object. He is not a modeler. He's admitted that he's done no modeling. He's supervised no modelers. He's basically telling us that he sat next to a modeler and now he wants to testify in a legal proceeding about modeling. I think it should be excluded.
Mr. Hearing Officer, if I may.
Yes, you can respond.
Mr. Schneider already said that he was informed in some of his decision making by the modeling guidelines. He's not speaking as a modeler. He didn't run a model. He's not trying to say he ran a model.
Yeah, but it's basically hearsay based upon information he's gotten from modelers. So I'm going to exclude it at this point.
Thank you, Mr. Hearing Officer. Let's see. Mr. Schneider, at your time at NMED, would various guidance documents put out by the department be updated regularly?
Yeah. In fact, that was done a lot in the permitting section. I mean, there were new types of permits, like general permits, which essentially cut down the time that was put in to review them, so that plants actually, not as I'm talking here, are plants even in this category, asphalt plants and sand and gravel plants, and some oil and gas plants underwent essentially expedited review, which would make it easier essentially to get permits. And so there were lots of guidance documents related to those permitting types, permit application types.
Okay. So if new information about something related to permitting came out, guidance related to permitting would be updated generally based on the information.
We would vet it and evaluate it and then go forward with what that looked like as appropriate.
Okay. So, and then Mr. Schneider, based on your experience at NMED, if new data came out or new information came out 2016, 2017, would it be reasonable to expect the department to have reviewed that data and included it in guidance by 2020?
Yes.
And then you heard a lot of testimony from the other two witnesses about, bad data approved and provided by the department, right? From a permit writing perspective, what would the use of bad data mean?
It mean that you would have essentially an inaccurate result in what was proposed in the application, and if unfortunately it went forward in the permit, you would have basically an incomplete permit and one that was not, or potentially was not, compliant with applicable standards.
Mr. Schneider, and are you familiar with Associated Asphalt's current permits? It has 2 current operating permits,
So when I went to the Air Quality Bureau's website where they have a map of these sources, I was able to find the current permit or one of the permits, previous permits for the smaller batch plant. Yeah, asphalt plant.
And what are your impressions of the current permits?
Well, they were reflective of the times, I would say, and they were brief, but I would say also that, you know, for what was being done at the time, which was a lot less than now, they included the applicable requirements.
And in your opinion, how do the old permits compare to the new proposed permit?
Well, they're inclusive. I guess I'm sorry, can you clarify the question?
Yeah, looking at the old permits, would you say that the new proposed permit is, you know, better and solves the problems that might be identified in the old permits?
Right. So yes, it's an improvement. It's an improvement, but it's incomplete. And so I think there's some good language in it, but it's not complete. And I think the older permits, since there was less content, you know, less rules at the time, were just more straightforward and smaller. And so, you know, size in regard to permit doesn't always mean that it's a good permit.
Thank you, Mr. Schneider. And speaking of the current permits, you said you reviewed them, and I know you provide a list of proposed condition changes with your written report, and we don't need to go through all of those, but can you sort of tell me, tell the board, tell the public your sort of big picture observations and recommendations about the proposed permit as it is?
Sure. And so just stepping back a bit, you know, basically with an asphalt plant, you're concerned about what comes out of the stack after the asphalt's being made and it goes through its emission controls. And so there's one of the problems I have with the asphalt plant, as the way the permit is written, is there's a requirement to look at the visible emissions from the plant in one of the federal rules that applies. And outside of the initial compliance tests, there's no evaluation of those visible emissions or from the two asphalt plants. And so there's other conditions that I think the department thinks are sufficient. But I think like the really obvious thing, as a person who's actually been on the ground and looked at a number of these when I worked for the department, is to actually see what's coming out of the stack. And so by not having periodic monitoring of what's coming out of the stack, either visually or using a tool like a continuous opacity monitor system, you don't have a good indication of whether you're complying with the pound per hour emission rate along with the visible emission standard for the asphalt plants. And so for the sand and gravel plants, they have a lot of, basically those emissions are what we call fugitive emissions. And so the department in the permit has indicated that the compliance with those emission rates are basically a calculation. And that's the same thing with the haul road emissions. So basically they use the same calculations that were used to determine the hourly emission rates for the permit. And then they say, okay, keep track of haul road traffic, keep track of tons per hour production, and then basically do the same math that they did when they submitted the application. And so one side of me says that's somewhat okay, but I feel like that's incomplete, because really at the end of the day, you want to see what's happening at the plant. And so see what's happening on the ground at the plant at these emission source points. And so without doing that on a consistent basis, you don't have a good understanding of what's really happening. You just have a lot of paper. And I think the Hall Road example is good because, as I point out in my written testimony, in the evening, they say, go out and do an evaluation because this plant's going to be able to operate 24 hours a day during certain times of the year. They say, go out and do an evaluation in the dark and see if the emissions are going over, I think it says the headlights or so of the trucks, the haul trucks that haul the materials out or into the plant. And so I've argued that in my written testimony that same approach should be taken during the daylight hours, and it's silent about what happens in the daylight hours. So those are a couple gaps that I see that are pertinent to both the stack emissions and the fugitive emissions from this plant, which are the two primary types.
All right, thank you, Mr. Schneider. And you mentioned something called a continuous opacity monitor. Can you talk a little bit about that and if that would be, reasonable to use as a condition in a permit like this?
So I think it should definitely be evaluated. My experience with it was at a wallboard plant in Bernalillo, New Mexico. And essentially it measures the amount of visible emissions over a certain period of time during it, for a frequency of time. And I don't know the exact frequency, but basically these type of monitors are out there to evaluate visible emissions. And at a minimum, I think the department should consider the appropriateness of that for an asphalt plant. It's been a while since I looked at the technical nuances of doing that, but anything that results in either data being generated from a tool like that, from a monitor, or data being generated from a stack test, or data being generated from a visible emission evaluation, provides more clues as to how realistic what's been permitted is, how realistic what's happening at the facility is reflective of what's required by the permit. And I will point out too, outside of the initial compliance test for the asphalt plant stacks, that's it. And so this plant can operate under that permit for a long time without ever having to make that demonstration of how it stands in regards to complying with those emission limits.
So, and related to this, the use of a continuous opacity monitor, this idea of generating more data, is it your opinion that providing permit conditions like that would make the permit more protective of nearby community?
Yes.
Another thing. Oh, go ahead.
It'll give a more robust data of what's happening that's meaningful on the ground at the plant. So to the extent that helps the community, I would say yes.
And that data would inform something, right?
Yeah, well, so the plant has a requirement of a 20% opacity. It's required by a federal rule, which means you can have a little bit of emissions, but not a lot, just in very simple terms. And so, like, you can see, like, you can see most of the mountain behind the plume, essentially. And so, so it would help inform the compliance related to that, because it's a 20% requirement. And then that's a surrogate to whether or not it's meeting other requirements, such as the grain loading. It's getting a little technical here, but basically the pound per hour emission rate and the amount of emissions that are allowed by EPA's standard of performance for that type of plant. Okay.
So it would help sort of inform and ensure permit compliance.
Yes.
Okay. Okay. Another thing you mentioned is EPA's method 9 and 22. Could you tell us, what those are, why one might be better than the other, and what's being employed by the current permit?
Right. And so, as I mentioned, we have emissions from fugitive sources and from stack sources. And there's specific opacity requirements for those sources at this facility. And so opacity, basically, we're looking at the amount of light that's being obscured by a plume. And so the worst case is you look at a stack with the sun at your back at the correct angle to the facility, to the emitting source. And the worst case would be if you could not see, let's just say, the Jemez Mountains behind a plant that was located near the Jemez Mountains. It was totally opaque. So that would be like what's called 100% opacity. And so what the department's done outside of some initial compliance testing is they basically have allotted to the permittee the use of method 22, which simply indicates whether there's emissions present over a certain period of time. And it doesn't specify exactly what those emissions convert to in terms of opacity. And so method 9 requires you to maintain a training and certification. At least when I worked there, every 6 months. That may have changed. Whereas method 22, they strongly recommend that you're trained, but doesn't require certification. And so using the two methods, basically method 22, the way the permit's written is, well, if there's some emissions being seen, they're saying we're not going to worry about the quantity of them. We just want you to address what's going on. And I'm saying that that's not robust enough because, method 9 takes on more seriousness in terms of compliance and it would be easy to say, because with method 22, you don't have to keep a record. Method 9, you have to keep a record, and it just makes, in my opinion, the source more accountable. And having a certified method 9 reader at the facility also makes it more accountable versus just someone who's trained and says there may or may not be emissions using method 22.
Thank you, Mr. Schneider. And then I want to talk a little bit about sort of the stack testing methodology for asphalt fumes. And if you have any thoughts about that, maybe start with why asphalt fumes are an important consideration. Obviously, it's an asphalt plant, but why?
Right. Objection, Mr. Hearing Officer. The subject matter, that there are two issues that are being appealed. One is whether the department used a definition of ambient air that was that it unlawfully expanded the EPA's definition, and the other issue in this appeal is whether or not the department appropriately used the AP 42 standard. None of this testimony going through and giving various recommendations on Mr. Snyder's opinion about the permit have any bearing on this proceeding. And we objected to this, and I realized that, we raised this issue in the motion in limine, and I understand that the hearing officer ruled against us on that issue. But we're really now outside of the scope of this proceeding, and we've opened it up to just various things that Mr. Snyder thinks should be better. This was not brought in the petition, and I don't think it should be allowed. And frankly, it feels like a waste of time.
Ms. Locke?
Mr. Hearing Officer, I would just respectfully suggest that you ruled on this already. You've already decided that Mr. Schneider's testimony related to permit conditions goes to the enforceability of the permit. And I would just suggest also that this is intended to be a de novo hearing. The board is allowed to consider evidence that wasn't brought up, or for that matter, was brought up at the proceeding below, and this testimony was provided by Mr. Schneider last March. So I would just say that it's relevant, and you ruled on this already.
In my room,
you did not rule on this. You ruled on the motion in limine, but you specifically said that the department can object on a case-by-case basis. Whether or not this permit is enforceable is not a subject of this proceeding. I mean, unless it pertains to AP 42 or the definition of ambient air. You know, and we have essentially what petitioners want to do is they want to amend their petition unlawfully without giving us notice. So I think I've made my case. I'll wait for your ruling. Thank you.
Yeah, I did expressly state that I was not precluding the department from objecting to specific questions that might not relate to the grounds for the appeal. So if you can relate, Ms. Locke, if you can lay a foundation to show how this relates to the two issues you raised in the petition, we can proceed. If not, I don't think it's appropriate for you to proceed because you did raise two specific issues in the appeal, and the rule says you are limited by what you raised. And unless you can bring this back to what you stated in the appeal document, the petition, I think it's outside the scope of the case.
All right. Mr. Schneider, you said that permitting, right, the writing of permit conditions was informed by modeling. Bad modeling would mean bad permit conditions. Is that correct?
Yes.
Okay. So then with these permit conditions that you're proposing, are they being suggested as a way to help the board understand how to potentially remedy the department's bad modeling?
Yes.
Objection. I don't see how this relates to the question of AP 42 or the definition of ambient air. I mean, she's asking him to opine about what the board's jurisdiction is.
Ms. Locke?
AP 42 and the issues we raised with the air dispersion modeling directly impact the permit conditions.
And Mr. Snyder is not an air dispersion modeling expert.
He's not speaking as an air dispersion modeling expert. He's speaking as a permitting expert that would have done his job informed by modeling.
I'm going to let some further questions, I'm going to allow some further questions on this subject, and I will give it the weight I deem appropriate when I review the record and make my recommendation. It's sounding to me at this point like it's marginally, possibly marginally related to the issues you raised, and maybe not. So you can ask some questions on it. You can make a record on it, and then I'll consider it when I make my recommendation.
Thank you, Mr. Hearing Officer. Mr. Schneider, what are your thoughts about the department relying primarily on emissions calculations and records of water usage without visual observation of emissions to verify permit compliance?
I think that's problematic.
Okay, can you tell me why?
Well, I mean, at the end of the day, I mean, you can say there's 90% control on haul roads because they're watered, but until you go out and see what's going on with the haul road and the haul road traffic, you don't know that. And I think the same principles apply for, you know, the other fugitive sources there. You know, the conveyor belts and screens and crushers.
All right, Mr. Schneider, just a couple more questions. In your professional opinion, why is it important to strengthen the permit conditions in this case?
It's important because we have questionable data that was used in the modeling to determine compliance with standards, and we have questionable background concentration data that was used in the model. And, you know, if you don't put good data in, you don't get the best result, and you could have problems. And so my mission here is to make the permit as stringent as possible, in the context of assuring that standards will be met, but we're not even at that point. So, and you know, it'd be one thing if we were not nearly as close as we are to the ambient air quality standards, and that's not the case, and we're in an area where there's a lot of people that could be negatively impacted if those standards aren't met and the permit's not well written.
All right, one more question, Mr. Schneider. Knowing what you know about air permitting and stringent permit conditions and what you've heard from the last two experts, would you want to live near the AAM plant?
Objection. This hasn't, well, I withdraw the objection. Never mind.
I would not want to.
Thank you, Mr. Schneider. I have nothing else, Mr. Hearing Officer.
Okay, we'll go to cross-examination from the department, Mr. Vigil.
The department has no cross. Thank you.
Okay. Are there any questions from members of the public? Okay, hearing and seeing none, we'll go to, I'm sorry, okay, yes. Miss Marianello, yes.
Yes, just as a point of clarification, please, I was going to submit a fourth comment in writing, and I believe that today at the end of the hearing that you had ruled that we must submit all comments by that time. May I just ask for clarification on that, please?
Yeah, the hearing will be continuing tomorrow. The department will present its witnesses tomorrow. So, you will be allowed to submit written comments through the close of the hearing. So as long as you do that, they will be admitted and you will have time tomorrow to do that.
Just one final question, I'm sorry, and that is, will members of the public be allowed to make more than one oral comment?
No, not at this time. My procedural rule said you have one chance to make oral comment and that's it. Okay. So we were at the, anything else? Ms. Marianello, did you have anything else?
No, thank you very much. Those were my questions.
Okay, thank you. So we'll turn to questions from board members. Do we have any questions from board members? Yes, Ms. Davis.
Sorry about that. Took me a second to unmute. Yes, thank you. I just want to just go back to a couple of points you made. I wanted to make sure I had this correct, but the method 22, that is the audio visual olfactory test, also known as AVO, is that correct?
So I'm sorry, Ms. Davis, could you please clarify, also known as?
The AVO test?
I'm not familiar with that characterization of method 22. My understanding of method 22, it's a visual test of essentially of the presence or not of emissions over a fixed period of time.
Yes, sir. I believe that's known as an AVO test. Are you familiar with the current regulations for AVOs and method 22s?
I'm familiar with method 22 as to how I applied it and how it was applied when I worked for the department. So if there's been changes to it, I'm not aware of those at this time.
And I'm sorry, I must have missed this in your testimony, but when did you work for the department?
Sure. I worked for them from 1993 until 2017.
Okay. So are you familiar with method 22 when it's applied to oil and gas?
Yes.
Okay. So are you testifying that this particular permit only requires an AVO inspection and a stack emissions inspection at the beginning of operations and
So-
not following operation or commission?
So if I may, Ms. Davis, I'm not familiar with AVO, but I'll say the opacity evaluation from the stacks is only required on the initial compliance test. So the use of method 9, which is different than method 22.
Okay, and actually, Mr. Hearing Officer, would it be possible for the board to get a clarification on method 22 and the current AVO requirements from the NMED?
Certainly, I'm going to ask the department to have a witness when they present their case tomorrow to address those points for the board. Is that something that can be done, Mr. Vigil?
Absolutely, yes.
Okay, thank you. Just, if you would in the morning, identify which witness is going to address it so we know when that'll be presented.
I will, thank you.
Okay.
Okay, then let me just rephrase my question for the witness, and that would be, is your testimony that once the facility is commissioned, that they no longer have to have any sort of emissions reporting or testing that they're required to have on hand for an inspection or submit to the NMED on a regular basis?
Generally, no. There's a specific situation where my read of the permit for method 9 for the asphalt plant stacks is only an initial compliance test. But for other sources of emissions, they use method 22, which in my opinion is less robust than method 9. And so my testimony is that method 9 is a higher bar, and the higher bar should be used in this situation in terms of demonstrating compliance over time.
Okay, thank you for answering my questions. I don't have any more.
You're welcome.
Okay, do we have any other questions from board members? Okay, if there are none, we're going to turn to the public comment scheduled for 5 o'clock. And we have one person who wishes to make a comment. And her name is Patricia Garcia. She is participating in the meeting. So I would ask and she's going to speak in Spanish, as I understand it. And I will ask the interpreters to swear her in and let her make her presentation.
Permiso entonces para hablar.
I was going to swear her in first.
Yes, yeah, can the interpreters, one of the interpreters swear her in?
Ms. Garcia, raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Sí, lo juro.
Okay, please let her know she can proceed.
Buenas tardes, muchas gracias. Mi nombre es Patricia Chillón García. Yo soy bueno, una vecina. Yo y mi familia somos vecinos de la Comunidad del Sur, que se va a ver afectada directamente por esta ampliación y este permiso de la planta de asfalto. Además, soy maestra de una gran escuela que alberga 700 niños desde Cottonwood y partes de Agua Fría que se van a ver afectados directamente por el permiso, en el caso de concederse, de la planta de asfalto. Hemos estado desde el año pasado luchando para que esto no ocurra, muy preocupados y más después de haber estado presente en la anterior audiencia pública, donde había pruebas de que no se han hecho los estudios pertinentes para ver el impacto que va a tener esta planta en la salud y en el bienestar de nuestra bella comunidad. Bueno, de la comunidad del sur, porque de darse este permiso y de no hacerse los estudios pertinentes que nos merecemos como parte de la justicia social y de la equidad, se estaría incidiendo en un racismo medioambiental. Y eso ya ha sucedido en Albuquerque y se tomaron las medidas para hacer los estudios. Nosotros, la comunidad del sur, nuestra comunidad, pedimos que se nos trate equitativamente y que se hagan los estudios que merece una construcción tan importante para la salud y el bienestar de nuestra comunidad. Y eso es todo lo que tengo que decir. Muchas gracias.
Okay, thank you, Ms. Garcia. Can the interpreter thank her? Okay, thank you. Okay, I have on my screen, although I don't have him listed, Herman Gomez Chavez has his hand raised. Has he signed up with the host to make a statement?
Yes, Mr. Hernan Gomez Chavez, and then Jonathan Juarez Alonso, in that order.
Okay. Okay, are these in Spanish or English?
Mr. Juarez Alonso will be speaking in English. I'm not sure about Mr. Chavez.
Okay, will the interpreter just ask him which language he wants to speak in?
Hello, my name is Hernan Gomez. I live outside. Thank you for allowing me to speak. I hope you can hear me.
Okay, excuse me,
I'm very-
Mr. Chavez, excuse me, this is the hearing officer. Have you been sworn in?
No, I have not.
Okay, let's have the court reporter swear him in.
Would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I swear.
Thank you.
Thank you for allowing me to speak. My name is Hernan Gomez. All of my family lives in this part of town. As somebody who lives in that area, I know that there's been a lot of construction, and this poses a huge risk to the health of my family personally. So allowing for this permit to go through without doing proper investigation and being thorough about the process means that this city, sadly, like I've been witness to as somebody who's local, is putting money over the benefit of the people who actually make the city work. So I love Santa Fe, and it's really important to me that the health and well-being of my family and myself is put ahead of just allowing some company to move forward with their asphalt company, just to start producing pollutants in the south side and create more of a health impact in our community. Already been mostly impacted by COVID compared to other parts of the city. And I think it's important to be very considerate about who's actually benefiting from this, and the fact that you know, we are made up of a huge immigrant community in this part of town, and a lot of those folks don't actually get to speak or be a part of these conversations. So it's important that they be included as well, which I think moving forward, it'd be important to include more of the community in some of these processes so that they're aware of what's going on. Thank you.
Okay, thank you for that. I forgot to ask if there were any questions of Ms. Garcia. I believe she's still on. Let's go back to that and see if there are any questions. Okay, seeing and hearing none, we'll ask if there are any questions of Mr. Gomez.
Mr.
Yes.
Hearing Officer?
Yes.
I just wanted to thank the members of the public for providing their comments and taking the time to join us this evening. Thank you.
Okay, we have one more person whose name was given to me by the host, but I don't see that person's name up on the screen. Can the host indicate if that person has joined? I may have not be remembering the name correctly.
Yes, Jonathan, if you can turn your camera on or identify yourself.
Yeah.
So we might swear you in. There you go. And then, Mr. Hearing Officer, there will be one additional speaker.
Okay, let's swear Jonathan in.
Would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
Good evening, hearing officer, members of the board, and my fellow concerned neighbors. My name is Jonathan Juarez Alonso. I am 19 years old, and I'm here today as a leader of YUCCA, Youth United for Climate Crisis Action. Our work primarily focuses on climate and environmental justice, and I'm here today representing over 200 of our members who reside in Santa Fe, but particularly here today representing young people that reside on Santa Fe's south side, who this proposed plant expansion will directly impact. Our youth stand in strong support of the repeal and in strong opposition against this expansion of the plant in our neighborhood, which directly threatens our health and futures by further polluting our communities. As our leaders, you have a responsibility to make sure that the most stringent standards are used to protect us and that our data is sound, up to date, and comprehensive, as well as to listen to the constituents before you here today, asking you to reconsider approval of this expansion. Santa Fe's south side has already been disproportionately impacted by COVID, and if we don't stop this reckless expansion, we may see increased rates of asthma and other respiratory diseases in our children. Our youth urge you to value the health of our community by supporting this appeal. Thank you so much for the opportunity to speak here today.
Thank you, Jonathan. Are there any questions for Jonathan? Okay, hearing and seeing none, I'm going to ask the host to identify the last person, and we'll have them sworn in.
Yes, Marianne Maestas, if you would turn your camera on, please, to be sworn in.
Would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
Good afternoon, everyone. My name is Marianne Maestas. I'm a part of Earth Care, but I also live and my family lives off of Airport Road, close to Riverside. And today I'm here in public. I'm doing the public comment in support of this appeal because our family's homes are nearby this asphalt plant, and we already see some of the pollution, the exhaust from the semi tractors coming through our neighborhoods. And we do not want more of this, especially potentially 24 hours a day, every day of the year. And we need more stringent standards applied to protect our health. And thank you for listening to my comment.
Okay, Thank you for that, Mary Ann. Are there any questions of Ms. Maestas? Seeing and hearing none, I'm going to ask the host if there are any more members of the public that are wishing to testify at this point.
None that have reached out to contact me, sir.
Okay. Thank you for that. With that, we are concluded for the day, and we'll start in the morning with the witnesses for NMED and get through that. And then we'll go into the rebuttal phase after NMED has presented its witnesses. Are there any other matters to come before the hearing today?
Mr. Hearing Officer, just one thing I flagged earlier today that Dr. Sahu was going to be out tomorrow morning. He's actually going to be out all day tomorrow. So if we need his rebuttal testimony, it will have to be Friday morning, if that's okay.
Well, I'd written down he was going to be not available just in the morning. But have you determined if you're going to use him as a rebuttal witness or not? Probably not at this point. But
not yet, but we'll work with what we have to, but just to flag that.
Okay, if you could let us know, let me know, let the parties know and the participants as soon as you've made that determination, we
Certainly.
will have them scheduled within confines of his schedule if we need to.
Thank you, Mr. Hearing Officer.
Okay, anything else to come before the hearing? If not, we're adjourned until 9 o'clock in the morning. Thank you all very much.